Hey, how are you? All right. Whoops. There we go. Things should be working out. Good morning again. It is the mute a few more people. Okay. Last day of August. It's my brother's birthday. We have our Zoom calendars first. A couple notes. Is there someone on from the sheriff's office who will be helping chaperone us?
Yes, good morning, Judge. This is Livingston. I'm on the call today.
Hey, Ms. Livingston, good to have you back. So that do you have the calendar in front of you?
Yes.
There are a couple of cases that we're not doing. Position 10.
Okay.
And position 14. And I'm happy to engage those gentlemen if you've already gotten them, but their lawyer asked that we reset. They're on for probation revocations and they got a business in a whole bunch of other places. And so we weren't going forward. So if you already got them, we'll do them first and I'll just let them know what's going on. Otherwise, we can go and if there's a particular order you need us to go in, we'll do that.
Okay, Judge. They both are in the booth right now, and I don't have an order today, so however you want to do it is fine with me.
All right, I'm going to start with them. I'll turn their booths on in just a minute, and then they'll be excused, and then we'll just go through the calendar in the order it's published. Ms. Jones doesn't need to be here. If anyone's here for Tatiana Jones, she's already taken care of her. Do we have any public defenders?
Yes, Your Honor.
Oh, there we go. All right. So I don't know if that's your case, Ms. Feely or Ms. Woods, but Ms. Nelson told me that there's been a waiver filed, so we'll skip position 1.
Yes, Your Honor.
Okay. Let me see. Hey, 7 North, is that Gregory Watson?
No, this is D'Anthony Tolbert.
Okay, I'm going to mute you again. We'll get to you. But I was told Mr. Watson was out there in the mix. Mr. Watson, if you're in one of the booths, will you wave your hand?
He's in the
All right.
7 South.
7
booth,
South.
Judge.
Got it. Okay, 7 South. We'll go there now. Whoa, something's loud. All right, Mr. Watson, can you hear me?
Yeah.
So good morning. I'm Judge McBurney. Your case was on for a probation revocation. Hold on, Mr. Shad, you got to stay muted. Mr. Watson, your case was on for a probation revocation. Your lawyer, Ms. Wood, asked that we reset it because you've got 3, count them, 3 unindicted cases that she's trying to sort out before we work through your revocation, okay?
Yeah.
All right, so you're free to go. That was easy.
Judge McBurney, this is Dennis Schaub. Did you just tell me I need to stay muted? Judge McBurney.
Sorry, we're back. Audio got paused. Is there a James Smith? All right, 4 North. Stay right there, Mr. Smith.
That will be mine this morning, Your Honor. Good morning.
Good morning, Ms. Primovic. How are you?
Doing great. Thanks for asking. How about you?
Well, it's my brother's birthday. Let me unmute Mr. Smith and we'll get going. All right. Mr. Smith, can you hear me?
Yes, sir.
Good morning.
Good morning to you.
Your case is on for plea and arraignment. Ms. Primovic is handling your situation for today, I think, because the lawyer who'll be working with you full-time is on leave. Ms. Primovic, is Mr. Smith waiving arraignment?
He is, Your Honor. We were hoping to work this out this morning, but the offer that we asked for was rejected.
Oh,
We didn't get a counter offer, but we were hoping to work this out, but he will be waiving arraignment this morning.
okay. And who is handling this for the state?
ADA Whitenhauer and I was on the Zoom.
Okay, Mr. Whitenauer, so good morning, sir. You weren't interested in the offer from the defense. Did you have a counter offer, or it's too soon for you to be engaging in that way?
That's correct, Judge. They did make an offer, which I declined, based on 2 things. 1, the defendant's criminal history, and 2, I've not yet had an opportunity to speak with the victim. Our office did attempt to make contact with the victim in this case yesterday, but that was unsuccessful. So I can't make an offer until I've done so. We will continue to make contact with her, and I'll speak with Ms. Primovic about the case.
Okay, and Ms. Primovic, will Ms. Wood be the right point of contact going forward?
That is correct, Your Honor. Yes.
All right, so Mr. Smith, all hope is not lost. The prosecutor needs to spend a little time looking at the file and reaching out to the alleged victim. After he's done that, he'll be reaching out to your lawyer to see if there is a way to sort it out. If not, I'll be signing a scheduling order that will get your case moving right along so that if it's not going to be resolved that way, we can get you a trial, okay?
Yes, sir. I've been locked up 4 months, so I was trying to figure out, like, cause they told me they was gonna have a plea for me today, so I've been trying to figure that out.
Well, it takes 2 for that dance. Your lawyer made an offer that might work the case out, but the state has to agree to that. It's just not a plea because you want a plea. I mean, ultimately, it could be that way. You could do what they call plead blind, where you say, "I'm pleading guilty, and I don't care what the state recommends. I'm going to plead guilty." It doesn't sound like your lawyer is recommending that quite yet, so I'm going to let Ms. Wood, who works with Ms. Primovic, come see you. And you guys can make a plan, and it sounds like the prosecutor will be talking with Ms. Wood as well. For now, your lawyer has filed all the right paperwork to get your case moving along, all right?
Yes, sir. So how long would it take for me to be back in court?
Well, that would depend on whether your lawyer and the prosecutor can reach an agreement. If they agree that this is a case that should be sorted out, then we'll do it real soon. I'm not interested in you staying where you are any longer than you need to. But right now there's no plea deal. And so absent a plea deal, we got to move forward with motions. Maybe there's a motion to suppress, who knows? Your lawyer will talk to you about that. And if that aren't any motions, then we'll get you a trial. But it sounds like you want to work this out short of a trial. And I bet that's what'll happen looking at this charge. But your lawyer and the prosecutor need to talk a little bit more, okay?
All right, so a question, there's no chance I could take first offenders or anything?
Well, doesn't sound like you're eligible for first offender, but I don't know. And again, I'm the wrong person to ask.
Right.
I will be happy to entertain the plea once it's been worked out. So you, your lawyer, and the prosecutor need to talk more about that, okay?
Mr. Smith, what you all talked about, you and Ms. Wood, the state rejected that. What you all talked about at the jail last week, the state rejected that.
And my name is Taisha Jackson. I don't know if the court can.
All right. Anything else, Mr. Smith?
That'll be all.
Okay.
Thank you.
She'll keep working on it, sir. She'll keep working on it.
All right. let's move to, what'd you say? Oh, muted. Good. All right. Bye-bye. Let's go. Maybe this is in Cobb. Let's find Cobb. Are you Mr. Kilgore? Yes. All right. Let me unmute that and we'll get going.
Good morning, Judge. Ben Taylor for Mr. Kilgore.
Hey, Miss Taylor.
Hello. Happy birthday to your brother.
Good. Thank you. Let me get Mr. Kilgore's volume on. Look at this software working all the way across county lines. Mr. Kilgore, can you hear me?
Yes, sir. Are you on?
Great. Good morning, sir. Ms. Taylor is on the call as well. Let me add her to the screen so you can see her. So many participants. She is. All right. There's Ms. Taylor in her mobile legal vehicle.
Yeah, I'm in the back seat, so we're parked, so I'm not moving.
Amen. You're not violating any rules, policies, or procedures. So Mr. Kilgore's case is on for plea and arraignment. Ms. Taylor, is Mr. Kilgore waiving arraignment?
Judge, I wanted to try to work it out. Is there any way I could go into a breakout room with Mr. Kilgore? Can they put us in a breakout room while you continue with the counter? Let me speak to him briefly. And
Yes, ma'am. Yeah, I think so. Let me see whether the Cobb booth shows up on that. If not, it may be that you have to make a phone call to Cobb. Oh, here comes someone in charge.
Good morning, Your Honor. Mr. Kilgore can see you.
He can or cannot?
He can. Raise your hand.
Good. Yep. No, I can see him too. His lawyer wanted to have a private conversation with him, and I just can't remember. Do the Cobb booths, will they go into breakout rooms?
Some of them will and some of them won't. However, I can provide here my county cell phone if she would like to call it so she can speak with him.
All right. Let me see if I can make the breakout room happen. And if I can't, then if you would graciously share. Yeah. So Cobb is not showing up on the list. So if you could share with Ms. Taylor the phone number she can call, she'd like to speak with her client. And then who from the state is handling Mr. Kilgore's case? Is that another Whitenauer special?
Is.
Okay. Have you and Ms. Taylor spoken?
Judge, I did receive a phone call from her, a voicemail from her yesterday. As Your Honor will recall, I was in court. So I did give her a call this morning. We spoke briefly. Again, I don't know if this is one that we'll be able to work out this morning, but we can certainly continue to talk.
Why don't we do that? So why don't we have Ms. Taylor confer with Mr. Kilgore? What's the phone number, ma'am, we should give to Ms. Taylor?
It's going to be 404-227-6572. I can repeat that. That'll be 404-227-6572.
Thank you.
Right now.
All right. So Ms. Taylor's going to call that. Ms. Taylor, you can drop off the Zoom for a minute, or I can put you in the waiting room so it's private. You and Mr. Kilgore can talk, and then when you pop back in, we'll figure out what the plan is. Okay.
I'll just mute everything and I'll come back in when we're done. Okay.
Sounds good. So Mr. Kilgore, you and your lawyer are going to talk, and then we'll reconnect. All right.
Yes, sir.
All right. You Cobb, and we will go on to Lillian Diaz-Ortiz. I don't have any reason why this is on the calendar. Hey, Ms. Kaufman, how are you?
So I believe she was excused to wait to raise.
Okay, but you came all the way.
For something else.
Oh, okay, great. Is she a co-defendant in a case? Because this just standalone charge is odd.
He is a co-defendant, judge, to position 5, Raquan Pitts.
Oh, and Mr. Kane. Of course, Kane is here because Kaufman is here. All right.
Ron, we had the hour-long volunteering, I remember a few weeks ago, my client was out of town, just started tampering with evidence.
Right. And this is, was that Mr. Whitenauer who was talking?
Was.
Okay. So let me just pull the case up. And then we can also get Mr. Pitts on the screen. And Mr. Kane, why don't you come on up to the podium? Good morning, sir.
Yes, sir. Good morning. How are you?
I'm all right. And let's find, so he in theory was being 4 South. Is there a 4 South? Mr. Pitts, can you wave your hand? That's awkward. Mr. Pitts, you there? There he is. He is 4 South. All right. South. All right. Good morning, Mr. Pitts. How you doing? Okay. So Ms. Diaz-Ortiz, you've waived arraignment on her behalf, but you've got other business here this morning. Excellent. Well, still good to see you. Mr. Kane, Mr. Pitts is on for plea and arraignment. Is he waiving arraignment or does he want to be formally arraigned?
Your Honor, we'd like to waive arraignment.
Okay, we'll do that. I will get a scheduling order out that will set a deadline for the state to get you discovery. Your motions deadline is not till after that, so you don't need to worry about the 10 days from now to file motions. You'll get a chance to get that discovery, process it, and then confer with Mr. Pitts before you determine if there are any substantive motions, not motions in limine, evidentiary motions that you need to file that we would need to hear.
Yes, sir. May I have an announcement by counsel for the state who I could speak to?
Sure. Mr. Whitenauer, this will be your case going forward?
Yes, Judge.
Okay.
Can I get a phone number from Mr. Whitenauer?
What's the best way for Mr. Kane to reach you? Do you want me to, you want to text me something and I hand him the card? Or do you want to just say it?
Sure. He can email me at john.whitenauer, which is spelled WEITNAUER at fultoncountyga.gov.
So John.Whitenauer, WEITNAUER.
All right, very good.
So you and he will be in touch. He will need to start getting discovery to you and to Ms. Kaufman. Mr. Pitts, I will see you next. If Mr. Kane and you decide that there are motions to suppress, some kind of motion where we would need to take evidence, we'd get you in here for that. Otherwise, the next time I see you is at what we call a status hearing, which would be the last time for this case to resolve by way of a plea, if that's how it's going to sort out, when you could withdraw your plea if you didn't like the sentence you got. But we make sure at the status hearing that all systems are go for a trial, and then we get your case on a trial calendar if that's how we're going to resolve this case. Do you have any procedural questions? No. Nope. Okay. Well, I'm sure Mr. Kane will be in touch. Mr. Kane, anything else on behalf of your client?
Nothing on behalf of Mr. Pitts. I do have a question for the court. When you send out the notices for status conferences and arraignments, is appearance optional? Is Zoom a possibility?
Well, Zoom's fine. Appearance is not optional, as in don't not show up. But if you want to appear remotely, that is A-okay. As long as, I mean, if there's going to be some evidentiary situation, you'd need to confer with the prosecutor that's all right. But otherwise, no, virtual is always all right with me. Okay.
All right, with that, may I be excused?
You may.
Thank you. Nice
all
to
right.
see you.
Nice to see you. There was someone in the back raising a hand. Are you?
I'm his sister, it's my father.
Mr. Pitts?
We're here.
Okay, all right. Well, Mr. Kane's right there. All right, thanks. So you have more on the calendar. Okay, all right. All right, Mr. Pitts, you're good to go. Mr. Kane will be in touch once he gets discovery.
Okay, thank you.
Mr. Kane? There is a waiver of arraignment form you should fill out, please. So you already did one and have filed it, Ms. Kaufman. All right. If Mr. Kane needs help, you'll help him out with the waiver form? Okay. Moving right along. So Mr. Lloyd, I believe, was brought over. So we will do Mr. Lloyd's bond hearing, but we're going to wait because we got to finish the Zoom stuff first. Can you confirm that Mr. Lloyd is Deputy Gordon back there? He went to get him, but all right, we'll come back. I believe Mr. Lloyd, for some reason, got brought over. That wasn't how it was supposed to work, but if he's here, let's do it that way. So that gets us to Anthony Tolbert, who is in one of those rooms. 7 North. Hey, Mr. Tolbert, can you hear me?
Yes, I can hear you.
All right. Mr. Tolbert, your case is on for a bond hearing. Mr. Cladis filed a bond motion on your behalf. That's what we're going to talk about right now. Who from the state is handling Mr. Tolbert's bond hearing? Well, I guess it'll be you, Ms. Charles. So he intends to be here. Okay. All right. So Mr. Tolbert, we will have your bond hearing. The prosecutor is en route. Mr. Cladis.
Just briefly, I was hoping to have a word with the prosecutor before we actually start the hearing.
That's fine. We'll do that. All right. So sit tight, Mr. Tolbert. We'll do the bond hearing once we have all the right players in the room. We'll move to Mr. Cox. You wave your hand. There he is, 5 South. Excellent. Good morning, Mr. Cox. Can you hear me?
Yes, sir. I hear you. Good morning.
Good morning. Who is handling Mr. Cox's case?
That's my case, Your Honor.
All right, Ms. Feely, let me add you to the screen there. And let me pull up the warrant for Mr. Cox. It's in here somewhere. There it is. Okay, Ms. Rivers, good morning.
Good morning, Judge.
Are you ready to take this down?
Yes, I am.
Okay, this is position 9. It's indictment 13 SC 117146, state versus Mr. Cox. We have who on the state side? Ms. Charles, and your microphone is on?
It is now.
It is now. Great. And we have Ms. Feely representing Mr. Cox. Mr. Cox, the probation warrant that I signed in January of this year alleges that in mid-December of last year, so 2021, you were arrested for a marijuana charge in DeKalb County. That arrest would be a violation of your probation. So that's what the warrant was about. Ms. Feely, is Mr. Cox admitting to, stipulating to, or denying the allegation in the warrant?
Your Honor, this morning we would like to admit for probation purposes that arrest.
Okay, then why don't you tell me a little bit about Mr. Cox and what you think we ought to do in his situation?
Yes, Your Honor. It's my understanding this is his first violation in this case. He tells me he was reporting, he was paying, he had done everything else, and then he caught this arrest in DeKalb County. Unfortunately, he also had probation in Forsyth County, for which he ended up doing some time for a revocation for the DeKalb arrest as well. So he's already done, not for our probation purposes, but in Forsyth, he got 120 days for that DeKalb arrest. So now he is here before Your Honor. He's got 2 daughters. Their birthdays are both in October, so they're almost 2 and almost 8. And he was working at the time of both this arrest and then this probation warrant. He was working at Astro Group Grading and Piping. He's been there since 2015. So he's really eager to get back out and continue doing well on probation. He's got his heavy equipment certificate. He's otherwise doing very well. And given that this is his first violation, he's been in for 69 days in Fulton County. So we would ask the court to consider time served and reinstate.
Can you, I want to follow the sequence of events. So Mr. Cox was revoked for 120 days. I think you said in Coweta, somewhere else. Then did he come here next? So he's actually been in custody for 189 days? Or there was a break between the two?
There was a break between the two. So it was Forsyth County, and he, I think, went there in February, and then he was released, and then he got stopped in a traffic stop in June, and that's how he ended up with us.
Okay, so somehow while in Forsyth, they didn't, because this warrant would have been in the system by then, that didn't catch him, and he was released, and then this got him.
That's correct. That's my understanding.
And what is your understanding of the status of the DeKalb case?
I don't have any documentation of, I know it appears to be unindicted from what I can see, but other than that, I don't know.
Okay, got it. Ms. Tucson, good morning. How are you?
Good morning. I am well. How is everyone? Happy birthday to brother.
Yeah, thank you. So how much time does Mr. Cox have remaining on this 2013 case?
On the 2013 case, he has 3 months, 30 days remaining. December 30th, 2022, that ends, and he is on probation in Forsyth for 8 years, 2 months, and 1 day till 2030.
So we're almost done with our Fulton case.
Almost done with Fulton.
Do you have visibility into the system such that you could confirm what Ms. Feely said, that Mr. Cox had been doing just fine on probation until this?
I can look and see if there's any previous violations or anything. Give me one moment.
Thank you. While you're looking that up, Ms. Charles, what is the state's recommendation for Mr. Cox?
Your Honor, when we looked at it, my recommendation would have been to revoke 6 months and reinstate, subject to the confirmation of how long he had left. And from what I'm understanding, he's got 3 months left, so probably would just revoke and then end.
Okay.
Terminate probation. And let him.
Got it. Mr. Cox, you have daughters who are turning 2 and 8 in a couple months?
Yes, sir. Next month, October 10/17 and 10/29, sir.
Okay, and do they live in your household?
Yes, sir.
Who's taking care of them right now?
The mother.
Okay, does she work?
Yes, sir.
What does she do?
She's a caretaker. She take care of the elderly.
So your 8-year-old would, your 8-year-old would be in school now. What happens with the 2-year-old when their mother is at work?
I usually watch them, or my mom will watch them, but since I've been incarcerated, I can't help out. So I was trying to help out like I usually do if I can go work and help out with my baby, help on the daycare and stuff like that.
But if you're doing grading and piping work, my guess is that's during the day and not at night. So what happens with the 2-year-old if you're working and their mom is working?
She work at she take care of the night shift because she can pick. It's this app. She can pick day or night shifts. So she'll pick the night when I get off of work, or on the days that I don't work, she'll work through the weekend. So as a fluctuate, or my mother she'll intervene to help out.
Okay. And you did 120 days in Forsyth?
Yes, sir.
And then you've done a couple months plus a little bit more here in Fulton?
Yes, sir.
Okay. All right. Ms. Tucson, did you find anything?
No, Judge, just the one that that she mentioned from from Forsyth, and that was it. And then this current one. So that's it. There's no other violations or revocations on file.
Okay, all right. Well, Mr. Cox, I find that you did violate the terms and conditions of your probation by getting arrested in DeKalb. Sounds like that case is still rattling around out there, so you're going to want to stay plugged into that. I don't know what kind of address you gave the folks in DeKalb when you bonded out, but you're going to want to make sure if that address has changed, that you keep them current on that, because otherwise you may miss court, then there'll be a warrant. This whole process could start all over again with Fulton and Forsyth and DeKalb. And as you're learning, you get stuck in different places, and the clock keeps ticking. I'm going to revoke 90 days of your probation. You will get credit for the time you did serve, and I will suspend the balance when you are released. So you'll be done with your Fulton case when you get out. You'll still have probation in Forsyth, and you've got this charge in DeKalb County. That's, as I said, floating around out there. And that will be it. Ms. Feely, anything else on behalf of Mr. Cox?
No, Your Honor, thank you.
All right, Ms. Charles?
No, Your Honor, thank you.
Mr. Cox?
Yes. What was the exact date of when he has been in custody for the credit for the time served?
So when did Mr. Cox get to Fulton County?
Correct.
When did you get arrested, Mr. Cox? It sounds like there was a traffic stop and this warrant got you. Do you remember the day?
It was before Father's Day.
It was June 24th, Your Honor.
Okay. So from 24 June of 22, Mr. Cox gets credit.
Thank you.
All right. Mr. Cox, any questions?
Asking, did I get reinstated? Will I be released today, or how would it go?
So I revoked 90 days, 90. You served about 70. So the sheriff will be figuring out how much longer you're going to stay there. You will not be transported anywhere. And the sheriff may conclude you've done enough. That's not my call. You will be released soon. Next couple of weeks would be the math. I guess technically it could be 3 weeks. But then you aren't not being reinstated on this case. I'm closing out the probation. So once you do get out of the Fulton County Jail, no more probation in Fulton, but you still have your Forsyth case. Okay?
Will they give me credit for 2 for 1? This is a probation case.
We'll see what happens.
Yes, sir.
All right. Thanks, everyone. You're free to go. All right. Shenard Collins should be on the first floor. Let's see if we've got a. Mr. Collins, can you wave your hand? Are you in 1 North? Yep. All right. Good morning, Mr. Collins. Can you hear me?
Yes, sir. Good morning.
You're here for a probation revocation. Let me call up your warrant.
Your Honor, I'll be handling that case this morning.
All right. Thank you, Ms. Primovic. There it is. All right, Ms. Rivers, are you ready?
Yes, I am.
Okay. So we're going to go on the record in position 11, State versus Shenard Collins. It's 18 SC 157382. Mr. Collins, I signed a probation warrant for you in March of this year. The allegation is that in June of 2020 in Clayton County, you committed the new crime of possession of a firearm or knife during the commission of a crime, and maybe you're a convicted felon and you had a gun and maybe some other charges. So it sounds like some felony arrest in Clayton County in June of 2020, 2 years ago. Let me. Okay, Ms. Primovic, is Mr. Collins admitting to, stipulating to, or denying these allegations?
Your Honor, we're stipulating to.
Okay. Do you know the status of the Clayton case?
He went to jail, he went to prison, Your Honor, for 2 years. And then when he was released from Augusta State Prison, he came back to Fulton on this hold on June 4th of 2022.
So that the June 2020 situation in Clayton resulted in a conviction, a sentence of 2 years. He's completed that sentence, and waiting for him was this warrant.
And yes, Your Honor, and a warrant out of DeKalb for the same thing, for the same Clayton County charges.
Got it. And has Mr. Collins gone to DeKalb to deal with that, or he's stuck with us first?
He's stuck with us first, Your Honor.
Okay, understood. And what are you recommending happen in Mr. Collins's case?
Your Honor, we're asking for 90 days commuted and let him go off to DeKalb and hopefully get that taken care of. I believe the state is stipulating.
Okay,
time
well,
served.
I'll find out in just a sec. Ms. Tucson, how much time is left on Mr. Collins's case?
He only has 28 days, Judge, on this case. It ends September 28th.
Okay. Ms. Charles?
Yes, Your Honor. Myself and Ms. Wood had agreed to 6 months and reinstate, but it's got 28 days. So because we wanted to have him go on his way to DeKalb. So
Sure. Okay. Mr. Collins, you know you got to go to DeKalb County after we sort this out.
He.
Can you say that again? Oh, I didn't hear him, but he does. He understands that, Ms. Primovic?
Yes, Your Honor. He and Ms. Wood talked about that.
Okay. All right. What are your charges out of DeKalb County, Mr. Collins?
It's a probation violation. They supposed to have ran it in with this within 5 years ago, so it's the same thing. It's supposed to have been ran in with the Fulton County case, but I guess I gotta go over there for a separate, to go back in front of the judge too for a probation violation.
You do. What was the case in DeKalb? What were you, do you remember?
Possession of firearm.
Well, that seems to be a thing you do. All right. Well, Mr. Collins, I'm going to revoke the balance of your probation. That's 28 days. I'll reduce it to time served because you've been in for 2 years for, again, having a gun. And you will work your way over to DeKalb and we'll see what they do. Ms. Tucson, are you able to tell how much time is left on the DeKalb case, or that's not visible?
Supposed to be 2000.
I am pulling it up. It looks like that case is, he's on probation for that case until 2029. So it looks like
Okay, that's fine. So they've got more to work with than what we have here.
he has 6 years remaining on that case on probation.
Okay. All right. Well, in this case, Mr. Collins, I'm revoking the balance. I'll reduce it to time served so that there won't be any reason you're stuck here. The sheriff in Fulton will reach out to the sheriff in DeKalb, and fairly soon you should be transported to DeKalb to figure out what's going to happen there. Any questions?
No, sir.
All right. Thank you, Ms. Primovic. Big stretch from Mr. Collins. All right, Mr. Sirleaf is next. Mr. Sirleaf, can you raise your hand? There he is, 5 South. Mr. Sirleaf, can you hear me?
Yes, sir.
Good, I can hear you now. Who is handling Mr. Sirleaf's revocation?
That's my case, Your Honor.
All right, and I forgot to add Just primitive last time. All right, Mr. Sirleaf, let's get on the record in your case. It's position 12, indictment 18 SC 160492. And you pled to a burglary charge. I have a warrant that indicates that in October of 2020, you had a shoplifting. In June of 21, a shoplifting, and then they ran out of space because the text field only has so many characters in it. Something happened in November of 2021 as well. Ms. Feely, is Mr. Sirleaf admitting to or stipulating to these allegations, or is he contesting them?
We are stipulating to these arrests, Your Honor.
Okay. Do you know the status of either of them, the shoplifting in Fulton or maybe in DeKalb? Yeah, DeKalb.
Sirleaf reported that he believes that his case in DeKalb was closed with time served, and as well as the Fulton County, I believe, was closed in July of this year. We're talking all theft by shoplift.
I went to court recently in July for shoplifting in 2019, I believe, or maybe in 2020 when the warrant was placed, and then I just came from DeKalb, and the case from November got closed out, it got dismissed.
Okay, what happened with the Fulton one?
It was time served.
Okay, all right. So you're admitting or stipulating to those arrests. Ms. Tucson, how much time remains on Mr. Sirleaf's case?
1 year, 8 months, 1 day, May 1st, 2024.
All right. What's the recommendation from the defense, Ms. Feely?
Yes, Your Honor. As you heard, he came here from DeKalb, and he's been here with us for 73 days. So we are asking the court to sentence him to the time that he's served. He is single. He's got a 5-year-old son here in the area. He has been working for the last 3 years at the Jimmy John's, the Lindbergh location. He's a delivery driver. So he's eager to get back out to that employment and to his son.
And Mr. Sirleaf was in DeKalb most recently because of one of the arrests listed on this petition?
That's my understanding, yes.
Because of the warrant, yes, sir.
Okay. How long were you in custody in DeKalb, Mr. Sirleaf?
2 days.
2 days?
32.
32. And then did you come straight to Fulton, or were you released?
I came straight here.
So you've been in Fulton for 73, you were in DeKalb for 32. So you've been in for over 100 days now, if you add the two together?
Yes, sir.
And why did you get arrested in DeKalb?
Because I had a warrant.
Okay. For?
Shoplifting in November.
For what?
Shoplifting in November of last year, November.
Oh, okay. Got it. And then you're saying that case got dismissed?
Yes, sir.
Okay. All right. Ms. Charles?
Yes, Your Honor. The state's recommendation would be that you revoke 6 months and reinstate on probation.
Ms. Tucson, does Mr. Sirleaf have probation in any other case here or in any other Georgia jurisdiction, or is this his one open matter?
This is the only open case on probation at the moment.
Okay. Mr. Sirleaf, it sounds like your 5-year-old son is someone important in your life, doesn't live in your household, but he's someone that you help care for.
I actually do live with my son.
So who's taking care of him now?
His mother.
His mother, okay. So, pardon me?
We share a living arrangement.
Meaning your son moves from your place to her place, or the three of you live together?
The three of us live together.
Okay. And does his mother work?
No, she doesn't.
Okay. All right. All right, so Mr. Sirleaf, I am going to revoke 4 months of your probation as a result of the multiple arrests while you were on probation for burglary. I'll give you credit. You will receive credit for all the time that you have served here in Fulton County. So, Ms. Feely, do you have that arrival date?
I do. Give me just 1 second to switch screens.
Sure.
That is, June 20th.
All right, so Ms. Tucson, Mr. Sirleaf should receive credit from June 20th. I am revoking 4 months. I'll reinstate the balance and we'll take it from there. So you got less than a year and a half left on probation, Mr. Sirleaf. Hopefully you can navigate this in a way that keeps you out of having to go to DeKalb and Fulton and all that stuff. All right?
A question, do you know how the time is like? How?
I don't. It's a mystery to me. I'll say an amount, and sometimes someone does all the time. Sometimes they do part of the time. What I can tell you is it will not be more than 4 months, and you have already done much more than 2 of those 4 months. So you are at worst more than halfway through the revocation sanction. And at best, you may get out real soon, depending on the number crunching that gets done. I don't get to do that. Okay? All right. Thank you. Thank you, Ms. Feely.
Thank you.
Judge, not to interrupt you, Beverly Taylor back on Reginald Kilgore.
All right. Let's get him back on the screen too. So that's Reginald Kilgore. Yep, hold on.
Okay.
Whoops, that's not who I wanted to spotlight. Go. All right, Mr. Kilgore, can you hear me?
Yes, sir.
Yes, welcome back. Did you have an opportunity to speak with your lawyer, Ms. Taylor?
Yes, I did.
All right, so Ms. Taylor, back to you. We're on for plea and arraignment. You were cautiously hopeful that this might work out. Is it working out, or are you going to waive arraignment and it'll work out soon?
Judge, I'm going to waive arraignment, enter plea of not guilty. I expect it to work out soon. I'll be getting with Mr. Wood now with the contact information for the victim in the case. I did try to the information. I don't know if she didn't respond to me, so I don't know if I has logged on. Otherwise, Judge, we would like to bring him back ASAP because I think we can work this out quickly.
Okay, so the way we'll do that is that when you and Mr. Whitenauer, if you've reached some understanding, then just let Ms. Nelson know, and we can get Mr. Kilgore here in one of 2 ways. We have 2 opportunities every week. We have jail calendars where he'd be transported here. We also have what we're doing today, a Zoom calendar. So one way or the other, we can make it happen pretty soon after you let us know that there's a reason to make it happen. So if you and Mr. Whitenauer sort it out, or it's close enough that it's non-negotiated, but within a reasonable range in your mind, then let's get Mr. Kilgore back here. In the meantime, I'll enter a scheduling order that'll map out a longer term plan in case it's not worked out. Okay. Mr. Whitenauer, anything for the state?
No, Your Honor.
All right. Mr. Kilgore, you have any questions, or you think you understand what's going on?
Yes, sir. I understand what's going on, and I'm in compliance with whatever's going on.
All right. Well, Ms. Taylor will be in touch with you. It sounds like she's going to be working with the prosecutor to see if she can sort this out.
Okay.
All right. You're free to go.
All right. Thank you.
So that gets us to Gregory Gordon. in 7 North, maybe.
Morning, Judge. Dennis Scheib. How are you doing, sir?
I'm doing well. Do we see Gregory Gordon in there? Gregory Gordon, wave your hand if you're in there. There he is. He is in 7 North. Excellent. Spotlight and add to spotlight. And let me unmute Mr. Gordon. Mr. Gordon, can you hear me? All right, let me pull up your probation warrant and we'll get on the record. All right, Ms. Rivers, are you ready?
Yes, Judge.
Okay, so we're here on the case of 18 SC 160659, State versus Gregory Gordon, who was sentenced on a drug case and received probation. And wow, over 2 years ago, I signed a warrant that alleged that in June of 2020, you, Mr. Gordon, committed the crime of aggravated assault upon a police officer, having a gun, having some drugs, all here in Fulton County. Mr. Scheib, is Mr. Gordon admitting or stipulating that that occurred, or is he denying it and we need to have an evidentiary hearing?
He is stipulating, Judge, that he was arrested. He's not admitting that he committed the crime. And that's an area we're going to be dealing with in the future. And Ms. Charles and I have, I believe, reached an agreement. Of course, it's going to have to get your blessing.
Okay. There's an open case that Mr. Gordon has with Judge Glanville. Is that the indictment of these charges?
Yes, Your Honor, it's set for trial on September 19th.
Oh my gosh, Mr. Scheib, do you have that other case too?
I do, which 20 SC 177200.
Yeah, so it's set for trial next month.
Well, good luck with that. Everybody's going to have to get in line. I've got some cases 5 and 6 years old.
Oh, well, I'll let you say that to Judge Glanville. All right, we're going to deal with the part of Mr. Gordon's life that I have. Ms. Tucson, how much time remains on Mr. Gordon's case?
6 months, 30 days, 3/30/2023.
Got it. What is the recommendation from you, Mr. Scheib?
Judge, we've negotiated that he be revoked for the period that he's been in and the case be suspended because he's been in jail a little over 2 years. And so this has just been kind of hanging around. And I picked it up in March of 2022. So Ms. Charles and I have agreed that it should be stipulating that he was arrested, revoked the balance, and suspended, and let him deal with Judge Glanville and his probation be done.
Okay. Ms. Charles?
Yes, Your Honor, that is the agreement.
Okay. Mr. Gordon, have you followed what we've been discussing?
I kind of went blank for a minute, but I kind of understand what's going on.
Okay, when you said it went blank, meaning you couldn't hear us or you like momentarily went unconscious?
I couldn't hear y'all. Screen just stopped.
Okay. All right. So here's what I'm going to do. It's, I think, structurally the same thing as what your lawyer, Mr. Scheib, has negotiated. I'm going to revoke 2 years. Well, you don't even have 2 years left. So I guess I can't do that. But I was going to, I'll revoke the balance and we will close the case out that way. Is he in a no bond status with the Judge Glanville case, Mr. Scheib?
That's correct.
Okay. All right. So I'm going to revoke the balance of your probation and close it out that way. You've got the case with Judge Glanville that's set for trial. It sounds like Mr. Scheib may have a conflict, so that may get bumped a little bit. We'll handle it that way. That way you don't need to worry about this probation anymore. Your focus can be on the open, active case in front of Judge Glanville. Ms. Charles, anything else in Mr. Gordon's case?
No, Your Honor.
All right.
Judge, let me ask you this. Just technically, should the order be revoke and suspend? I mean, if you revoke the balance, he would actually have to do, I'm thinking, I'm just trying to be cautious, another 5 months. But if you revoke the balance and suspend it, I think that would be the correct terminology. Am I right or wrong?
No, you're not right or wrong. That's a different approach. But where is Mr. Gordon going in the next few months that it would make a difference?
Well, I just don't want it in the computer to be any type of glitch.
Okay. I don't think there'll be a glitch. I think understanding the posture of Mr. Gordon's case with Judge Glanville, I think we'll be okay. If we're not, you know how to reach my staff and I will certainly fix it.
Okay. Thank you, sir.
You bet. All right.
Okay.
Good luck, Mr. Gordon.
All right, thank you.
Okay. Bye, sir.
Mr. Scheib, you in better health now?
I'm doing great. I just had a shoulder replacement.
Okay. So it was a physical thing. It wasn't like your heart gave out or anything.
After all these years of being in martial arts, I had to have it replaced.
Okay. So you have a bionic shoulder now?
It is. I had a reversal done, kind of unusual, because I pretty much destroyed it fighting all these years. That's okay. I wouldn't have traded it.
Good. Well, it stood you well over those years. All right. Thanks for joining us.
Thank you, sir. Have a blessed day.
You too.
Okay. Bye-bye. Great judge.
All right. I think we got to go back to Mr. Tolbert, and that's the last one on the main calendar. We have an add-on, and we'll take care of those. Mr. Cladis, did you, and Mr. Abate has arrived. Did you get a chance to speak with him?
Yes, Your Honor.
Okay. Are you ready to go forward with the bond hearing?
Yes, Your Honor.
Okay. Let me get Mr. Tolbert going.
Judge, while this hearing is going on, may I be excused to go to a calendar in Judge Dunaway's courtroom?
Sure. Do you have more this morning? I know we've got stuff in the afternoon, but do you have?
I do this morning, I think, Judge, on the main calendar, position 6, Sanchez Lloyd.
That's your bond hearing?
Well, so the bond hearing, I believe, is on 7, same defendant. 6 is on for plea and arraignment.
Got it. So yeah, go do what you need to do and come on back. Mr. Lloyd, we got to finish all our Zoom stuff before we do Mr. Lloyd. Mr. Lloyd is physically here, is that right? Yeah, so he's physically here. Go deal with Judge Dunaway and please be back.
Yes, Judge, thank you.
All right. Okay. Ms. Rivers, are you ready?
Yes, Judge, I'm ready.
Okay. This is position 8. It's indictment 19 SC 167684, State versus Tolbert. Mr. Tolbert has been in jail for over 1,200 days awaiting trial. The state has been ready to try this case for a while. The defense has had on Mr. Tolbert's side, a little bit of a rotational issue where different lawyers have come and gone. Mr. Cladis is currently representing Mr. Tolbert. He too will be leaving. None of this is Mr. Tolbert's fault. He's just bearing the consequences of it. However, Mr. Cladis did file a bond motion, and we need to talk about bond for Mr. Tolbert. Mr. Tolbert, that's all we're doing today is talking about whether bond makes sense for you. If it does, I'll set a bond. If it doesn't, nothing's changing. You are where you are, and we need to get you in court for the trial. When you're ready, Mr. Cladis.
Thank you, Your Honor. Your Honor, as the court noted, Mr. Tolbert has been in custody for over 1,200 days, 1,268 as of today. Since the court denied bond on March 1st, 2021, another 550 days have passed. As the court mentioned, there's been a little bit of a rotation here. I'm the third attorney who's handled this case since the court denied bond. And as the court noted, none of this is Mr. Tolbert's fault. He's 24 years old, Your Honor. He's lived in this area his entire life. He remains close with the woman who raised him, who also lives in the Atlanta area. That's Sharon Tolbert. a retired computer technician. She had planned to be in court this morning. She was stuck in traffic. She may actually be on the call right now. Mr. Tolbert has 2 children who live in Atlanta, Solomon, age 9, Major, age 3. At the time of his arrest, he was working as a garbage collector and part-time for a landscaping company, and he had been working pretty regularly, although his housing situation was not stable. And that, I believe, led to his one failure to appear in April of 2018. That failure to appear seems to stem from a misdemeanor case in DeKalb that started in 2015. I've not been able to determine what the exact circumstances were, but whatever happened there, it was inadvertent. Mr. Tolbert was unaware of the court date. That is the only time he's ever missed court that I'm aware of.
So I'm clear on this. The court date Mr. Tolbert missed was not for the murder charges. It was for some misdemeanor case.
Yes, Your Honor, that's right. In terms of Mr. Tolbert's criminal history, he essentially has a couple misdemeanor cases out of DeKalb, no felony convictions, no felony charges before this case. And the misdemeanor convictions seem to, from what I can tell based on DeKalb County records, all stem from conduct that occurred in spring of 2015 when he was 16 years old. At the time of his arrest, well, at the time, he actually started custody in this case, Your Honor, on February 1st, 2019. At that time, he was in Cook County Jail on Illinois charges. On that date, February 1st, 2019, the detective handling the case sent an arrest warrant for the murder.
Mr. Tolbert was in Illinois?
Yes.
Was Mr. Williams not in Georgia also?
Chicago together.
Huh, okay. Because I'm remembering we had a bond hearing on Mr. Williams and he disappeared to Illinois somewhere, which didn't help his argument. Just coincidentally, Mr. Tolbert, out of all places in the world, was in Illinois also.
They were together as far as I know, Your Honor.
Okay.
So on February 1st, 2019, the Chicago police received the murder warrant from Georgia. And at that point, he cannot be released from custody because under Illinois law, because the charges in Georgia carry a possible penalty of life or death, he has to stay put. The offenses he was being held, the Illinois charges, were bailable offenses. He could have been released.
What were they?
The records I have indicate either obstructing identification or some kind of possession of drugs. And the possession charge would have been a felony. And the only records I've been able to get directly from the Chicago Police Department say obstruction of identity.
Relatively minor, potentially felony offenses.
Relatively minor, definitely bailable. But he started to be held that day on the murder case in Georgia. He waived extradition on February 4th, 2019. And as of that point, he's at least in custody on the original murder charge. So I think he's entitled to bond on that charge under Georgia law. The prosecution, the state added charges. I forget now, well, in the indictment, they added 5 more charges, a couple more murder charges, armed robbery. And then, but he's been in custody on the original one since February 1, 2019. Your Honor, he's got nowhere to go. If the court would grant bond, he can stay with Ms. Tolbert. He can reside with her. Of course, whatever conditions the court would see fit to put on him, including an ankle monitor, he would have gladly accept that. The main thing, he's just been in custody so long, and he's going to be in custody a little bit more because of my leaving. So I'd ask the court to grant bond. Thank you.
Okay. Thank you. Mr. Abate.
Thank you, Judge. I was speaking with Mr. Gladys, and I agree with his analysis of when Mr. Tolbert was taken into custody in Chicago and subsequently, I guess, waived extradition. And the case was later indicted on May 10th. Based on my understanding of the law, and this is kind of the issue that we had litigated as it pertained to Mr. Williams previously with Ms. Patel, I would agree that he is entitled to bond on the count one, which was murder. When the case was indicted on May 10th, the state then did add an additional 9 charges, 4 counts of felony murder, armed robbery, aggravated assault, and the firearm charges that go along with the incident. So I would respectfully request you deny defense counsel's motion for bond as to those counts, as there's been no change in circumstances since you heard bond. last time. In fact, since you heard bond last time, Mr. Tolbert has continued to get in trouble or at the jail. Specifically, there's been an incident on July 27th of 2021 where Mr. Tolbert was found with a very large shank on his person when he when he came in contact with the sheriff's deputies. He's had 9 incidences of not being compliant and having to be tased on several of those occasions because of his non-compliance. So I would submit to the court that he is a risk of committing felonies pending trial if he was released from custody. As Mr. Cladis and Your Honor did discuss, he did flee from Atlanta immediately after the victim, Mr. Flute, was murdered on the streets, walking down Northside Drive when the two attempted to rob him of his book bag as he walked. And because Mr. Flute didn't submit to the robbery, he was then shot, killed, and both defendants then fled and immediately fled to Chicago. When he was arrested in Chicago, he was arrested with a decent amount of cocaine, enough to be charged with possession with intent to distribute cocaine. So that was what that was the drug charges in which he was charged with in Chicago. Based upon all of that, Your Honor, we respectfully request that you deny defense counsel's motion for bond at this time, as it pertains to counts 2 through 10.
Mr. Williams remains in custody, as far as you know?
Yes, Your Honor.
Okay.
Your Honor, a plea bond was granted for Mr. Williams.
It was, I'm looking at it. And so I'm trying to work through why I wouldn't treat Mr. Tolbert the same. I didn't realize that is it your understanding, Mr. Abate, that Mr. Tolbert and Mr. Williams were actually found together in Chicago, or they both happened to be in Chicago?
Oh, no, they were found together. They were arrested together.
Okay. All right. So, Mr. Tolbert, I'm going to set the identical bond for you that I did for Mr. Williams. It's a big old amount. I don't expect you to be able to make it, but there's a reason for that. I disagree with Mr. Cladis a little bit when he says you've got nowhere to go, because apparently you had Illinois to go to. I haven't heard any connection you had to Illinois other than that had you with Mr. Williams, and it had you way away from Atlanta where you were wanted on these charges. But through no fault of yours, you've been sitting in jail for far, far too long. I am almost as anxious as you to get this case to trial. I don't know what to do to make it happen.
Say, Judge McBurney.
Yes, sir.
Excuse me, may I speak to you on my behalf? I was just saying that I have 6 charges. I don't have 10 charges. And I was only originally locked up for murder.
He's correct.
Okay.
He's charged with counts 1 through 3.
And when they came and got me from Illinois, I was a person of interest. I had no warrant of murder on me.
Mr. Tolbert, we can talk about this a little bit more. I can address this with the judge.
All right. So I didn't mean to misspeak. What I don't want you to do is think that I'm misunderstanding what's in the indictment. I'm looking at the indictment right now on my screen, and you're right. You are not listed in all of the counts. You're listed in counts 1 through 3. So murder, 2 felony murders, an armed robbery, aggravated assault, and a gun charge. You are not listed in all the counts. That being said,
excuse me. I was waiting for my turn, my opportunity to speak. Can I speak on behalf of my son, please? My name is Frank Fluid. I'm Frank's father, the deceased.
So you may. This isn't quite the time.
Okay, no problem. Sorry.
No, don't worry about it. Thank you for being here. So, Mr. Tolbert, you are nonetheless indicted for murder and 2 counts of felony murder, armed robbery, etc. Serious stuff. You're found in Illinois, not in Georgia. So I have reasons to be concerned about, one, the safety of the community if you are out and about, and I suspect I'll hear that from Mr. Fluid's father. I also have reasons to be concerned that you might skip town because there you were in Illinois, and I didn't hear anything from Mr. Cladis about your connections to Illinois, just that you were caught there.
I had planned to address it further. I thought I would speak again, but I don't need to.
No, I want you to speak again. It's just Mr. Tolbert spoke up. And so I get it that he's not listed in all the counts. But that doesn't change my analysis. He's listed in the important counts. So I want to do this in an orderly way. I'm going to let Mr. Cladis go last as the movement. Mr. Fluitt, if there are things you'd like to share with me about your thoughts about bond for Mr. Tolbert, now would be a great time for you to share that.
Thank you, Judge. I appreciate it. Thank you for allowing me to address the court. I'm sorry for interrupting before. I getting kind of nervous and think I'd be able to speak.
Not a problem. Thank you for speaking up.
Yes, sir. I would like to say, Frank was my firstborn son, and he was loved. He was loved. And these guys are talking about how many days this guy spent in jail. Well, my son has been dead even longer.
Hey, excuse me, Mr. Frank.
I feel that he doesn't deserve bond. He deserves to stay exactly where he is right now. And that's all I have to say, Judge. Thank you for allowing me to address the court. Thank you.
Mr. Fluitt, you have an absolute right to be heard in situations like this, and the district attorney's office will continue to let you know when we have hearings in connection with your son's case. So you're welcome. It's appropriate that I hear from you. You are what we call a stakeholder in this process as one of the family members of Mr. Fluitt. So I encourage you to stay involved as long as that's consistent with you being comfortable. I know it's emotional and it's difficult, and it's clear from hearing from you that the wounds are still raw for you and your family, even though it has been so much time and you haven't been able to move on because we haven't had a trial for a jury to decide whether the right people have been charged for the death of your son. Thank you for joining us.
Thank you, sir.
Mr. Cladis.
I do just want to quickly address Mr. Tolbert's being in Chicago. He did go with Mr. Williams. He talked about that with the police. He did not go there entirely willingly, but in any event, the court has granted our request, and I thank Your Honor.
Okay. Mr. Tolbert, I'm going to set a $300,000 bond, just like I did for Mr. Williams. I'll allocate it across the 6 counts, so it'll probably be $50,000 per count. I think that's the right math. It was $30,000 per count for Mr. Williams, but that's because he has 10 counts. It will be through the sheriff's 10% program. So if you or family can come up with 10% of that bond amount, then you'll be able to get out, and that money, for the most part, will be returned to you or your family when your charges are resolved. You will be subject to pretrial supervision at level 3, and you are to have no contact with Mr. Williams, the co-defendant, as well as no contact with any member of Mr. Fluitt's family. I'm gonna unmute you now. I had muted you because you were interrupting other people. But if there's a question that you've got, I'm happy to answer your question. If instead you're gonna complain about something, now isn't the time to do that. So Mr. Tolbert, do you have any questions?
I was just gonna ask, so you saying that I don't have to pay the whole cash amount to the jail?
That's right.
I can go through a bonding company and pay 10%.
No, it won't be through a bonding company. It'll be through the sheriff, but you and Mr. Cladis can talk about that, okay?
Thank you, Mr. McBurney.
You bet. One other thing, Mr. Tolbert will be required to wear an ankle monitor, and Mr. Cladis, you'll need to get that address where he'd be staying to Ms. Nelson, so that can be baked into the bond as well.
Would the court consider a county-funded ankle monitor?
Yes.
Your Honor.
Okay. All right. So I think that clears out the first calendar, except for Mr. Lloyd, who I'm not forgetting, but again, he's not on Zoom. So I think next would be Malik Henderson. See if we can find him in 2 North.
Judge, can I?
Nope, 6 South. Hold on one second. Let me just make sure. Mr. Henderson, is that you? Okay. Yes, Mr. Abate.
Do we have an idea who is going to be the newly appointed lawyer for Mr. Tolbert, so I can make sure I start getting discovery to him ASAP?
So I'm sending an email to Ms. Ali as well as Ms. Bernard today, asking that same question. I asked Mr. Cladis and he said that wasn't clear, which is most unfortunate. So I would hold on to everything. And when I get a good answer from management, I'll let you know. Mr. Cladis may hear before I do, and I trust he'll let Ms. Nelson know. And you just need to let Ms. Nelson know. She can push it out to all the lawyers. But as you know better than anyone, there are a lot of defendants who were hinging on there being a lawyer ready to go to trial, Ms. Boyd, Mr. Tolbert, and others. So we need to figure out who that's going to be. All right?
Thank you, Judge.
You bet. All right, let me get Mr. Henderson unmuted.
Sure. Judge, I will see you at 1:30.
All right. All right, Mr. Henderson, can you hear me?
Yes, sir.
Great, good morning. Who's that in there with you?
It's my client, Judge, Mr. Wilson. He's
I'm not sure.
All right, hey, Mr. Wilson, I need you to leave the booth, all right? We're not going to forget about you. He did not want to share that booth. All right. Mr. Henderson is on, so we can discuss a motion to reinstate bond. Ms. Kaufman we got like 20 people standing up right now. Oh my gosh. Let me find out who's handling this for the state.
That's Kim Carey, Your Honor.
Hey, Ms. Carey, that's the name on my calendar. I love it when it's right. And Ms. Kaufman represents Mr. Henderson. You have Ms. Singleton here.
I'm with Ms. Kaufman and Mr. Henderson's also on the case. It's interesting.
Three defense attorneys. Okay. All we're talking about today is whether we reinstate bond. Ms. Carey, do you have a perspective on that?
Yes, Your Honor. The psychosexual was scheduled to be completed prior to this hearing.
Let me make sure. Ms. Rivers, are you able to hear people? They're all real far from the microphone.
I would prefer them near a microphone.
All right, let's mosey on up. And if you want to spread out, we got 3 microphones people can use. Prosecutor can use prosecutor's table. There's the podium. All right, let me be more organized about this. Okay, let's go on the record. This is 22 SC 183095, State versus Malik Henderson. And I'm looking at the motion to reinstate bond. It refers to Judge Newkirk. Is that because Judge Newkirk heard the bond hearing when it was unindicted?
I believe, yes, Your Honor.
Okay, no longer his business, mine. It's been indicted and got assigned to me. So I have no background in this. Doesn't mean I'm not the right person to hear it, but whatever happened with Judge Newkirk and his litigation manager, et cetera, will be news to me. So folks are going to need to walk me through it. I have read Ms. Kaufman's motion seeking to reinstate the bond. It was filed in July, and we ought to work through that. So why don't I start with you, Ms. Kaufman, and then I will hear from Ms. Carey. I just thought if there had been a misunderstanding and the state was saying, of course it should be reinstated, we could short circuit it, but it sounds like it's more complicated than that. So why don't we start with you, Ms. Kaufman? Mr. Henderson, all we're going to be talking about today is whether your bond should be reinstated, okay?
Yes, sir. Yes, sir.
All right. When you're ready, Ms. Kaufman.
So, Your Honor, it came to our attention this morning while speaking with the state that there's been a number of issues / reasons why they will not agree to or consent to a reinstatement of Malik's bond. For that reason, we think it would be prudent to have his psychosexual exam completed prior to coming before Your Honor to ask for this reinstatement. He's scheduled to have the psychosexual exam on September 16th. We are going to ask Medlin if they can push that up any. And then we'd like to ask to come back before Your Honor sometime towards, later in September.
Sure. Once we've got results and everyone can point to concerns or lack of concerns based upon that assessment.
Yes.
Fair statement?
Yes, that's a fair statement.
Okay.
I know he's having a hard time.
Just looking at the indictment to try to figure out why there's a fleet of lawyers representing Mr. Henderson, but that will be revealed to me at another time. Do you have any objection to that, Ms. Carey, that we maintain the status quo, ensure that Mr. Henderson has the aforementioned evaluation, everyone gets the results, and then we can work through what those results say about the wisdom of reinstating bond? And there may be other reasons why it should not be reinstated because it at some point got taken away, and those may not be addressed by the evaluation. So we're not removing anything from the table, but we'll be adding richness to the discussion. And that may alleviate concerns or heighten concerns on either side once we get those results.
Yes, Your Honor, and no objection from the state. It was actually my idea that we have this completed prior to having the motion to reinstate. I would just ask that all of our witnesses for this hearing be held under the subpoena that we provided them for this hearing until the conclusion of this matter.
Well, I'll let you manage that. I'm not a big fan of 3-month subpoenas. And so if it's that we can't reconvene until I'm making a date up September 28th, and one of your witnesses is supposed to be out of the country, then we'll see. But what I will do is if you share with Ms. Nelson that a witness that you think is essential to your presentation can't make it on that new day, then we may have to bump it by a day or two to accommodate the fact that you had all the witnesses today, and we ought to try to have them all again when we reconvene.
Thank you, Your Honor.
All right, Mr. Schiffer, you looked like you wanted to say something.
Yes, Judge. And I know that one of the biggest concerns with this case is Mr. Henderson's age and his safety within the Fulton County Jail. His mother has been in regular and routine touch. As concerned as she is about her son's facts and the actual case, his daily condition is extraordinarily difficult for her, as it is, I'm sure, for Mr. Henderson. He has had more than one associate harmed in the jail, and he literally turned 18 in Rice Street. And I understand that the court is limited with what remedies that it can apply, but if there's any consideration that can be done, it certainly needs to be noted for the record. We are in great fear for his personal safety while incarcerated.
Okay, I appreciate that concern, and I'm hearing it more and more frequently. But you did answer one of my questions, which was, why is he at Rice Street? He's 18. He was 17. So he is in the appropriate facility if he's going to be in custody. There are a couple of other options that we can talk about, Cobb County, et cetera. I've offered that in the past, and some defendants have said, oh no, I'm good where I am. So you should talk with your client and his family. And if a different facility over which the sheriff exercises authority is preferred, we can usually make that happen. And I'm happy to make that request. I don't want to do it sua sponte again, because I have then had lawyers say, what'd you do that for? Well, because you asked me to. So why don't you sort out what you think would be the best scenario? But second question, you said he's had associates harmed. I hear that when it's a gang case and this and that. And maybe that's why there are 15 lawyers on a one defendant case. But this case doesn't jump out at me as one where his associates are at risk because they're slime or they're anti-slime.
No, I meant, friends, there's absolutely no gang anything with this case. That's just lawyer speak and my crippling mental illness that came with my JD.
Okay, there is a cure for that.
They won't let me quit yet, Judge.
Yeah, all right. All right, so what we're going to do is reset this. We will not pick a date yet because it's driven in part by whether, Ms. Kaufman, you're able to get the evaluation accelerated. But please just reach out to Ms. Nelson, and we can have Mr. Henderson here in person on one of our in-person days or virtually. We have one each every week, so we have sort of doubled our capacity. Virtual used to be on a strange cadence, but now, unless I'm in trial, each week we've got an in-person inmate calendar and a virtual inmate calendar. which makes it easier to drop a single defendant in on a particular date. So work with Ms. Carey, and then if there's agreed upon date, let Ms. Nelson know, and we'll see what we can do.
Thank you, Judge.
Mr. Henderson, did you follow enough of that you think you understand what's next?
Yes, sir.
Okay, so you're gonna meet with some folks who are gonna want to ask you a bunch of questions, talk to you about some things. Hopefully you'll cooperate with them, but I'm gonna let your lawyers talk to you about that. After you've had that set of conversations, we're gonna meet again to talk about whether your bond should be reinstated or modified in some way. That'll be in a few weeks, okay?
Yes, sir.
All right, Ms. Carey, anything else?
No, Your Honor.
And Ms. Singleton, you will remain engaged in this case because of the age of Mr. Henderson at the time of the alleged offense.
That's correct, Your Honor.
Does he ever age out of it? Like if he becomes 25 before?
No, Your Honor, I actually have someone that's like 28.
Okay, that won't be this case, okay? All right.
Thank you.
You bet. All right, Mr. Henderson, you're free to go.
Thank you, Judge.
Thank you all.
Maybe be excused, Your Honor?
Yes, everyone who was here, all the many people here for Mr. Henderson.
No, I'm just gonna go and see Mike.
What about arraignment on that case? I didn't see if it's been arraigned.
I'm sorry, I couldn't hear whoever just said that.
It's Ms. Nelson. I was checking to see if the paperwork had been filed for his arraignment, waiving arraignment.
Oh, can you see if Ms. Kaufman is still around? Any one of those many lawyers. And what we're gonna do next is Mr. Riggins. Is that you, Mr. Riggins and Cobb? Can you wave your hand? It is. All right. Ms. Kaufman, Ms. Nelson, speaking through like 5 tin cans and 6 sponges, asked if you were waiving arraignment for Mr. Henderson.
Yes, we will waive arraignment, plead not guilty. I'll file it.
One of those forms Mr. Kane was struggling with.
Thank you, Judge.
You could file it, or since you came back, you can leave it with me and we'll get it filed. All right. Who is handling Mr. Riggins's case for Mr. Riggins?
I am, Judge. Good morning.
It's Mr. Hudson. Excellent.
Yes,
how do I find you? How are you connected to us? Up there you are.
I'm in the car, Judge. I'm actually heading down to Fulton County, but I had to log on. Ms. Nelson sent the Zoom link.
Good. I want you to stay right there and do not operate your motor vehicle while we're doing this.
I'm parked in my office parking lot.
That's a good spot to be in. All right, stay there. Let me get your client off mute. There he is. All right, Mr. Riggins, can you hear me?
Yes, sir.
Great. All right, Mr. Riggins, you are on for plea and arraignment. You're charged with aggravated assault and possession of a gun or a knife and a misdemeanor. Mr. Hudson, is Mr. Riggins waiving arraignment, or does he want to be formally arraigned?
Your Honor, we're waiving arraignment.
All right, I will enter a scheduling order that will give the state a deadline to get you discovery, and then give you a deadline, Mr. Hudson, beyond that to file any evidentiary motions, and we'll move this case along.
All right, Judge, I also believe Mr. Riggins may have 2 cases on the calendar. I'm not sure if it's one showing. But
Nope, he does. I just forgot to turn the page. So you've got 2 cases, both with Mr. Whitenauer. The second case is more aggravated assault, more family violence, battery, etc. Are we waiving arraignment on that second case too?
Yes, Judge. Your Honor, I also filed a motion for bond, but I'll get with Ms. Nelson and I'll get with Mr. Whitenauer so we can get a date.
Please do that. Yeah, because that's not what it's on for today. That doesn't mean we can't do it soon. Happy to do it soon. There is an active probation warrant for Mr. Riggins, which might complicate his ability to make bond, but you and Mr. Whitenauer can talk about that. And if bond is something you still want to pursue, then reach out to Ms. Nelson and we'll get Mr. Riggins right back in one of these booths and take care of that.
Well, Judge, I filed a motion for bond, but I didn't really want to address it right now.
Understood.
Probation, like it'll probably be down the road or something, but I'll get with Mr. Whitenauer.
Sounds like a plan. Mr. Riggins, do you have any questions about that?
No, sir.
Okay, then Mr. Hudson will be to see you soon. Once he gets discovery from the prosecutor, he'll have more to talk to you about, and you guys will figure out a plan for moving forward, okay?
All right.
All right, you're free to go.
Thank you, Judge.
Thank you, sir.
All right, I'm coming to call up later today to see you.
Okay.
All right, bye-bye.
Sounds like a threat. All right. Next up is Mr. Wilson, back in 6 North. Or is it 6 South? Mr. Wilson, raise your hand. 6 South. All right. You got a fan base here. All right. Can you hear us?
Yes, sir.
Great. All right. Let me pull up the motion and then we'll get on the record.
Scott, can you hear me also?
Yes, sir, I can.
Andrew is outside waiting also.
What'd you say?
Andrew from Academy of Hope.
Oh, he's got a witness there at the jail that's accessible that might have to come into the booth if the court wants to hear from him.
Okay. We'll see. I'm not seeing the motion for bond, but I bet you'll be able to articulate it. Let's go on the record. Ms. Rivers, are you ready?
Yes, Judge, I'm ready.
All right. Position 4 on our add-on Zoom calendar is State versus Wilson, 22 SC 183525. Mr. Smith represents Mr. Wilson. Mr. Hiles represents the state. Mr. Wilson is charged with a series of gang offenses, murder, felony murder, aggravated assault, and possession of a firearm. All we're doing today, we're doing 2 things today, Mr. Wilson. We're talking about arraignment, and then we are talking about bond. Your lawyer has filed a demand for speedy trial, which means we need to move your case along at a fairly healthy clip. I think Mr. Smith will know this better than I because it affects his line of work even more directly, that we don't actually have a speedy trial clock ticking yet, but this certainly would be at the front of the queue because I don't think I have any other cases with the speedy trial demand. And so we're going to treat it pretty close to an active running speedy trial demand. But I just don't think that the clock is technically ticking. Let's start with arraignment. Mr. Smith, is Mr. Wilson waiving arraignment?
He is, Judge.
Has he already waived arraignment or do you need to fill out one of our forms?
He has already waived.
Great. Then a scheduling order will go out if it hasn't yet. That will give Mr. Hiles a deadline to get you the discovery he has. And that gives you then a deadline, Mr. Smith, to file any evidentiary motions that we need to work through. And we'll let that flow as it does. So I think then we can talk about bond.
Before we move on to bond, how does the court feel about the state giving me a copy of their witness list as it stands now?
I'm not doing that today. There's other reasons why.
So he didn't ask you.
I'm sorry.
He asked me. And it's not your call. It's my call. But you're asking about witness list as in, hey, if we went to trial next week, what is that witness list looking like?
Well, I'm asking, since we are waiving arraignment, the state has an obligation to provide a copy of the accusation or indictment. In this case, it's an indictment, and a copy of their witness list as it stands now. My understanding is that the state is going to re-indict the case, which goes into my motion for bond and what the court just relayed about being towards the top of the list as it relates to my demand, which will in effect make my demand, once they null process this case, ineffective, where the demand will no longer be running. So as a result of that, I am asking for a witness list so I can go ahead and get started and prepare the case. And I think I'm entitled to a witness list as it stands now.
Okay. I understand that a little bit better. A couple things. So fan base, stop waving. No more hearts. He's got it. Okay. Hands to yourself. Thank you. would you not be able to file a new demand for speedy trial on the subsequent indictment?
I will, and
Okay.
as you had mentioned, that it's told until January. So technically, the state would have Fulton County terms of court of 2 months. I'm just talking out loud, Judge. I know you know this. January, February, March, April, May, June, based upon the nature of the offenses. So technically, they can go towards the end of June, first week of July, and try his case. But it's my intent to refile another demand under 17-7-171, but the state would then have the ability to indict this case anywhere between now and then July, or when the case gets called in for trial. I know that the state was probably going to proffer. We're going to do that as soon as possible. We're going to do that next week, as we hear a lot. And I accept that. They're busy. But at the same time, there's no telling when that will happen. So I've cautioned my client about that. We were aware the state has relayed to me that they plan to re-indict the case. I think there was some effort by the state to beat the 90-day indict or release rule because it was indicted on the 89th day.
Meaning Mr. Wilson's case was?
Yes, sir.
Okay. Got it. I'm going to let Mr. Hiles address that question about witness list and concerns he may have when he responds to your motion for bond. We'll just sort of weave the two together. It's not something you're going to get right now. You're going to need to be prepared to go forward with the bond argument. My limited understanding of the case is that there may well be concerns about identifying who's going to testify, but we'll work through that. And there may be a middle ground where, at a minimum, Mr. Hiles would need to share with you where he is now with law enforcement witnesses, expert witnesses, et cetera. But it could be that lay witnesses, that's a list that is supplemented or augmented later on. But we don't need to work through that 100%, I think, for purposes of bond hearing. But I appreciate you bringing that to the forefront.
Thank you, Judge.
All right. When you're ready.
Thank you, Judge. I am asking the court to make a difficult decision in this case based upon the nature of the offenses, to grant Mr. Wilson a bond in the amount of $100,000 in aggregate with some very stringent special conditions. And I'll walk the court through that. I do believe, as a lawyer who's been practicing 22 years, that he is a good candidate for bond. I am at a slight disadvantage as I have not received discovery on the case. But new additional facts have recently come out that I've garnered through prosecution, through speaking to witnesses potentially on the case. And I want to relay what I understand of the facts of the case. The decedent in this matter, the victim, was a passenger in his own SUV. He was driving with a friend who was driving for him. There's some indication that he may have been impaired on intoxicants.
The victim or the driver?
The victim.
Okay.
And I think that's maybe why he had a driver, or some indication he was impaired. We now know that there are 3 individuals that are in the back seat of the SUV. Those 3 individuals, the state believes that my client is identified as one of those people. The state has relayed at the last time we were in front of the court, not this honorable court, but another courtroom, that the 3 individuals in the back seat were armed, but so was the victim, and the victim had his gun out at some point. In addition, the state has found a gun on the scene that was located outside of the passenger side area, and everybody fled the scene when shots were fired. My understanding from speaking to the state is that there was 1 gun that was fired, and you have 3 people in the back seat. The state believes that the forensic evidence would support that my client was potentially the one that fired the gun. It is something we vehemently deny.
Do you deny that your client was in the back seat?
At this stage, yes.
Okay. So you deny any connection at all. So it really doesn't matter who shot the gun because your client wasn't there.
That's right.
Okay.
And, admissions in Judico are funny because I don't want to put myself in a posture where I'm ruling out potential defenses. And that's why I said what I said, Judge, if you can read between the lines.
I know, I fully understand. I just wanted to, I was trying to read between the lines as well, because you said we vehemently deny my client fired the gun. I heard that. And so I asked what I asked, but I'm following you.
And you do ask very poignant questions, and I don't know why I'm using Latin. I think it's only when I'm in front of you.
I don't use Latin, but you're welcome to.
Okay. Judge, my understanding is all the people in the backseat fled, including the driver as well fled. There was some indication that the passenger victim had texted the driver to be on the lookout for the people in the back seat, that he felt like that maybe they were going to commit a robbery or something to that effect, is my understanding. At this juncture, the state, as my understanding, does not have a motive for the offense. There is no crossover between my client and one of the defendants that is found or believed to be in the back seat of the vehicle as well. I should note that.
When you say crossover,
Meaning that there's no ties between the two of them.
okay. So you think you know who the other two, well,
I do.
first of all, your client wasn't in the backseat, but you think you know beyond the mystery person who may be named Wilson, you think you know who one of the others is?
I do, to the extent that they have been arrested on these charges and
Oh.
are currently at Rice Street.
Well, that would link them to it.
Yes.
Okay, got it.
Yeah. And let me walk you through the procedural history of the case, if I can. My client was initially contacted by law enforcement. Law enforcement went out to my client's address. He left his card, notified that he wanted to see him as a person of interest. I was then contacted by Mr. Wilson. Mr. Wilson came to my office. He hired me to reach out to law enforcement. I reached out to the homicide detective. I said who I was. I identified that I was representing Mr. Wilson. In the conversation, he identified my client as a person of interest. We were working through the process with law enforcement when my client was arrested.
So that I follow that, there was this initial, we'll call it cooperation. But before that could amount to a proffer, a sit down or anything, your client was arrested.
Yes.
On a warrant for this, or he was arrested because he ran a red light?
On a warrant for this.
Okay. And was that something you were given advance notice of, or you learned because your client said, hey, I just got arrested for this thing you're helping with?
I was not informed that there was an arrest warrant. My conversations with the lead detective, I think there was at least two, were cordial. We made small talk. We talked about the case. He talked about Mr. Wilson having been a victim in the past on one of his cases, and he's identified or knows Mr. Wilson. He knows that Mr. Wilson is engaged in the music career. And I was not given information that they were going to arrest him. Had I been, I think my client was in a possession to turn himself in voluntarily. And that was a discussion Mr. Wilson and I had in my office and on the telephone. In addition, I don't fault law enforcement, though. They have a job to do. And I know the court doesn't either, but at the same time, this is probably like the fifth time that I've tried to reach out to law enforcement, try to be cooperative. I just explained that to Judge Carnesale yesterday, that we even went in and spoke to law enforcement, and then all of a sudden my client had an arrest warrant without being told, even though I've informed them I was willing to voluntarily surrender at Rice Street. The court is aware of the procedural posture of the case, that the case was indicted on the 89th day. The state did so in order to beat the indictment or to beat the 90-day indict or release rule. We now know that the case is going to be re-indicted. I'm going to walk you through the Ayala factors for the court. I know that this court is a stickler for details, so I'm trying to give you as much details as possible. Mr. Wilson is also known as Crystal, and his stage name is Baby Drill.
Baby Drill?
D-R-I-L-L. What is drill, Judge? It is what people call rap music, or it's a type of rap music. Some say it was started here in Atlanta. Others say that it was started in Chicago. Big discussion on the listservs where it was started, but it's a nature of rap that is very hot right now and very popular with young kids, and it's called drill rap. He's 20 years old. He lives with his mother and sister. His mother is online. His sister, I believe, is present here in the courtroom. The address is 1761 McClelland Avenue in Atlanta. His sister and mother live with him. His sister is 28 years old. She works for the Hyatt Regency downtown as a manager. He has 3 sisters in total. One sister is a business owner. Second sister, Hyatt, works for the Hyatt downtown, the middle sister. And then his youngest sister works for Delta as a concierge in the first class department. His sister that he'll reside with is 28 years old. She's lived in the house for 4 years. He has no children and he has no passport. As it relates to his family connections to Atlanta, he's a multi-generational resident of Atlanta, meaning that his immediate family and extended family all live in Atlanta. He himself was born at Grady Hospital, being a Grady baby. He attended elementary school at Wilson, middle school at Gene Child Middle School, and then high school at Douglas High School. But then he also attended military school at Milledgeville Academy, and he's completed that. But his graduation degree is from Douglas High School.
So Milledgeville was a temporary, Douglas wasn't working or whatever was going on, back to Douglas and graduated from Douglas.
No, graduated from Douglas, went to Milledgeville post-graduation for a 6-month stint, and then successfully completed Milledgeville as well. He has no psychiatric issues, no medical issues, other than he does suffer from bronchitis and asthma. His mother is a registered nurse. And to tell you a little bit about his mom, she's been a nurse for 25 years. She's been a mother of 4 children. They grew up lower middle class. And her job is, she worked entirely through the pandemic, is to take care of the sick. She worked for a company called Accountable Healthcare. And she currently has a contract with Gainesville that lasts 1 year. So you know that she's staying in the metro Atlanta area and continue to live and reside at that address.
She'll just commute to Gainesville?
She'll commute to Gainesville, which is about an hour drive from here or from the house. As far as his grades go, they were not great, but they were enough to pass or graduate. As it relates to his mother, she does have insurance that includes him under her umbrella insurance. I do want to address with the court just a little bit about him. I know that I have several witnesses that are going to speak to his character, but I think there is going to be one in particular that I'll talk about. Judge, do you see Rondre Walker on the screen?
I'm here.
Oh, you're here, Mr. Walker. How do you want to do this, Judge? Can I call him up to the podium?
If he needs to be under oath, he can come up there. If he's just going to, I don't mean to minimize it because it's important. If he's going to just share how he knows Mr. Wilson, how Mr. Wilson's a good guy, that doesn't need to be under oath. If it's going to become more fact intensive, I want to give Mr. Hiles a chance to ask questions, but that is uncommon in my experience with bond hearings. You'll know better the kinds of things that this gentleman would be talking about.
Yes, no doubt, Judge. So I just want to tell you a little bit about my client's upbringing. I said that his mom was a single mom. After 20 some odd years of marriage, his biological father had left the family, had basically absconded, even though he lived here in Atlanta. And there's a very emotional story that the family tells about when he was a young man, a teenager, he and his girlfriend went to his biological father's house, found out where he lived, and knocked on the door, and they heard shuffling and rumbling going on inside the house. And no one came to the door when he identified who he was. Mr. Wilson went home and he cried like a baby, according to his mom. The reason that I was going to call Mr. Walker, who's also known as Big Dre, is number one, he owns his own business. He's an entrepreneur. It's a very successful business, but he's acted like a father figure to Mr. Wilson, stepped into the role. He told me when I talked to him in preparing for the bond hearing that Mr. Wilson has always been a good role model in their neighborhood. He was a neighbor to him. He's always been supportive of kids, and he's always had a soft heart for people that are homeless. Stories go that he would stop the car, feed homeless, provide money to homeless, and continues to do so up until his arrest. I'm very aware that the state is going to paint a picture of a gang member, of a violent interaction. We're prepared to overcome that to the best of our ability today by describing a little bit about what you see on the social media and why it's there. It's going to be a blurring of both art and marketing that the state is going to sink their teeth into, and I do respect their position, though. But I did want to just proffer, if I can, with your permission. Did you want to speak, or can I proffer what you know I talked about? Of course. That he actually is a soft-spoken kid. He's polite and respectful. He uses manners. He also has always talked to kids about doing the right thing. And he could speak to that, is what he would be testifying to. And I think his ties to the community are pretty substantial. I'm talking about Mr. Walker and my client, of course. I do want to turn my attention briefly to a witness I do want to call, and that is going to be Mr. Pitts from the CEO of RCA Records and Sony Entertainment. He should be online, Judge.
I'm on. Good morning. Can you hear me?
We hear you, but bear with us 2 seconds. We're going to be able to pull you up.
All right, Mark's iPhone.
Judge, this is Mark Pitts, P-I-T-T-S. Mr. Pitts, do you mind raising your right hand? Do you swear or affirm the testimony you're going to give the court should be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, can you please state your name?
Mark Pitts.
And Mr. Pitts, I know you're on the West Coast and you got up very early this morning to be here. You're in California, correct?
Correct.
Okay, can you please identify your name and your job title?
Mark Pitts, and actually the president of RCA. I didn't get the CEO yet. I'm almost there. The president of RCA under the Sony Music Group.
And you are familiar with Mr. Wilson?
Yes.
Okay, and I just want to lead you a little bit just to get to cut to the chase. I know I'm taking up a lot of the court's time. As it relates to Mr. Wilson, he is a current artist that is signed with your entertainment group.
That is correct.
Okay, and there's a couple things I just want to relay to the court, and you tell me if I'm correct about this. He is under his employment agreement. He's potentially worth millions of dollars. Would you agree with that?
Yes.
Okay, and the time period for capturing the funds of capturing that amount of money, is that now?
Oh, absolutely.
Can you explain that to the court?
It's now because he's one of the hottest young prospects in the streets of Atlanta. You know, he was very well sought after, and he has great potential to do amazing things. But the time is now. You know, the music industry moves fast. It moves fast, and you definitely have to take advantage of moments.
Would you agree with me that one of the needs for him under his obligation to your company and in order for him to capture his income would be to be in the studio?
Yes, that's definitely, it definitely starts there. We need to record, absolutely.
Okay. And then would your company be supportive of the idea of him being able to reside at home on an ankle monitor solely with a curfew, but not a curfew, but 24 hours, 7 days a week of home confinement, but support him in traveling to and from the studio?
Yes, the company will support him, and I personally will support him.
Okay. And do you have people in place here in Atlanta that will ensure that he does not drive and that he just gets transported to and from the studio?
Yes.
Okay. And then I want to talk briefly about social media. And you and I had spoken recently about this, but his social media, is that entirely run and operated by his record label?
He said every situation is different. But I guess his social media now will be, run by the team.
Okay, and the team is people under your umbrella?
Yes.
Okay. And to the best of your understanding or knowledge, and if you don't know this, it's fine, but they have been operating his social media as of today. Would you agree with that?
I can't say it with great. I believe so, but I can't say. I can't pinpoint exactly when.
Okay. All right. Mr. Pitts, is there anything else that you want to add about the case based upon your understanding of the case?
Listen, I've been in this game for a long time, almost 30 years. I've been around it from, I don't know if y'all familiar with Biggie Smalls, Notorious Big, I'm Henderson, I've seen it all. And I watch a lot of these lyrics, I don't know. I watch a lot of these, I've been hearing a lot what's been going on with these cases. And, these guys, a lot, it's like, they like screenwriters, you know what I mean? And I see, and I understand,
when they matching lyrics and what Laura was trying to do. But at the same time, I watched it for years, and to me, a lot of it's personally unfair when I hear when I'm hearing connection to lyrics in cases. I can't speak for everyone, but I've seen enough of it to know that it isn't. It's they write movies.
Things didn't end real well for Mr. Smalls. Is that the example you really wanted to give?
I mean, but Mr. Smalls wasn't talking about lyrics. It wasn't about a lyric thing.
Well, there seemed to be some overlap between lyrics and life for him. So you may want to come up with another example next time you're testifying.
No, I mean, I hear what you're saying, Judge, but
yeah.
I lived it, and maybe it doesn't ring fresh with you, but I'm just saying I know them. I know him. He was a man. His mother was a Jehovah's Witness, and I knew who he was, and I understand that. But I know who he wasn't, and I know who he was.
Okay.
Nonetheless, Judge, online you'll see that we have a tremendous amount of support from several folks that are within the company that are layered, including people that will operate a social media and have been operating social media. I can proffer that. He has not been operating it himself. Thank you, Mr. Pitts. I appreciate you so much. I know you got a doctor's appointment to go to. Thank you, sir.
Before he goes, though, Mr. Hiles, do you have any questions for Mr. Pitts?
No, sir. I think it was all said.
Okay. All right, Mr. Pitts, I appreciate it. Where are you in Southern California?
I'm in right now. I'm in Century City, California.
All right. Well, thank you for joining us at the early hour.
No, absolutely. You guys have a blessed day.
You too.
Judge, as it relates to my client's criminal record, he has no felony convictions. He's not at risk of committing new felonies. He does have a pending case in Clayton County that occurred prior to being implicated in this case. I have negotiated a resolution on that case, and I'll read it to you. It's a plea of no contest to reckless driving, where he'll get 12 months of probation. And that comes from Andrea Thomas. I don't know if she appeared in front of you when she was a prosecutor here in Fulton, but she's now in the Clayton County District Attorney's Office. And that email was sent to me, and I could tender that if the court wants to see a copy of it.
What was he arrested for in Clayton County?
Yeah, thank you, Judge. It was fleeing, attempting to elude, tag violation, reckless driving, stopping, failing to yield, improper turn, and a highway violation that I'm unclear what the highway violation is.
But it was all motor vehicles, no gun in the car, anything like that.
All Title 40.
Okay. All right.
But I do have a copy of the plea negotiations if the court wants to see it. And we're just waiting to go in front of Judge Carter. If you were to grant him a bond, one of the special conditions we would ask for is permission to attend court appearances when directed to do so.
Okay.
Judge, I do think that there is, and I'm just going to briefly touch on it, some due process argument. I know what the law says about the state being able to re-indict the case and so forth. But I do think the state has an obligation to bring this case to a correct indictment or an accurate indictment as soon as possible. They understand their obligation because they clearly met it on the 89th day. But I do think that there's something that potentially deep within the Georgia Constitution, maybe Justice Peterson could find it for me.
He will. 80 pages in.
I was expecting that. That's why I'm smiling. So, Judge, I do want to give you my proposal. Oh, I do believe Andre is there. Can you just show him in? Judge, this is a little awkward, but there's a witness that's at the jail that comes and supports the members of the jail. Can he come in and just identify himself?
Is he going to be at 6 South or do we need to find him?
He's at 6 South. He's standing outside. He's a civilian witness. Thank you for the court's indulgence.
No problem.
Hello, sir. How are you?
I'm doing great, and yourself, sir?
Good. Do you mind stating your name for the court?
My name is Andre Norman.
And sir, do you mind teaching us, what do you do at the jail? What do you assist with?
I run a violence interruption program.
Okay. And have you had interaction with Mr. Wilson during his stint at the Fulton County Rice Street Jail?
Yes, I have, sir.
And what has your interaction been with Mr. Wilson?
Mr. Wilson enrolled into our program, and he's been a participant in the violence interruption program here at Fulton County Jail, sir.
And has he been a good participant?
Yes, he has.
Okay. I don't have any further questions.
Mr. Norman, I'm Judge McBurney. Thank you for taking a minute out of your busy day.
No problem, sir.
How many inmates there participate in your program?
Currently, we're working in, I'm gonna give you a number. I would say we're roughly around 240 people we're interacting with, sir.
Okay, and how does that, you don't bring all 240 together at once. How is it that you connect with your clients?
The way the jail is set up, there's a zone where there's 6 housing units on the floor. And they're all on one side. There's 6 south and 6 north. There's 6 housing units that we have access to. And we go into the housing units and we speak to the gentleman. We're literally in 6 south right now. So there's zone 100, which has 40 men, zone 200, roughly 40 men, all the way around the 6. So we go into the zones and we speak to the men in the zones.
So it sounds like there are about 240 people in the zone across the 6 zones, if they're 40 each. Does that mean almost everyone is a participant?
Yes, sir. Majority of the people are participating, yes.
Okay, thank you so much. Did you have any questions for Mr. Norman, Mr. Hiles?
I don't, Your Honor.
Okay, anything else for him, Mr. Smith?
No, Judge.
All right, thank you, sir.
You're welcome.
Judge, I have a proposal for the court. Is now a good time?
So you'll get the last word too. If you want to save it till then, you can share it now. It may help to share it now so that Mr. Hiles can react or respond to the proposal. I know it starts with 100,000.
It starts with 100,000. Thank you, Judge. We would ask for the 10% option if accessible. In addition to that, we would be waiving our speedy trial demand if he were to be granted a bond. And I hate saying that because I don't want the court to feel like I'm saying that to put pressure on the court or the prosecution. Ankle monitor being affixed 24/7. We're asking for pretrial supervision level 3. We're asking for a 24-hour curfew with an exception that he'd be permitted to go to the studio to work, and I can provide that studio name and address.
But that's local. It's not going to Century City to be with Mr. Pitts.
No, that's exactly right. Even though that's something we talked about, but it's nothing that we understand that there's limitations on his travel, and it would be simply for studio work, studio to work, attend his lawyer's office in court. In the court, of course, you would now know is Clayton County and Fulton County. That he cannot drive. He must be driven. No cell phone use. No social media use, no iPad or electronic device to communicate, no contact with either the co-defendants or co-indictees, co-arrestees, cannot control social media himself, no guns or replica guns. As you'll see on some of the videos, or the state presents some of his videos, he does have replica guns. In those videos, or people in the videos have those with him. And that would be my recommendation to the court.
And it would be residing with mom, the registered nurse who is going to be doing work in Gainesville, and sister, middle sister, who is the manager at the Hyatt.
And I appreciate you bringing that up because they actually do work 2 different shifts. One works night shift and one works day shift. So somebody will always be home with him that's an adult.
Okay.
And I do obviously have people present here, including his family members.
There were clearly a lot of people here in support of Mr. Wilson. I'm surprised they didn't hold up their cell phones with the lights on as well. All right, Mr. Hiles, what is the state's thought about bond for Mr. Wilson?
Your Honor, sorry. I also want to apologize. I'm sorry for cutting off Mr. Smith and jumping in.
It's all right. Got some energy about this case.
I do. Your Honor, we are adamantly opposed to bond. And I just want to address the reasons I'm not apt to turn over a witness list today. I understand that Mr. Smith is entitled to it, and I'm going to comply with all the court's orders and discovery order. But we have recovered cell phones and jail calls that relay direct threats to witnesses, both in this case, as well as others who are believed by this particular gang, PDE, which stands for paper, drugs, extortion, to be snitching on the gang, directly asking for paperwork. So I am going through the Crime Victims' Rights Bill. There are specific filings that I am gathering and anticipate bringing before this court within the next week or two to make sure that those witnesses have all the protections that the law gives them before I turn over information to Mr. Smith. I trust Mr. Smith, but there has been some very public leaks after our office has turned over discovery recently that has given me great pause to be doing that at this juncture.
Right. I don't like you. I don't think the issue is defense counsel so much as then defense counsel, for it to be valuable, needs to share that information. And the weaker links are maybe one step removed from most of the defense attorneys.
And I totally, and that is my position as well. Your Honor, I understand that the defense is adamantly denying that Mr. Wilson was in the car. It's the state's position that he was. This incident occurred just after 2 a.m. On April 8th of this past year, where—
As in 2022?
Yes, Your Honor.
Okay.
And this was a performance at the Diamond Club, which is, I guess, sort of North Buckhead on Northside Drive, for which—
Performance as in, Baby Drill,
no,
AKA Crystal, was performing?
No, Mr. Drill was in attendance.
Okay.
It is two of his record label / gang members performing at that particular incident.
When you say record label, RCA, or is there a local?
So, the PDE does have a separate, in fact, a LLC that is a record label. I'm not saying that they are not part of a record label. I'm just alleging that they are also a criminal street gang by definition and by action. Your Honor, we have detailed video of the co-defendants, Mr. Edgequervis Hall and Sewell Pepper, with Mr. Wilson, Baby Drill, inside the club and then leaving, getting all into the same car. We also have a message sent directly from Mr. Wilson's phone. This was recovered on the phone he was arrested with. It was sent to his co-defendant, Edgequervis Hall, about 2 minutes prior to Mr. Hall leaving the club with the victim, that said, "I am outside with all the guns." That is what was sent from Wilson to co-defendant Hall, who are close associates and members of the PDE gang.
So Mr. Smith shared with me that he, of course, is climbing the steep learning curve of discovery. Maybe doesn't have all these things. Are the things you share with me right now, the text, et cetera, something that Mr. Smith already has, or something that he will get soon because he's filed the waiver of arraignment?
He will get very soon because he's filed the waiver of arraignment. We're
Okay.
going through making sure that the witnesses are turned over in the proper way. It's not a hide the ball issue. I'm gonna walk them through discovery.
No, and that's not my concern at all. My experience with you, it came up yesterday. You'll say the cell phone has 1,000 pictures. Here are the only 2 we care about. You can look at the other 998, but this is what the state's focused on. Mike, I didn't ask the question well. You're sharing with me some of what you think will come out as this case develops. It's just something that Mr. Smith, if he's heard about it, he would have heard about it by talking with his client, not because you provided it already.
That's correct.
Okay.
I have not provided.
That's not a
anything.
critique. I just wanted to, if Mr. Smith says, gosh, I didn't know that, there isn't a way he would know that.
I don't think
at least
he would
from the
know
state.
that. I don't think he would know that information. And he will be getting a copy of that cell phone dump along with many other things.
Okay.
Your Honor, this was an execution style shooting. The victim was shot just behind the ear over the backseat. It's the state's position based on video evidence that Mr. Wilson was in the seat directly behind him, and that forensics would show that he, in fact, was the shooter. He is seen fleeing the car. That is on video from where it parked in Midtown. So I also want to point out that he does have a juvenile record. He has a adjudication of delinquency for a robbery. under 18 DL 03008. That adjudication of delinquency was on May 13th of 2019. I'm sorry, it was on October 10th, 2018, and the case was actually closed and transferred to a different county on May 13th of 2019. I don't know where it was transferred, because when there is an adjudication of delinquency, whatever county the juvenile resides in is going to be the county that handles it. And once it leaves Fulton, I don't have any more information on it.
Okay.
And then I just learned today that there was a negotiated resolution on the
Clayton case?
Yeah, the Clayton case. So I do know, though.
So everyone is learning things on both sides.
That is true.
All right.
That is true. However, I do know that prior to Mr. Wilson's arrest on this case, that Clayton case was in bench warrant status. And I believe has been since 2020. You can correct me if I'm wrong.
Well, he's going to get a chance. He's not going to interrupt you. He's making notes, and I'm making a list.
So, Your Honor, there was a video call between Mr. Wilson and three other identified gang leaders of PDE. On that video call, it was observed that Mr. Wilson and the other members on the other line in this three-way call discussed getting the defendant a cell phone inside the jail. Just 2 weeks ago, I believe on August 16th, after having time to review that call, the cell was shaken down and two phones, one attributed to Mr. Wilson, were recovered from his jail cell at Rice Street.
Okay. So full disclosure, Mr. Smith, I felt like I had heard Mr. Wilson's name before. I signed a warrant authorizing the exploitation of the phones. That this is why what you were saying started like, wait a minute, some kind of call, and then a cell was tossed. So I'm aware, and I just didn't know which case that went to. So I'm aware of that situation. I think an iPhone and some kind of blue tech phone were found in the cell that Mr. Wilson was in. He may have had a cellmate, but there were two phones found there, and your office is seeking to find out what's on them.
And out of an abundance of caution, we went ahead and got warrants, although I do not think a warrant was necessary, as I don't believe there's any expectation of privacy in the jail, but we decided best practice, we'll get the warrants. So additionally, Your Honor, on June 9th of 2022, Mr. Wilson made a phone call to an unidentified male. On that jail phone call, he specifically listed two other known and identified gang members inside PDE, and he said to that individual that he believed that those people were snitching, and he specifically in there asked for the paperwork. It is my understanding, having done this for years now, that paperwork refers to police work or any sort of government documentation of an individual who is listed as a witness or said to be speaking out against a particular person or organization, because these types of organizations, they do require some sort of proof before they take internal action against others. So that is what I believe that to be. There was also another conversation between jail call between known gang members, for which another individual, I'm not going to name him, who is a known member of his gang, they refer to him specifically as being held on the fifth floor at Rice Street, and said that he was being harassed by other gang members, and because of that harassment, quit claiming the gang, quit claiming PDE. That discussion was then that it was over for him, and Mr. Wilson's direct response was, "I'll no longer save him." Now, my understanding of that is that he is no longer receiving the protection of the gang and is also subject to potential violence for his no longer claiming membership of PDE, who also refers to themselves as 4L or for life 4L gang. Again, Your Honor, I do want to touch on drill music. That is, it is a form of rap, kind of an extension of trap music. It is very violent. There is a debate between Chicago rappers and Atlanta rappers as to where it has started. And that debate of where drill music has started has actually spilled into violence in the streets of Atlanta when many of these Chicago rappers have come to Atlanta to record. Mr. Wilson's Instagram itself, he posts many things. I know that it was said today that going forward, his Instagram account will be run by the record label, but in the past, based on direct messages and such, it is apparent that Mr. Wilson himself was running it. He posts pictures with guns and claiming that this gang is 4L. Anyone gone against it is going to die in this shit. I'll leave out some of the other language. So, Your Honor, as it is right now, the state feels that, one, there is a strong case against the defendant, which the defense needs time to go through the actual evidence. But that combined strong case, placing him in the car behind the victim as he was shot, is a strong incentive to flee. Additionally, as a gang member and based off of the messages obtained from both the cell phone he was arrested with and video calls and jail calls from jail, is a threat to intimidate witnesses. He already has some sort of influence over powerful people just to get a phone into the jail. If he were out on the streets, that influence would be that much stronger. I'm sure RCA wants him out if he's worth millions, but I can give you millions of reasons they want him out, and what their reasons for having him out are strictly monetary and for their own gain. They don't care about Mr. Wilson. They care about their own gain. So I don't think that goes to any sort of Ayala factor or reason to let him out. And in fact, you picked up on it as quick as I did. I would have said it that, rap music translates to violence, and Biggie Smalls was a terrible example of.
So I didn't say rap music translates to violence. There's nothing that I said. Peculiar example that he selected as someone whose life and lyrics seem to collide in a fatal way. That was my point.
That is
May I say something?
It's in general. It is not rap in general, but violent lyrics can translate into violent endings. Point in case. And I think that is apparent in this case as well. Rather, I think I'm asking you to deny bond as a threat to reoffend. He has committed felony offenses, whether he was a juvenile or a adult. A threat to flee based on the bench warrant status, as well as a strong case against him, and an absolute threat to witnesses and the community at large, based off what has been recovered. And for those reasons, Your Honor, we ask that you deny bond. Briefly, I spoke with the family last night.
Give me the last name of the deceased so I can be referring to him beyond just the deceased.
Yes, I was going to, Scott.
Mr. Scott.
And I believe, so there was some confusion as to whether the bond hearing would have been today, with communicating that from my office to the family.
Okay.
So they weren't planning on being present for the plea and arraignment, but I did speak with the father last night.
Well, let me just ask, there was someone named Rondre who was making noise. I moved Rondre into the waiting room. If Rondre is with Mr. Scott, I'll pull him out. Is there anyone else on the call who can hear me, who is here on behalf of Mr. Scott or his family? Okay.
Okay. I wanted to make sure they were going to try to be here if they could, but they just wanted me to relay that they are adamantly opposed to bond. They feel that this was a senseless killing, and it was a miscommunication of scheduling between my office and them as to why they're not here. It has nothing to do with them not being supportive of their son's case as it tracks through the system.
What can you share with me with some level of confidence, as opposed to speculation, as to if and when the case would be reindicted?
So I have learned that if it's not reindicted Friday,
as in day after tomorrow,
I'm still structuring it. It will be September 12th, because that's going to be the next day that this new grand jury coming in will actually be available.
Okay. So it's either the 2nd or the 12th.
That's correct.
Any reason it wouldn't be the 12th that you control?
If it is, it would be it would be a shock to me, nothing that I control.
Would it be something you could relay to Mr. Smith, because he will be tracking, understandably, where this is going next?
If there is some sort of delay, I will tell him the reason why. And
yeah, I mean, the reason why may be something you can't share, but you can keep Mr. Smith apprised.
I will.
Because I'm going to assume that come the 2nd, or at the latest the 12th, there'll be a reindictment. It'll get assigned somewhere else initially. It'll very quickly get bounced to me. And then we can pick up where we left off in terms of, at a minimum, getting discovery to Mr. Smith, and he's moving forward with motions and whatnot.
Understood. Yeah,
Okay.
I'll share the updates with the court, Mr. Smith. I'm not, there won't be any hide the ball.
Okay, and that wasn't the point. I just wanted to make sure that we would know promptly when something changes.
So,
okay. All right.
Excuse me.
Yes, Mr. Wilson, why don't you wait for Mr. Smith to come back to the podium? And then if there's something that you wanted to add, maybe you can. Mr. Smith may not want you to add a whole lot, but it is certainly Mr. Smith's turn to say anything he wants in response. I got a couple questions for him, and we'll wrap it up.
Thank you, Judge. Judge, I don't want to proceed on a demand in this case. But at the same time, as we heard earlier today, 1,000 days in custody on a co-defendant case. And I know it was transferred from Judge Newkirk, who's no longer handling criminal. He might be retired. I don't know that.
No, he's still here. He's in the family division, but that actually wasn't a Newkirk case. That was a Downs and then Reeder but the issue is one that could recur here if a co-defendant gets not the public defender, gets the conflict defender or beyond. We have had no luck. And so it is a very real concern. And it is a reason for a defendant, whether it's retained or appointed counsel, would say, you're going to have to decouple me from this situation because the system is failing us and we aren't getting those conflict attorneys, whether it's Metro conflict or C3 and beyond. And
yeah,
that's an issue.
I appreciate the court saying that. My oldest client awaiting trial in a murder case is 4 years right now here in Fulton. It's the longest I've ever had a client wait. Is it a co-defendant situation or it's a judge issue? It's a co-defendant situation. Okay. When I draft the demand, the 171 demand, it unnerves me because I don't want to do it. You're going blind. You could call me in, I think, we may say 10 days or 7 days. That won't happen here, but you're right. It accelerates things in a way that's not always advantageous to your client. Yeah, and they also say, right, in the constitutional speedy trial case law, it's always advantageous to the defendant to wait, and I believe that. Memories fade and cases potentially get better and usually do. But at the same time, I don't want him to sit and linger where it's a defensible case. As you heard, one gun was fired. Yep. I proffer that, the state didn't. And then multiple people in the backseat are identified as the state as having guns on video. I did know about the text message Kara Convery before she left that told me that my client apparently could not bring guns into the venue. that you were being wanted down, and my client has been identified as potentially sending a text saying, "I'll hold the guns for you." I don't know how you can spin that. I think you could spin it both ways. One of the special conditions I am going to be asking the court to issue is a Fourth Amendment waiver going forward on his home. He's under pretrial release supervision 3 if the court believes what I'm asking for the court to do. I was also aware of a juvenile record. I didn't bring it up because I did not know that juvenile records were considered by the court as relevant, but if they are.
It depends how old the defendant is. It is chronologically relevant if someone is 20 years old and it happened 2-3 years ago. If your client were 50, why bring that up? But it's a data point, but I appreciate that it is processed in a very different way. I only have one question about it. Mr. Hiles mentioned that there was a county change, and you had made it sound like Mr. Wilson had a fairly stable address. And so do you have any insight as to why the supervision or whatever it would be called would have shifted out of Fulton County? And if so, where would it have gone?
I don't think it was shifted out of Fulton County. I think it was shifted to Fulton County, if I'm not mistaken.
It was a juvenile case that was not in Fulton and then came here?
I don't have that information.
Okay.
I mean, that's under seal. I'd have to unseal it.
Okay. It's not a huge deal. I just was curious.
But I know, I'm sorry. I don't mean to interrupt.
Go ahead.
But I do know, Judge, that in that case, it was a stolen car in which the victim had come to court in support of my client at some point, is my understanding.
Okay. What about the supposed bench warrant in Clayton County?
So I was looking it up as we were sitting here. It does appear that there was a motion to set aside or a set aside potentially on their equivalent of our Odyssey system. But I filed an entry of appearance as soon as I was hired by Mr. Wilson and was able to arrange that deal. So the bench warrant will be recalled in Stanter once he answers the plea.
But why would he have a bench warrant? He's someone who shows up all the time.
That's a great question. And the answer is, I don't know that he has a bench warrant, number one. Number two, I do see what appears to be a set aside on the filings, but I don't know that he has a bench warrant on the traffic violations.
Okay.
So I don't, without certified copies, without having seen the record, but Ms. Thomas didn't raise it when I addressed it with her and via email. And she obviously made me a recommendation that, especially for a tough prosecutor, supports the idea that the case was not as serious as the 7 allegations in the accusation.
There are lots of reasons why it could have been resolved that way. Social media. It sounds like today, Mr. Wilson doesn't manage his social media, which is good to hear, since it would mean he has devices he shouldn't have if he is. And it sounded like Mr. Pitts was saying, nah, there's a team that does that for him. Yeah. Do you have any insight as to when things transition to RCA managing the social media of Mr. Wilson versus he's got his own? There are references to Instagram, and I might be shocked, but I don't move in some of those circles if Mr. Wilson didn't have his own. This is the real baby drill. And then there's RCAs where, you know, things are photoshopped in and everyone's in soft focus and they're making their money selling their albums. Are you saying that for some time, and if so, how much time is it, that Mr. Wilson actually has had zero control over what his social media presence is?
Approximately 4 months. And the person that has been in control of it is online with us as well.
Okay. And that would be it. I'm going to date myself. That's Instagram, that's Facebook, that's whatever people use, TikTok, all those things would be not Mr. Wilson. He doesn't have a way. If he got a new set of kicks he wants to show the world, he can't unless his handlers say, we want to show you with those new Jordans.
Correct.
Okay. But he's been in custody for how long?
For over approximately 4 months.
Oh, okay. So there's almost 1-to-1 overlap up until he was arrested while you were interacting with the police trying to sort things out. He managed his social media, but after he went into custody, then it's been managed by RCA handlers.
Correct.
Oh, okay. Well, that makes much more sense. Okay.
And that's going to continue going forward. And he's not going to sign up for any new social media accounts. And he doesn't have any personal other than what
has been taken over by RCA. Okay. But a semi-bright line one could draw is social media pre-arrest on this case. That's Mr. Wilson. Social media post-arrest, that's RCA.
Well, I can only tell you that I know that RCA took it over approximately 4 months ago.
Okay.
As far
I
as
don't know about the time he was arrested. It's not 8 months ago or 2 years ago, so that if Mr. Hile says, look at this Instagram post and he's got 2 AKs and one of them is actually firing bullets, and that's 10 months ago. I'm making this all up. That's not RCA as far as you understand.
That's not RCA. And there is, I've looked at his social media. I don't see anybody firing any guns.
I didn't say there was, but just if one of the things Mr. Hiles was relying on was social media presence. He didn't go into a lot of detail. You don't have it yet, so it's appropriate. He didn't go too deep. But if he's referring to things that Mr. Wilson is allegedly saying or doing or posting, and it predates his arrest in this case, it is more likely social media activity that Mr. Wilson engaged in rather than someone at RCA saying this might sell some more albums if we had a picture of you holding a replica firearm.
Oh, thank you for bringing that up. I think that the whole purpose behind the social media postings in the last year has been geared towards selling songs.
Okay.
That was a roundabout way to answer your question, but also put in my little feelings about rap music and how potentially it can be misconstrued, art versus crimes and so forth.
Right.
I just had this conversation 2 weeks ago with Congressman Johnson, Hank Johnson, in person, and he's petitioned or he's presented proposed legislation where government should not be able to use art to be able to establish crimes.
It is front and center in our culture right now. Just down the end of the hallway with Judge Glanville. That's where the big one is.
Yeah, for sure.
Okay, I appreciate that.
Yeah.
All right.
And I'm available for any other questions that the court might have. I know my client wanted to say something, but I might have addressed what he had to say. As far as the cell phones that were found in his cell, I don't think there was anything inculpatory on what they're claiming that they found. Otherwise, they would have brought it up.
Beyond there being cell phones in his cell.
Beyond there being 2 cell phones amongst 2 roommates. That's
okay.
Correct.
All right. Mr. Wilson, I want to make sure if there was something you wanted to add that was not you talking about your case, because that's what you need to not do right now. Was there something that you wanted to add that Mr. Smith didn't? Or do you feel like he's covered it for you? He looks frozen right now. Mr. Wilson, your screen froze up for a minute. Were you able to hear what I just asked?
Yeah, I heard you, sir.
Okay, you feel like Mr. Smith has covered it for you?
Yes, sir. I was saying they didn't find 2 cell phones in my cell. They found 2 cell phones inside of the dorm.
Inside of what?
The dorm.
The dorm.
The dorm. Okay.
It was one cell phone in a cell, and there was another cell phone in another cell. It wasn't both inside one cell.
Okay. Point well taken. Appreciate you clarifying that. All right. At this point, Mr. Wilson, I'm not going to set a bond, but what I do want to have happen is Mr. Hiles to get to Mr. Smith the discovery as promptly as he can, independent of whether there's going to be a superseding indictment, because I want Mr. Smith a chance to go through the discovery, in particular jail calls, et cetera, so that if we should revisit this, we'll do it sooner rather than later. I have several concerns. The primary one is the risk of improperly influencing witnesses. And second, so I'm going to finish talking, and then if you've got any questions, Mr. Wilson, you can ask your questions. But my primary concern is I think about the Ayala factors, none of which is strength of case, but one of which is the ability of potential witnesses to go about their business, uninfluenced and unharassed by folks associated with anyone on the defense side. I'm concerned about that. But much of my concern arises from the way the state has processed, interpreted phone calls, video calls, et cetera. I want Mr. Smith to have a chance to review those himself, because he may say, Judge, we should reconvene. You ought to actually listen to these, or there's a different way to interpret these, such that we don't need to worry, or I don't need to worry about Mr. Wilson either directly or, far more likely, indirectly seeking to influence witnesses who are associated with this case, know something about this case. It is a risk that arises in cases like this, where there is an allegation of an association of people. Some might call it a gang, some might call it a music label, some might say they overlap. They seem to overlap in this case, but it is an all too frequent problem that someone is initially willing to talk to law enforcement about what happened, and then there's a phone call or a text or an Instagram post, and then all of a sudden that person stops talking, can't be found, has moved to Chicago or who knows what. And I want to avoid that happening in this case. And I have sufficient reason at this point to believe that it has already begun to happen, that I'm going to deny bond. I'm less concerned about the prominent Ayala factor, risk of flight. Mr. Wilson benefits from very, very strong family support. This is one of the more stable family situations that I get to hear about, and we ought to celebrate that. I do believe that Mr. Wilson's mother and sister would do their best to keep track of Mr. Wilson, but there's only so much they can do. I appreciate that Mr. Smith said no cell phone, things like that, but in this day and age, it is impossible to build a cocoon around someone that would keep them from communicating with others if they are bound and determined to do that. And my concern is that those communications would result in improper interference with the state's movement forward with its case and working with its witnesses. I appreciate RCA's interest in having their asset back and working. That weighs with me in no manner whatsoever. Mr. Wilson could have been flipping burgers at Burger King and they would want him back as well because he's a good burger flipper. That's just not something that I weigh here. RCA is going to need to find someone else in their stable to make them millions. But for right now, that's not going to be Mr. Wilson. Mr. Smith, most of all, I invite you to revisit this. And I mean that. You are not being overly aggressive on behalf of your client if after you have digested some of this discovery, you say, we need to talk again, because here are 3 more reasons why you need to not worry, Judge, about Mr. Wilson and his associates influencing witnesses in this case. That's my primary concern. And so as you're thinking about ways to address that after you process the discovery, we should reconvene. But right now, I don't see a way. I mean, frankly, Mr. Wilson being where he is doesn't prevent him from communicating with others. Witness the cell phones. But I believe that if he were out, even under the substantive and meaningful restrictions that you've identified, we would be amplifying Mr. Wilson's ability to do that, despite the folks who are present in his life, the substitute father figure, the actual mother, the sisters, et cetera. Those are folks who care about Mr. Wilson and were present in his life when he wound up in this scenario to begin with, much to their chagrin. So I'm going to maintain the status quo. The other thing that I would consider that would be a changed circumstance beyond addressing this concern about influencing witnesses would be if we run into a pattern of delay that is occasioned by, we now have multiple defendants and we cannot get a lawyer for that third defendant. We'll get a lawyer for the second defendant because the public defender should be able to take one if they can't hire their own. But if we get stuck in a situation where there's a third defendant whose case has stalled and the state is not interested in severing, then we will need to start talking about bond again for those who are waiting to move forward solely because our criminal justice system can't provide constitutionally entitled representation to the third or fourth or fifth defendant. Mr. Smith, any questions about what I just said, Mr. Wilson's situation, so that you know how best to move forward?
No, but I do have a question about the scheduling order.
Yes.
So demand.
Has it already gone out or?
No, when do you suspect it will go out? And how do you want me to handle the list of witnesses? Clearly, there's a state witness that is unknown at this point, that is the driver of the vehicle. I want to get his information. He's not listed as a victim in the case, but I want to get his information. I want to interview him.
Okay.
How can the court assist me in acquiring that information?
So a couple things. The scheduling order, your first question, will go out soon. It may be that Ms. Nelson was just waiting for today to happen because it was also arraignment, but as usual, you're ahead and have already filed the waiver. The scheduling order will give Mr. Hiles a deadline to get you discovery. Then there is a later deadline for you to file evidentiary motions. Then there are only 2 days after that. It would be the hearing if there's a motion to suppress or something. There's a status conference, last day for a plea where your client could withdraw his plea if he didn't like his sentence. There's a trial date. So we try to move things quickly. They'll move faster as long as the demand remains in place, even though that clock's not ticking. So we don't get caught short when the clocks can start ticking and all of a sudden everyone files them. So that's the scheduling order question. What I'd ask you to do is first get the discovery, look through it, and then if there is that witness you mentioned, and there are others, we ought to have probably just a teleconference, so you don't even need to come on into court. I don't think your client needs to be involved. If you want him to be, then we'll come to court, but I think it will be a more productive discussion because it's procedural. If it's Mr. Hiles and you and me, Mr. Hiles will be in a better position to speak freely about these are my concerns, and I'll be in a position to say, okay, there still has to be disclosure. How can we do that in a way that accommodates Mr. Smith's right of access? So we'll address that. Get the discovery first, get your arms around that, and then just reach out to Ms. Nelson saying we need to have a teleconference with the judge to talk about witness issues. And that can happen whenever. I always have time before court or after court. So 8:30 to 9 or at the end of the day to manage something like that.
And then the last thing, Judge, I'm not giving up on bond. I'm going to get a copy of the transcript, see what the state had alluded to. I try to take copious notes, but it's not going to be as good as the transcript. So if I get the court reporter's information, I'll order the transcript now, and then I'll compare that once I acquire the videos and audio recordings that they're claiming that my client was harassing or intimidating witnesses. And then I will potentially come back to the court as the court directing me.
That's my invitation. It's not direction, but it's an invitation. That's exactly what you should do. Because I may be overemphasizing this, and some of this is experientially driven. But in cases where we've got allegations like this, you know this just as well as I do, witnesses start disappearing. And then in the end, we learn, well, that's because defendant X, not directly, but through colleagues, made it so that that witness was very, very disinterested in being involved anymore. And I want to try to limit that. All right. He's already waived arraignment. It just may not have hit the docket yet. You e-filed it.
We e-filed it.
Okay. It is being reindicted on the 2nd or the 12th, and they'll be adding some defendants. All right. All right. Thank you.
Have the excuse.
Yes. And family, thank you for being here. I appreciate it very much. All right. Boy, that was long. Here is Malik Henderson. So we have one more. There's someone in Cobb. Who's there from Cobb? Oh, is that Mr. Matthews' client? Mr. Brown?
Matthews is in Judge, in 8A from Judge Barwood, where I'm headed now. He said, please hold for his report. He's going to be pleading his client.
Okay, I see his client. So we'll do that. That's going to probably happen after lunch, but we'll see. But I'd love to take care of Mr. Sexion if he is in 5 South.
I'll be handling that this morning, Your Honor.
Okay. I don't see anyone in 5 South.
He's in 3 South, Judge.
3 South. Oh, he's waving. Thank you, Ms. Livingston.
You're welcome.
3 South. Mr. Sexion, can you hear me?
Yes, sir. I can hear you.
Great. I can hear you now. Good morning. How you doing?
Good morning. How you doing?
I'm okay. Ms. Rivers, have you recovered from the previous bond hearing such that we can do this one?
Yes, Judge, I'm still with you.
All right. Excellent. Well, let's do that. This is 22 SC 182239, State versus Rodriguez Sexion. Am I pronouncing your last name correctly?
Yes, sir.
All right. Mr. Sexion, you're represented by Ms. Wood, who is on leave today, and her supervisor, Ms. Primovic, has agreed to cover the bond hearing. So she's going to be arguing bond for you. You can see her on the screen there. I'll hear from her, and then I'll hear from Ms. Charles, who's the prosecutor handling your case, and I'll let you know what the plan is for you and bond, okay?
Yes, sir.
All right, Ms. Primovic, when you're ready.
Thank you, Your Honor. Your Honor, Mr. Sexton is charged with, as you see, armed robbery, ag assault, home invasion, possession of a firearm, and false imprisonment. He is 20 years old. He is a lifelong Atlanta resident. He'd be living with his grandmother, Joanne, and his sister. They may or may not be in the courtroom. Ms. Woods has spoken.
They're here. There's several folks who've been here for a long time. Thank you for your patience. Just happened to be that Mr. Sexion was the last one on the calendar. Bad luck of the draw. Don't play the lottery today. But there are 4 people in court today for your client.
Oh, that's wonderful. Thank you, Judge.
Yep.
So he'd be living with them. He has no children. He has his GED. He was working at Wendy's for the last 3 years. He's hoping to be able to get his job back if he is released from bond. He has been in jail for around 141 days with no bond. We're looking for a reasonable bond, Your Honor. They do not have a lot of cash, obviously. Whatever stay away conditions you have, no contact. There is a codependent that is in the wind, Your Honor. So it'd be a stay away from the codependent if that person is in the Metro Atlanta area.
Is that do we know, is that male or female? Averiana, sounds female.
Female.
Okay,
Female.
so she is in bench warrant status.
Yes, Your Honor.
Okay.
Stay away from her, an ankle, a county ankle monitor with a curfew, whatever conditions that you would seem fit for this case, Your Honor.
Okay. Ms. We've had a bunch of different Jacksons on the call, but Ms. Jackson from pretrial, are you there?
Good morning, Your Honor.
Good morning. Welcome back.
Thank you.
Do you have any criminal history for Mr. Sexion?
Defendant has 3 cycles. The defendant's last arrest was April the 13th, 2022 in Forest Park, Georgia for theft by shoplifting and obstruction of an officer. There was no disposition for that arrest. The defendant does have 1 misdemeanor conviction that was in 2020 out of Clayton County for giving false information to an officer. Nothing in addition, Your Honor.
Okay, thank you so much. So Ms. Charles, essentially no criminal history for Mr. Sexion, nothing like this, nothing with guns or anything like that. What is the state's view about bond?
Your Honor, in consideration of the nature of the offense that Mr. Sexion is charged with, talking to the victim, the state's position is that you impose no bond and keep him in place pending the disposition of the trial. Our victim, Mr. Dwayne Evans, we spoke to him many times over the course of last week and again yesterday. He is fearful. He absolutely opposes bond because for 2 reasons. One, the co-defendant who was in the wind was the one who initially set up the encounter, knocking on his door, reaching out to him on social media, showing up. When he opened his door, 2 males jumped out with guns and basically, stole his equipment and terrorized him in his apartment.
His equipment as in, was it a recording?
PlayStation, iPhones,
Okay.
and some cash, credit cards, his social security card, that sort of thing.
So Ms. McBurrows would not have been a stranger to the victim in the
Correct.
sense they had been connecting
Friends and
virtually.
connected, yes.
Mr. Section might be a stranger to the victim just because he is allegedly one of the two who then burst in when Ms. McBurrows came knocking.
Yes, Your Honor. And Mr. Evans, he is fearful for his life if the defendant gets out of custody, because during the encounter, when he was sort of begging them to stop, they said, if you call the police, we will come back and we will kill you. And they know where he lives. He still lives in the same apartment. He says, having the gun pointed at his head was the scariest experience of his life. He is fearful that the other person who was not yet been indicted, the other male, and also Mr. McBurrows, who's in the wind, may all reconnect if Mr. Section was to get out and come after him. And he says if Mr. Sections gets out, he's fearful that he would have to buy a gun to then defend himself. And so we take no issues with Mr. Sections, ties to the community or his lack of a criminal history, but we do believe that he poses a significant risk of intimidation of the witness and likely to reoffend, to keep him from coming forwards and to not participate any further in this trial, since the time that Mr. Section is potentially facing is significant. And so we'd ask that you would keep him in place at this time.
So just so you know what happened, Ms. Primovic, someone associated with Mr. Section just had a little bit of an outburst. I need to understand what her connection is, because if that's where Mr. Section would be living, that's a less good development. No, someone from the family is going to explain. Yes, ma'am. Okay.
And so she had another person.
Okay, and that's not with whom Mr. Section would be staying? Okay, got it. All right, and Ms. Primovic, you may not be able to hear that, but your client's sister explained that that was your client's mother who has some mental health issues and reacted in a way that may be consistent with her mental health issues, weren't so consistent with being level-headed about what's happening right now. And I just want to make sure that's not where your client would be, and it's not. It would be with grandmother, who was very adamant that that's a different situation, or sister, who was the one who just provided that explanation.
Thank you, Judge.
Oh, there are 2 grandmothers? There are a lot of grandmothers here. Okay, all right. Was there anything you wanted to say in response, Ms. Primovic?
Yes, Your Honor. It seems the state's only hurdle that they have issues with is the risk of intimidating witnesses. In reality, Your Honor, if the other 2 unindicted co-conspirators or whatever are out there and they haven't had any trouble yet, I don't see, I think it's a stretch that if Ms. Section gets out, that would all change. If we could put him on an ankle monitor that can, with, curfew, so that he can work at Wendy's, maybe, a 7 a.m. to 7 p.m. curfew, and it knows where he is. I think an ankle monitor would take care of that. I think him reporting to pretrial services once a week would also take care of that. The fear of new charges and the fear of losing his bond and getting sent back to Rice Street is also a deterrent for him to do something as silly as to intimidate these witnesses. But it hasn't been done yet. With the 2 out there, out and about in the world, I think it's a stress to think it would happen if Mr. Section is released from jail.
Okay. Thank you for flagging that. So Mr. Section benefits greatly from being the bond hearing after the one we just had, not only because you all were much more concise, but I'm just going to flag the contrasts. Mr. Section basically has no criminal history. Yeah, there's a shoplifting and a misdemeanor in Clayton County, but nothing that's a crime of violence. No indication that what he's charged with is a hallmark of his. nothing about guns, anything like that. There's no evidence that there has been any effort to contact there's clearly a victim in this case. Whether this is the defendant who was involved with what happened is what the state needs to prove. But there's no evidence that the victim has been contacted, as Ms. Primovic points out, by either of the two people who would be in a position right now to be doing so. And I don't think that would change. That dynamic would change just because Mr. Sexian got out. I do think there is a set of conditions that I could impose that would ensure Mr. Sexian's appearance in court, which is the number one thing I'm supposed to consider. But equally important would be safety of community. And there's nothing to suggest that Mr. Sexian wouldn't abide by the conditions of bond. There are no failures to appear, no bond revocations that have happened in the past. And he does enjoy family support. I think where we're going to run into things is what is a reasonable bond. Right. I'm going to set a bond that is somewhat significant because we're dealing with serious charges. And there is always the concern, and Ms. Charles alluded to it, that, gosh, this is serious. And I really don't have that many ties to the community. I love my family, but I love them from Texas too. I don't have any kids here. And so I'm leaving because I'm not interested in spending the next 10 years without parole because of this armed robbery charge. That's a real concern that we always need to grapple with. But for now, I will set a bond. Ms. Primovic, it may come to pass that we need to have another discussion because the bond that I set is unreachable. That would be demonstrated by Mr. Sexian's family not being able to post it after a certain amount of time. And it's an iterative process, meaning I may have set it too high. I won't know that right away. You'll say, oh, it's too high, but it will be demonstrated because time passes and Mr. Sexian hasn't been able to post it. And that will be proof that it was too high. And there may be reason then to revisit and reduce it, which I'm willing to entertain, especially if this case isn't moving quickly. I have no reason to believe it won't move quickly, but things can come up that slow things down. So what I am going to do is set overall a $50,000 bond. It'll be through the sheriff's 10% program. It will be $10,000 for counts 1 through 3. And plus 5 counts. It'll be $10,000 for each of the 5 counts through the sheriff's 10% program. Should Mr. Sexian be able to post this bond, he will need to wear a county-funded ankle monitor. He will start out with a 24-hour curfew. I'm happy to modify that once it's documented that he's got a job. So if Wendy's will take him back, we need to know what that shift is. And if that shift is from 3 to 11, then his curfew can be modified so he's out of the house from 2:30 to 11:30 so he can get to work and come back. But until someone can show me that he's got the job, then it will be a 24-hour curfew. Ms. Primovic, you'll need to get an address to Ms. Nelson. That is the address where he'll be staying. So that could be grandma, it could be sister. I'll let you work through that, whatever the most productive household will be, where Mr. Wilson can most easily get to work and frankly be in a place where he's going to stay out of the most trouble. So I'll let the family work through that and they can let Ms. Primovic know what that address is. No contact with the victim in this case and no contact with the co-defendant, Ms. McBurrows. Any other conditions, Ms. Charles, in Mr. Sexian's case?
No, I think you've covered everything.
Mr. Sexian, any questions about that?
No, sir.
Okay. Ms. Primovic, anything else?
No, Your Honor. Mr. Sexian, are you living on Ash Street?
Yes, sir. I mean,
Okay.
yes, ma'am. Yes,
Okay,
ma'am.
I will get that. I will get that to Ms. Nelson, Your Honor.
Okay. All right. That's what we're going to do. Thank you, everyone.
Thank you, Your Honor.
Thank you, Your Honor.
And Mr. Sexian's already waived arraignment. This was just bond today.
That is correct, Your Honor.
Okay, good. So his case will keep moving forward. I think that covers everything from this morning's calendar except for Mr. Lloyd's bond hearing. Mr. Melnick is here and Mr. Matthews is here. Let me tell you my schedule. So you're free to go, Mr. Sexian.
I can take aid to my family.
Oh, all right. They're waving back to you. All right. They're all waving.
Thank you. Okay, everybody, happy birthday.
I will. Thank you. Let's just talk schedule for a moment after I mute things. Hello, Ms. Jackson.
Hello, good morning, good afternoon, Your Honor.
What case are you here for?
Sanchez Lloyd, sir.
Okay, we're about to talk about that, all right? All right. There is one more case on the calendar. Michael Colburn. It's a third calendar. All right, so we've got 3 things to do. We have 23 minutes in which to do it. And then I'm back at 1:30. But I have to go at 12:30 for a meeting, and I'll be back at 1:30. Mr. Lloyd was brought over. Don't know why. It was supposed to be virtual, but he's here. We've got someone online, and I believe the young lady back there is for Mr. Lloyd as well. Your client's last name is Brown. No, I'm talking to you, Mr. Matthews.
I'm sorry.
That's okay.
My client is D'Anthony Brown.
Mr. Brown, he is in the booth at Cobb, so we can do that. I think that's a plea.
No, Your Honor, it's going to be a bond motion.
Okay, a bond hearing, so we can. Okay, we can do the bond hearing. And we also have a revocation with Mr. Colburn. I don't know who's handling that for the defense.
That's my case, Your Honor.
Okay, so I'm happy to handle one of those things. I don't think we can do more than one before I need to step away. And then at 1:30, we're back in action, and we can start with what we didn't finish this morning. I don't know if you guys want to arm wrestle, draw straws.
Judge, I'm perfectly good with coming back at 1:30. I think I have a sentencing hearing at 3:00 this afternoon over at the federal building. So
I'm going to take you up on your offer. 1:30, you'll be the first thing we do. We'll do Mr. Brown. So Ms. Livingston, if you could just let folks know that we'll need Mr. Brown in Cobb Booth 1 at 1:30.
Okay, I sure will.
Thank you. That gets us then down to Mr. Colburn and Mr. Lloyd.
Who's handling Mr. Colburn's case?
Ms. Feely. Ms. Feely, do you need to be back for our 1:30 anyway?
I do not.
You do not. Do you have anything on our 1:30?
I don't.
Okay.
Well, so Mr. Lloyd is on for status for 1:30, but it's the same case.
Oh, okay. So then you were going to be here at 1:30 anyway.
Well, I was planning on handling both this morning.
Okay.
well, in that event, Judge, if you can do one of the others.
Well, no, I have 3. So you are graciously coming back at 1:30. Thank you so much. Is the revocation one that is negotiated or not?
It's not negotiated, Your Honor, just because we haven't had a chance to really speak about it. However, I don't think it'll be long at all.
Okay. And how about Mr. Lloyd's bond hearing?
Judge, I can get it in before 12:30.
Well, then let's just do both and I'll just be a little late. Okay. Let's start with Mr. Colburn. Mr. Colburn, I'm going to activate your booth in just a minute. Mr. Colburn, can you hear me?
Yes, sir.
Great. You are on the calendar for a probation revocation. We're going to get on the record. Let me find your warrant. There it is. All right, Ms. Rivers, are you ready?
Yes.
Okay. This is supplemental jail Zoom calendar. Michael Colburn, 11 SC 103136. And I signed a probation warrant in November of last year. The allegation is that in May of last year, you committed the offense of escape. I want to hear about that. And then in August, you had a disorderly conduct and simple battery in Upson County, Georgia. So a new felony and 2 new misdemeanors. Ms. Feely, is Mr. Colburn stipulating or admitting to these, or is he contesting these?
It's slightly more complicated than that, Your Honor. If I could elaborate on the escape situation.
Sure.
So the escape, it says in the petition that that was from May 23rd of last year, but that was actually just when the warrant was served on him. That was an offense from March the 2nd of 2020, which was before he was on probation. So he was in a transitional center and returned late. So there are two reasons why we don't think the court should address that today. One, it's not a probation violation because he was not on probation yet.
Okay.
Two, he's already been punished for that. So he was sent back to prison based on that. I don't know if it was considered a parole violation. I believe it probably was. So he went back into Department of Corrections custody when he was released a second time in May of 2021. That's when that warrant actually hit for the escape.
Okay. Got it. And then what about the misdemeanors in Upson County?
Those we would admit for probation purposes.
All right. Ms. Charles, any reason to disagree with Ms. Feely about the escape situation?
No, Your Honor. Based on what she said, I don't have any reason to disagree. However, while he was gone, he did a number of acts, which gives me pause, including allegedly assaulting his sister, drinking, doing drugs, and he.
But where's all this coming from? That's not in the petition.
I was looking at the pending CP case at the warrants, and it alleges what he did while he didn't come back when he was supposed to from a transitional center.
Oh, Mr. Colburn has an open case here?
Yes, Your Honor. It is, let me get for you. It is 21 CP 200098.
Did you know that, Ms. Feely?
No, Your Honor, we were only prepared to address the allegations in the petition.
You don't, I hear you. And you don't need to address other things formally in the sense that, that Mr. Colburn isn't before me for those other things. I'm more interested in the CP if he's got no bond in that or what's going on with that. He has a bond though. So, okay. It's the escape. This isn't making sense. If he went to maybe he got his parole revoked, but he also now has this unindicted escape charge, which is what we're talking about. And it is in fact from March 2, 2020. And then it's sort of stalled out here. In May of last year, there was some activity and that's it.
Yes, Your Honor. And I just looked up that CP number and that comes back to the escape. I didn't see anything to do with drugs or violence.
If you look in the affidavit for arrest, it identifies the things he's alleged to have done while gone, because when officers came to the scene, he fled. And it seems to say that, he deliberately fled and it wasn't just an oversight that he didn't come back within the time that he was supposed to. It was a deliberate act.
But all that stuff that happened before he was on probation in this case. But that doesn't make sense. How the numbers? This is a 2011 case. How is he not on probation? And he's been on probation for a decade.
He got a 15-10, Your Honor.
So he was on parole in this case? I mean, he clearly wasn't in. This is not going quickly. I just want to manage your expectations, Mr. Milner.
I can see that it's.
We're going to deal with Mr. Lloyd at 1:30 also, just so you can.
Judge, I will probably just join on Zoom if that's okay.
That works. And ma'am, you are welcome to come back if you want to go get lunch, but we'll do Mr. Lloyd at 1:30. And there's, I think, a Ms. Jackson on the Zoom call. It'll be this same Zoom session, but at 1:30, we'll take up Mr. Lloyd.
Thank you, Judge.
You're welcome. All right, I'm sorry. Let's get oriented on Mr. Colburn. I'm going to ask Ms. Tucson. Ms. Tucson, how much time remains on Mr. Colburn's case?
He has 3 years, 8 months, and 19 days remaining on probation with that case.
And when did his probation in this case start?
It started 2011. 9/15/2011 was the sentence date.
Okay, but that was the sentence date. But what I heard Ms. Feely say is that he was actually sentenced to prison and was in prison for a while. So I'm wondering when.
Correct. I apologize. May 20th, 2021.
All right. So in March of 2020, if Mr. Colburn was escaping from something, this would have been transitional housing from his custodial part of his sentence. He would have been on parole at that time. So this would be a parole violation, not a probation violation.
Correct.
Okay. But in August of 2021, when something happened in Upson County, Mr. Colburn was on probation.
Yes.
Okay. This is fitting together better now. May 23rd, 2021 is, I think, when Mr. Colburn was finally arrested for the alleged escape that occurred in March of 2020 when he was not on probation. He was still not on probation when he had just started probation. That doesn't make any sense either, when he got arrested for the escape. Seems like there's some missing pieces here. Ms. Feely, I'll let you take over now.
Yes, Your Honor. So he was released from prison on May 21st of 2021, and that is when he came directly to Fulton County on the CP escape charge and was able to post bond on May 26th of 2021.
Okay, so he got revoked, his parole got revoked for escaping, and there is still an unindicted Fulton case that reflects the escape that was the basis for the parole revocation.
Right, and the incident date predates his probation starting.
Okay, and he has been sanctioned for the escape, whether it involved him drinking or being rough with a female in his life or whatever it was. DCS, which happens to do parole and probation, has already exacted its penalty or punishment through the parole revocation.
Yes.
Okay. All right. So it seems like, and I'm open, Ms. Charles, if you've got other information, that we ought to focus on the consequences of the stipulated to Upson County misdemeanor arrests.
Yes, I understand. That's right.
I
think we're clear. That's right.
Okay. Mr. Colburn, do you have anything you want to add to that part? We're not done yet. We're just trying to make sure we're starting from the right place.
Yeah, I'd like to clear up a little bit. In 2011, I was sentenced to a 15-10. I did 9 straight years and I went to a transitional center, but at that point, I wasn't on parole. I was still in Department of Correction custody.
Okay.
There was no assault on my sister, and there was.
So don't go into that part. Just help us you've helped us understand the timeline. So you were in a transitional place. It sounds like you left.
Yes, sir. I signed out to go to work and didn't come back on time, and I didn't run. They come and they picked me up. I went back. They sent me straight back to prison. I did 14 more months.
Okay. You did 15 more months because of what we're calling the escape. Is that correct?
You could say that I still had time left on the 10-year sentence at that point.
Mm-hmm.
So when they sent me back, I was serving the remainder of the 10-year sentence. And during the 30-day period when they first sent me back, they took the warrant out for escape. And when I maxed the 10-year sentence out, I came straight to Fulton County Jail.
Got it. Okay. And then you bonded out, and then something happened in Upson County.
Yes, sir.
All right. So, Ms. Feely, what is your recommendation in Mr. Colburn's situation?
Yes, Your Honor. So he has been in jail on this probation warrant since February 28th of this year. So that's 185 days today. Before his arrest on this warrant, he was trying to get back on his feet after basically maxing out a 10-year sentence. He had been doing well. He was working at Bojangles, and then he got a second job also working at Action Tire, changing tires on 18-wheelers. So he wants to continue to do that. He lives locally in Jonesboro. His mom, Clara, I don't think was able to make it today, but she's in support of him as well. So we're just asking the court to consider the 185 days that he served towards this probation warrant.
Okay. Ms. Tucson, are there other open cases for Mr. Colburn at this time?
From what I see, that is the only case that he is actively being supervised on.
Do you have older cases of his that are now closed out?
Yes, there are older cases.
How many?
They are all Fulton County, except for Douglas. There's one Douglas and the rest are Fulton.
How many convictions does he have?
1, 2, 3, 4, 5.
Okay, thank you. Ms. Feely, you may have answered this, but then I got real confused by this timeline. What has happened with the Upson County case?
I believe it's still pending.
Okay, so you may, Mr. Colburn, need to be in Upson County at some point to deal with that.
Oh, yes, sir.
All right. Ms. Charles, what is your recommendation?
Your Honor, based on the clarity we've received, I think 6 months revoked and reinstate is appropriate in this case.
Okay. All right. I do too. Mr. Colburn, I'm going to revoke 6 months. You've already done 6 months, so that means you're going to be released shortly. You'll get credit for the time you served from, what was the date in February?
February 28th, Your Honor.
All right. So you'll get credit for time served from February 28th of this year. My revocation, your revocation from me is 6 months. I'll reinstate the balance of your probation. You'll thus still be under supervision. And I guess if you were living down in Jonesboro, you were reporting in Newton County or whatever county Jonesboro is in, Clayton County, you'll need to keep doing that.
Yes, sir.
Ms. Tucson, do you have an address on record that we can confirm? Or Mr. Colburn, will you be in a different spot when you get out?
No, sir, I'm still going to stay in Jonesboro.
The address I have on file is a Thomaston. Is that on Wren Street? Is that an accurate address?
That's my mom's address.
Is that where you'll be staying?
No, sir, I'll be staying in Jonesboro.
All right, so do you have that address, Ms. Feely?
I can get that address, Your Honor, and get it to the court.
Okay, well, get it to Ms. Tucson. And then that way probation's records will be updated, but you do need to get reporting instructions. So why don't you listen to Ms. Tucson, okay?
Yes, sir.
If you're in Clayton County then?
Yes, ma'am.
Okay, so you'll need to, do you know where DCS office is in Clayton County?
No, I can find out pretty easy though.
I'm gonna read the address to you.
All right.
Okay, it is in Morrow.
Mm-hmm.
And are you ready?
Yes,
Or the attorney could get it. It's 1331 Citizens Parkway, Suite 201 in Morrow, Georgia, 30260.
Okay.
And so just when you are released from custody, make sure you report within 48 hours upon release.
Yes, ma'am.
All right, I think that's it. Anything else, Ms. Charles, for Mr. Colburn?
No, Your Honor.
Ms. Feely?
No, Your Honor. Sorry, it wasn't as quick as I thought it would be.
No, that's all right. This one had a little wrinkle to it. All right, Mr. Colburn, if you are not released by Friday, you should reach out to Ms. Feely. Hopefully by then the paperwork will have flowed through the system. Certainly, on the weekend, it's hard to reach people. But if you wake up Monday morning and you're still at the county jail, reach out to Ms. Feely and we'll fix that, okay? All right. Thanks, everyone. So, Ms. Livingston, I think, well, before I do that, Ms. Nelson, is our afternoon calendar Zoom or in person?
We still, I do believe, may have one person on Zoom, but let's keep, it's the same link.
Okay. All right. I know we're going to have Mr. Brown in booth 1 in Cobb. I just wasn't sure if there was anyone else. We're going to take an hour lunch break. We will start back up at 1:30. At 1:30, we will handle Mr. Brown's bond hearing. but not plea. And then we'll do Mr. Lloyd's bond hearing, and then we'll pick up with our status conferences.
And Judge, may I just quickly ask, was McKeith Riggins handled earlier? I see that's on the add-on jail calendar.
Hold on.
Two and 3. Just one second.
Yes, that was Jacoby Hudson.
Wait, what?
Mr. Riggins, is he asking about Mr. Riggins?
That's our add-on. Yeah, Mr. Hudson, he waived arraignment.
Okay, thank you. I'm sorry.
Okay. All right. Thanks, everyone. See you at 1:30.
Thank you, Judge.
Nice. Right on now.
Well, you got an hour, man. Go make it happen. Thank you. Mr. King.
He's trying to raise on the radio. Yeah. I ain't gonna have. Definitely. He was just trying to get ahead. This one? Yeah, more than I want. And really the issue is freaking 5E. I ain't heard them say they deliberated yet. But and they was only had like 3 witnesses. I know that the defense is kind pretty good. So he probably trying to grab this thing out. They got a verdict when something else. That's probably the fast I've seen. Like, we did one in about 34 minutes. Well, so we going to we have on 20. Well, 15, I think, was one. He got it down to 8. He got it down to 8. Yeah. Hey, did you listen to close on Sunday album? They closed on Sunday album. Hey. Hey, I know you got no way going, boy. I'm on this. Where you at? You right here. Oh, this is. He said what? Oh, you eat. Oh, yeah. And if you're working on that here. Okay. Now we made it. What you gonna do? What you gonna do? 5 minutes, 10 minutes? Straight left. Got close that much. I didn't want to that. And then at night, it's going to be 2 5C. We got Pope on D60. And I got Kilgore should be finishing up over there with that. So that's the only way to go. So once he finish up that, I'm gonna have him go with the slaughter. Then Drake going, still going down. They jumped off for like 15 minutes. Yeah, no. Just sit out here. What terminal you got for me? What's good? What are you all saying? Here you go. You have breakfast. This is drill close up. You know, that's what Kyle used to say. That's what Kyle used to say. Yeah. We used to work later when I got down there. They must have a trial going on with Jake. Even on 9G. Right.
I go down there. You burn my wire or you go down? I like you know that too. I already know you brought him up. Bro. So you know when the judge box to pick out the car. I think you need more training, man. I'm gonna go down now, man. This man want to play. It's all right. You can unlock the door for me. I got you. Appreciate it.
Last thing I need to see is pictures of food right now. Yeah, we were gonna do mine before lunch. And Scott Smith went on every freaking volunteer. Were you here for that?
No.
Oh, Jesus Christ.
I think they're recorded, or at least I think the audio is.
Well, needless to say, it took a long time. I think it took 2 hours.
Oh, wow.
What are the charges? Murder. As a gang rap case. Yeah. So anyway, the reason I'm setting up here is because he said we were going to do mine right at 1:30, just in case you're wondering. It's actually one of your old cases.
I'm Mario, by the way.
Yeah, right. I'm John Melnick. Yeah. I've seen you. It's Sanchez Lloyd.
Ah, okay.
Yeah.
Do you have any, I feel like there was some question over whether we had a document or something that.
Well, so the discovery that you sent me had like all the written stuff, the warrants, the incident report. But I don't think there was a GCIC included in it.
Yeah.
But I got the GCIC this morning.
Were there medical records or something? Because there was some question of whether.
There weren't any medical records in what you provided to me, and I would tend to doubt that there were any medical records.
I don't mean for the alleged victim. I mean for your client. 'Cause I think prior attorney had been trying to obtain
mental
medical
health
I think
records,
so,
maybe. Yeah,
because I don't know that he had actually received anything. I had contacted the prior attorney to say, look, there's a new attorney taking over.
Gotcha.
So,
Well, the mental health records might actually be very helpful in getting the case resolved, candidly. He's been in for like 9 months, you know, and he hasn't even had a bond hearing. And I know you weren't the first attorney on the case.
Did I file one?
I'll be honest with you, I don't think you did. Because when I got into it, I filed one. That was in like late July, early August.
Because I actually I remember going to jail on Sunday morning to see that.
You couldn't locate him?
No, Odyssey wasn't working, they said.
That's unreal. Hey, how are y'all?
Right now.
You have Lloyd up?
Lloyd?
Yeah.
That left ball on side. Back on.
Hey, man. So they ended up not doing it all.
They didn't do it.
I won't wait. You know what took so long.
Yeah, well, I.
You got
was in and out.
Yeah.
Is he self-defense?
No. Yeah.
I'm not sure yet.
And game interaction.
Game.
Right. Yeah.
How many witnesses?
Like 3 or 4.
3 or 4 witnesses.
Yeah, excuse me.
It was like that. Yeah, that burned sometimes.
Yeah.
He denied it. On what ground?
Mostly because there were allegations of threats from the jail. Yeah.
Jail calls?
Yeah. The kid's been real active on his jail calls. Apparently, according to Reeves.
Yeah, that hurts.
It still astounds me.
When they say, listen,
yeah, I agree. Right.
Most of the time.
Yeah. Right. And I will tell you, so what they do, it's actually really bothers me, is they'll send you this whatever it is, with like 1 million jail calls, right? I'm not supposed to figure out
which one it is.
I mean, do you used to kind of listen to this?
No.
way.
Basically, you know, I usually call the DA.
Tell me which one it is.
Which one it is.
Tell me what's going on. If you're using the jail calls, just tell me which one it is. You gotta depend on them to be honest with you.
That's right.
There's no way that I'm gonna sit there and listen to 500.
That's how we do it.
Yeah.
Listening to that. I want to hear about, you know, did today.
Right.
You know, all the crap.
But so I will not take long, I promise you.
Okay.
Maybe 20, maybe 30 minutes at the end. I do have a vocal victim, so that's.
Well, you know.
I know you got your sentence.
Yeah, I got a sentence. So.
Yeah.
We'll get going.
I had an interesting scenario involving a guy in federal court. The guy's last name is Pitts.
Okay.
And after I got hired on his case, I got hired on a murder case in Caddo County.
Yeah.
One of the victims in that case, last name is Flag. I had no idea that Flag, yeah, I had no idea that they were brothers. Yeah. So I honestly did not even know it. Because nobody mentioned to me that his brother had been shot. I didn't know it until I started trying to murder. Yeah.
Wow. That's how you learn that your federal case.
Yeah, that I had a conflict with my guy. I mean, potential conflict. It's not really a conflict. It's not like my federal guy knew anything about. But then then the federal guy got pissed at me because I was representing the guy that was charged with murdering his brother. So he asked me to step off this case, which I did. Yeah.
Okay.
Yeah.
Well, I guess. Okay.
Yeah.
Understanding. But you didn't know.
I had no idea. Right.
It's only after you start trying to murder cases you learn that the victim is the brother of your federal defendant. Yeah. But couldn't.
Yeah. Have you noticed? I think they're picking up a lot of gun cases in the federal system right now.
All right, this is the one I've got.
Yeah.
It's a big thing.
Yeah. I've got 2 right now.
Yeah.
Yeah. I mean, it's nothing but,
It's just a gun.
Yeah.
It was
I get what they're. Yeah. Because everybody's going to get 3 to 5 years, basically. You know?
Yeah. It's my here.
Yeah.
In state court.
No, over there. Yeah.
Yeah, the minimum is 5.
Right. You can get them to deviate if you got a bad record. Yeah. Right.
Yeah, great.
On yours? The one that I was just telling you about, where my client's last name was Hicks.
Right.
They were asking for
10 on the gun.
2 different gun cases, like 2 completely different ones.
So they're asking 10.
Yeah, his record was Yeah. I mean,
My
we
guy's
had-
right. Yeah. It's pretty good. He's got
Yeah.
24.
Oh.
No, what's wrong with that?
You got nothing to say. Who's the judge?
Michael Brown. Really? Yeah.
The former law school classmate.
Michael Brown.
Yeah, he and I graduated from law school the same year.
Which school?
UGA. Yeah.
How old are you?
I'm 54. He and I are the same age, yeah.
So he can't, so you were, so you were Georgia in 91. So you were there with.
I was, yeah, but it was my law school classmate. Yeah.
Caesar Mitchell.
Yes, Caesar Mitchell. Yeah, I think he might have been a year behind me.
Okay. Who else was there around that time? Anthony.
Yep. Yeah, he was a year ahead of me, I think. Yeah.
Kel, Pete, their brothers.
I don't know Cal, but yeah, I know him.
The Supreme Court Justice, was he?
He was maybe 2 years ahead of me. Yeah, but yeah, he was there. Yeah, Howard Milton.
You were Franklin Thomas?
Yeah.
You remember Franklin Thomas?
Yep.
Ben Richardson, who's a short black guy. He's currently the either solicitor or district attorney somewhere in the middle of South Carolina.
I know him. Yeah. But yeah, Woody and I were good friends.
Yeah.
Yeah.
So, can you tell me about Michael Brown?
He's nowhere near as conservative as you would think he is, given he was a Trump attorney. But he also is probably not going to be one to deviate much from the guidelines. Okay. I mean, of course, he's got all the job security he could ever possibly want. But yeah, he's not some like crazy lunatic right wing guy. He was at least he wasn't in law school. And like he and I didn't walk in the same circles, you know, either in law school or we knew each other to talk to one another. Law school's pretty close knit. He was super smart. Graduated like number 2 in our class. Yeah, he was really smart. Went to work for King & Spalding, I think, or Tolbert. Then he went to the U.S. Attorney's Office. I think he was there at the same time that McBurney was. And then went back to Alstenburg. I think went from Alstenburg to Trump. Yeah. Right. Yeah. But you know, Trump also appointed J.P. Boulay.
That's true.
And
I love J.P.
Boulay is great. Yeah. I thought he was really good. I had a case in front of Boulay.
Oh, you had?
Yeah.
Okay. He was good work with.
He was. I mean, he went at the very bottom of the sentencing guideline, like the lowest number he could impose on the sentence. Yeah. Right. And it was the case. I was completely screwed.
Okay.
Yeah.
Yeah.
You ever actually tried a criminal case in federal court? I tried a criminal case and a civil case. Two civil cases in federal court.
How criminal federal trial?
You better hope you have
Comparison to.
You better hope you have a really good defense, because they do take that, you know, non-acceptance of responsibility. That's a real thing over there. Yeah, that's what I told my guy. This guy that I was if you get convicted, yeah, it definitely goes.
For that.
I went to trial with a case in front of Richard Story, who I don't think is on the bench anymore. He might have retired or taken senior status. Yeah, and I thought he was a really nice guy. He treated me well during the whole trial. He was and gave us a fair trial. But boy, did he hammer in that. It was a drug case. I didn't have terrible history. Something like 230 months or something like that. It was in 230 months.
Yeah, it's better to have a really strong.
Yeah. We had an equal access defense, but they had my client on recording talking about stuff, and so he really is. Basically, he's a runner, erratic, you know. Yeah, right. He didn't want to take anything off.
Yeah.
Okay, perfect. I just like that.
Running into that. You don't need the problems with the
Management,
Yeah, I mean,
Yeah.
coaches don't want to take.
they don't want to do this job.
Yeah, right. Yeah, it was real bad.
Welcome, welcome. Nice to see you.
All right, welcome back, everyone. We need to handle our two carryovers from this morning. We've got Mr. Lloyd, we need to do his bond hearing and his arraignment. And then for some reason, Mr. Brown is not a plea. We were told we better get him on the calendar today for a plea. And instead we got him on the calendar today for a bond hearing. Okay, all right.
Judge, we were trying to get to a resolution for plea. However, the prosecution, they look further and they're just not.
They're not there yet.
That's right.
Okay, you're gonna work on them though.
I'm gonna do my very best.
All right, can we bring Mr. Lloyd? Do you have enough folks to bring Mr. Lloyd out? Okay. So we'll do Lloyd, then we'll do Brown, and then we will pick up with our afternoon calendar, which is some status conferences and maybe a plea, Mr. Grossman?
We had a negotiated plea.
Oh, well, you worked your magic.
Things worked out.
Okay,
Thank you.
you're welcome. Mr. Cladis, you're back. Good. So I think our only, I won't make that declaration about whether any of the things this afternoon are virtual.
Did you want me at the
podium? Please, let's make sure we've got everyone we need. Ms. Rivers, are you ready to go?
Yes, Judge, I'm ready to go.
Great, welcome back. We are working through positions 6 and 7 on our morning Zoom calendar. Mr. Lloyd, who is in court with his attorney, Mr. Melnick. Do you handle both his cases?
So, Judge, I had not filed an entry on the 22 indictment yet, but we're actually part of that indictment is going to be part of what I talk about. So why don't I just get into everything and that'll make more sense. But I will file an entry on that case.
Okay, so you intend
I intend to file an entry. Yes.
Okay, because they're both 22.
I'm sorry, the one that hasn't been arraigned yet.
Excellent. And I brought it up in part because wondering if you'd be talking about it, but also I'd love to handle the arraignment / waiver of arraignment and then talk about bond. So, but I guess you need to file an entry first. Maybe you can file that entry and you can handle a waiver of arraignment so we can get that case caught up to the other case. Wait, there's 3 cases.
Are there 3 cases?
Well, I have yet another case number that, let's see if it is, yes. Nope, it's the same number. It just has a typo in one place. So the bond hearing is actually on a case for which we were going to have a status conference.
That's correct, Judge.
So that's one where in theory it ought to be trial ready. And if it's not, we'll talk about it. I don't expect the same response for the other case, but we'll want the newer case ending in 917 to catch up eventually to the case ending in 130. So let's start with bond, then we can talk status and we'll figure out where we're going.
Thank you, Judge. We ready?
I am.
Okay. Judge, Mr. Lloyd is 34 years of age. He will be 35 in September. When he is released from custody, he will be living in Forest Park with his mother, Miss Kathy Holliday, who you've seen here, who's here all morning with her hand raised and back.
Ms. Holliday has been here many times, even days when Mr. Lloyd wasn't here.
Oh, well, you can see that she is certainly diligent in making sure that Mr. Lloyd will appear in court if he is granted a bond. So, Your Honor, Mr. Lloyd unfortunately was not employed prior to his arrest. But the reason he wasn't employed is because he was awarded Social Security disability benefits in 2016, resulting from a number of physical and psychiatric diagnoses. And most specifically, he suffers from bipolar disorder and has been receiving treatment for that for a number of years since. I believe that is our victim in this case, Ms. Jackson, on the call. So anyway, Judge, he wasn't employed, but he was receiving Social Security disability benefits. Judge, I know I think one of the biggest points that needs to be made at a bond hearing is the defendant's prior criminal history. Count 3 of this indictment alleges that Mr. Lloyd was a convicted felon in possession of a firearm under indictment number 12 SC 112339. I have discussed this with Ms. Charles, and although the state has not actually committed at this time to dismissing that count, Mr. Lloyd was sentenced on February the 25th of 2013 in that indictment to a lesser offense to robbery by force, and was granted 7 years first offender probation. And although there was a revocation that took place, he was in custody between October 15th, 2019 and November the 25th of 2019. I looked at the revocation order and it did not revoke his first offender.
So your argument would be at the appropriate time, not a convicted felon.
That's correct, Judge.
Which helps me understand criminal history. There may be arrests, but the only conviction from a legalistic perspective would be the old case you mentioned, but it's not a felony conviction. It was a first offender disposition.
First offender disposition. That's correct, Judge. Other than that, which is not a felony conviction, he does not have any felony convictions.
Okay.
So, Your Honor, this incident is alleged to have taken place on December the 29th of last year, and that was why I had it in my head that it was a 21 case. He's been in continuous custody that whole time since December the 29th of last year. And he has not had a bond hearing prior to today. So he's been in custody for 8 months, more or less, without having, more than 8 months actually, without having a bond hearing.
Were you on his case the whole time?
No.
Were you okay?
No.
Because that doesn't fit your profile.
Not at all. No, I got on the case in mid-July. I think what happened is the state indicted the case right before the 90th day. And then Mr. Cladis had his hands on it briefly before I got into the case.
Right,
and then
but he wasn't the first. It was this more itinerant conflict defender who was spread across too many courtrooms.
Was it Mr. Webb?
No, I think this postdates him. Mr. Johns Harris was the name of the gentleman who was handling the non-serious felony. So Mr. Terry had murders, rapes, et cetera, across 8 or 9 courtrooms for the conflict defender's office. And then Mr. Johns Harris had, not that this is a non-serious offense, but it's an aggravated assault. If it had been a sexual offense or murder, then it would have gone to Mr. Terry. But it's been through a few hands.
Right. It's been through a few hands. So, but he has been in custody for a very long period of time with no bond. So, Your Honor, I've spoken with Ms. Holliday about what needs to be done in order to ensure that everybody is safe if Mr. Lloyd is released from custody. And Ms. Holliday has been working for the state of Georgia for the last 22 years. She works for the Department of Agriculture. And what I was going to propose is that Mr. Lloyd be placed on an ankle monitor, that he be released to her custody. that he only be allowed to leave for, I don't think he's going to be working. He'll just be.
That'd be tricky with the SSDI.
Right, yeah. So just for medical appointments, which she will be providing transportation for him. And for anything that has to do with court or coming to my office or anything along those lines. Just a couple of things about the incident, Judge. So the incident is alleged to have taken place on December the 29th of 2021 at about 4:00 in the morning. But the victim, Ms. Jackson, and Mr. Lloyd were together until about 11 o'clock in the morning. That's when she called 911. Apparently, he gave her a ride to her apartment after the incident supposedly took place, and there's no allegation that any subsequent incident took place or anything along those lines. And then she called 911 from the leasing office at her apartment, and Mr. Lloyd was there at the apartment and cooperated with the authorities, didn't make any efforts to leave or anything along those lines. Ms. Charles has shared with me a photograph of an injury to Ms. Jackson's eye. As far as I know, there was no medical treatment sought or anything along those lines. I think it's questionable whether that would constitute a felony or a misdemeanor, but Mr. Lloyd has now been in custody for 8 months. So I don't, I think that addresses the severity of what took place. So, Your Honor, Mr. Lloyd was apparently arrested on the case, the second 22 indictment on, I'm sorry, September 25th, 2019, and released on September the 26th of 2019. And then the state obviously did not indict that case until much, much later. I say all that to say that the victim in that case has passed away for reasons completely unrelated to the incident itself. She apparently overdosed and died of a heart attack. So I've talked to Mr. White now about that case. The only thing that's holding Mr. Lloyd right now, as far as bond goes, is this case that we're talking about right here.
How is that? I'm looking at the 917. I don't want to call it a newer case because it gets confusing because it's an older incident. But the case ending in 917, it can't be that your client has a bond on this unless it was exactly charged that way as a CP.
So they didn't do that, but they didn't add it on to his. They didn't add it on as a no bond bench warrant to his jail booking. So when I look him up on the jail website, the only thing that's holding him as far as the not having a bond are the charge
is the 130 case.
That's correct.
Okay. So I guess we've got a Ms. Jackson case and a Ms. Scott case is another way to differentiate the two. Well, I think we would want to sort out the bond situation in 917 just so that doesn't trip up Mr. Lloyd in the future, because I suspect that whatever bond was granted in the CP version of the case doesn't translate one for one into where we are now.
But I wanted to make sure we were clear on that too, because I wouldn't want him to post bond on this case and then be told, oh yeah, you're still sitting in jail.
You haven't really posted bond.
Right.
Right.
Yeah.
Okay.
All right, Your Honor. So what I'm asking you to do is grant a total bond in the amount of $25,000 with the requirement that he have an ankle monitor upon his release from custody and whatever other conditions you deem to be appropriate.
And he would be living with his mother in Forest Park.
In Forest Park, that's correct.
All right, thank you. So, Ms. Charles, I don't know how you and Mr. Whitenauer want to divide this up, if you were the only one planning on speaking, but I think we ought to discuss bond in both cases. It's not clear to me that there is a sufficient, and I don't necessarily mean dollar amount, but I probably do, bond for the 917 case. I don't have a CP number anywhere to look up what bond he got, but he posted it in one day. So it probably wasn't for kidnapping, 2 counts of aggravated assault, et cetera. And again, I'm talking about the 917 case. So why don't you start, and then if or Mr. Whitenauer can start, however you want to do that.
Perhaps at the end, whether you're decides may have an impact on this.
Ms. Charles, please put on your microphone.
And so I'll go ahead and start, Ms. Rivers, I'm sorry. And perhaps what Your Honor decides after our presentation may have an impact on Mr. Whitehouse case.
Okay.
Your Honor, the state will oppose bond in Mr. case for the reasons that Mr. Lloyd poses a significant threat to reoffend and a significant threat to the victim. And
you're referring, right? Well, I guess it would only be Ms. Jackson,
Ms.
Ms.
Taisha
Scott.
Jackson, who's with us by.
Yes, hi, I'm here, sir. How are you, Judge?
Okay, I'm well, Ms. Jackson. I'm gonna mute you, not to be rude, but there'll be a chance after I hear from Ms. Charles, if there's anything you want to add, I'll make sure we pause and give you a chance to have input, okay?
Yes, sir.
Thank you.
Your Honor, by way of brief history, Mr. Lloyd and Ms. Jackson have had an on-again, off-again relationship for a period of time, which was sort of marked by dysfunction, bit of domestic violence. In almost every instance before this instance, Ms. Jackson would recant, she would drop the charges and not go forwards. She would keep going back because in her words, and as she will tell you herself, she thought the next time would be different. This incident stemmed from after a 7-month break between them. They reconnected, spent a weekend together, very cordial. While she was napping, he was downstairs. Ms. Jackson woke up to a pistol upside her head, and Mr. Lloyd holding her cell phone, which had a photograph that Ms. Jackson had sent to someone else while they were not together. She tried to calm him down and say, don't do this. Look at the date of the photo. We were not together, that sort of thing. He said he didn't care. He proceeds to beat her, pistol whip her, headbutt her, and then put his arms around her, strangle her. Miss Jackson will tell you she fought back. She was able to escape. And then throughout the 7-hour ordeal, before she was able to get out of the apartment and get to the leasing office to call the police, she did everything she could to placate him, including giving him sexual favors. And then she made a story to tell him that she needed to go to the leasing office to renew her compliance or she would lose her apartment. She told him, come with me, come right up to the apartment. I promise you, I'm just gonna renew my paperwork. I'm gonna put my glasses on, I'm gonna put my hoodie on, I'm gonna put a scarf on my head. I'm not gonna call the police. She went into the leasing office, and when she walked in, she asked the manager to call officers. He was still waiting for her outside under the belief that she was doing paperwork. Officers come and meet him on the premises. As soon as officers come, he said, I know why you're here. Puts his hands, they take him into custody. Miss Jackson wanted me to share some photos with Your Honor before she speaks. And with your permission, I'd like to share my screen.
Okay.
This was the result of the assault that Mr. Lloyd perpetuated against Miss Jackson.
Wearing 3 different shirts.
Her eyes were bloody, swollen, almost the size of a football. Months afterwards, she could barely see. At this point, she only has about 17 to 20% vision in that eye.
I'm confused because I'm not good with left and right, but it seems like it's 2 different eyes that are affected. The picture in the center, it's a different eye than the 2 on the sides.
Your Honor, if I'm not sure just the orientation of the photo, but if I was to share the body cam, it matches exactly to how she looked on the day.
Which of the 3, because while I am admittedly not good with left or right, there's not a way that those are so the one, you got a purple tank top, And then it looks like a black t-shirt and then a yellow t-shirt. Purple tank top and yellow t-shirt, same eye. But the black or dark t-shirt, it's not forget about the fact that it's swollen in a completely different way. It's a different eye.
What I have seen that matches this photo, Your Honor, is the eye where it's on the left hand side. So one of the purple tank tops.
Yep.
That is what I
Okay,
remember.
purple tank top and yellow t-shirt
Yes, Your Honor.
would be the left eye.
Yes, Your Honor. That's
Okay.
what matches what was captured on the body cam by the officers
Okay.
after being pistol whipped. What Ms. Jackson wanted me to communicate is that this has happened multiple times. What she calls got her whooped multiple times. And at this point, she is terrified of Mr. Lloyd. We were able to also pull jail calls, Your Honor. Mr. Lloyd has contacted Ms. Jackson over 400 times. In many of those calls, he's telling her, you know what to do. In the earlier sets of calls back in February, Ms. Jackson was going along with that. She told him, yeah, I know what to do. I'm not going to lie to you because if I lie to you and you get out, I'm going to get my eye whooped. So I'm not going to lie to you. I will do a letter and I will tell him I don't want to drop charges. I don't want to do this. But as time went by, Ms. Jackson told me she's gotten some support, therapeutic support, and she's realized this is the time that she needs to stand up and say enough is enough, not go back to this cycle of abuse, this cycle of dysfunction. Mr. Lloyd doesn't have an extensive felony record, but Mr. Lloyd has an extensive arrest record. Multiple misdemeanors ranging from terroristic threats, willful obstruction, multiple repeated violations of the traffic code, possession offenses. So Mr. Lloyd shows a pattern of operating outside of the law. The case that's currently before, involving Miss Ashanti Hall, in that case, the domestic violence case with Adia Wattenhauer, in that case, he beat her with a fire poker. In this case, he beat Miss Jackson with a gun. And when you take a gun out, you're ready to use it. It's just one more second before you pull the trigger. And if she hadn't placated him that day with sexual favors and promising him not to call the police, who knows how things would have turned out. The constant calls, repeated calls from jail shows that Mr. Lloyd has a vested interest in, if he was to be released, not returning to see this through to the end. And Your Honor, I would like at this time to invite Ms. Jackson to address the court as she would like to do.
All right. So Ms. Jackson, well, let me be thoughtful about how we do this because Ms. Jackson has a right to be heard. Is it your sense, Ms. Charles, that Ms. Jackson will be providing a perspective about bond, or is she going to be, because if she's going to be talking about this situation with much specificity, maybe she needs to be under oath, maybe you have to do it by way of questioning, and Mr. Melnick would have an opportunity to question her. If it's more of an impact statement, then I think I'm comfortable having Ms. Jackson share that and I'll receive it in that format.
So Your Honor, we just talked about her addressing you about her feelings, her perspective on what the impact would be for her if he was released, not necessarily the facts of this case. It's just about the fear that she feels should Mr. Lloyd be released from custody.
Got it.
That is
well, let's do that. So Ms. Jackson, can you hear me?
Yes, sir. I can hear you.
Great.
So I can't, okay.
I don't know why I had left the spotlight on that. So we don't need to stare at that cell. There's Ms. Jackson. All right, Ms. Jackson. So what I'm going to ask you to do is to confine your comments for today. There may be another time you can talk about some other things in connection to what you've gone through. But today I'd like you to share with me your thoughts about bond, whether Mr. Lloyd should get a bond, and if he does, what you're concerned about.
Yes, Your Honor. Thank you for this opportunity. I really think Mr. Lloyd should not get a bond. He's a danger to community. He's a danger to me, my family. He knows where I live. This is my second time moving because of the first incident where he has attacked me multiple times. So you are correct about the pictures. They are different events, and I'm very fearful of what he's capable of. He's manipulative and he's a narcissist, and he will appear to seem like nothing's going to happen, or make you feel like everything's okay, but it's not okay. And if y'all let him out, I know I have went and experienced enough things with him to know that it's not going to be over. His mother or his family can say things. They are very intimidated by him. Everybody's intimidated by him, and I'm not running from him anymore. So I hope you and your courts will not allow him freedom for the things that he's done. He's dangerous. I know it may not seem like it, but I'm telling you, he's dangerous. And he means no good, and he will kill. He will.
Ms. Jackson, I think you're back. Okay, you had muted yourself. All right. Anything else? That's okay. Anything else you want to add?
Please don't let him out, please. Please don't let him out. Please.
Okay. Thank you, Ms. Jackson, for sharing this information. I appreciate you being here. I know it's not easy to do, but it's important that I hear from everyone involved in the situation, okay?
Yes, sir.
Thank you so much. All right. Did you have anything else you wanted to add, Ms. Charles?
No, Your Honor.
All right. Mr. Melnick, anything you want to say? And okay.
Okay. So I haven't been provided any jail calls, nor has my predecessor been provided with any jail calls. The address that is on the list of witnesses for that was provided to Mr. Cladis from the state is the 1033 Hollywood Road address for Ms. Jackson. That is the same address where Mr. Lloyd took her on the date of this incident on December the 29th of 2021. So if she has in fact moved, the state has not updated their address, their information with defense. And so we don't have any information about where she is currently living. And if that information were provided to me, I would agree to not share that information either with Ms. Holliday or with Mr. Lloyd. But the address on the list of witnesses that I've been provided is the 1033 Hollywood Road address, which according to Ms. Jackson is not a accurate address. There is no phone number on the list of witnesses, nor for that matter is there a date of birth on the witness list as the state is required to disclose. What Mr. Lloyd has told me is that there were times when there was a tumultuous relationship, but that Ms. Jackson would fight him as much as he would, get into it with her, and that she was oftentimes the primary aggressor, Judge. Those photographs, it's a difficult position to put me in because obviously we're not here on trial, but if I were cross-examining a witness, I would point out that it's clearly 3 different incidents. There's no way to tell that those photographs are not date or time stamped. So there's no way to tell that those incidents were the incidents that were at issue in this case. That there are different injuries. She's in different rooms with different backdrops. Different eyes were, demonstrated. So the photographs really don't show anything. As far as the allegation that he's had a previous history, he has no prior convictions for domestic violence whatsoever. He does have this prior arrest from 2019, a case that sat dormant for 3, almost 4 years in the Fulton County District Attorney's Office. So, Your Honor, I think that a reasonable bond should be granted in this case to the extent that there is any allegation or contention that Mr. Lloyd is a danger to Ms. Jackson. That is addressed by virtue of putting him on an ankle monitor where he can be sufficiently monitored by the state. So I would ask that you grant him a reasonable bond.
Okay. I have a couple questions, but first, well, maybe. Let me see if we have I don't want to confuse Jackson's. Ms. Jackson from pretrial, good afternoon.
Good afternoon, Your Honor.
How many cycles do you have for Mr. Lloyd?
I see 9 cycles, Your Honor.
Okay, and it doesn't sound like there are felony convictions. There was that first offender that we've been discussing. Did you turn up anything different?
That's it for the forest felony, that first offender. I do see misdemeanor. Something happened in 2021 in Fulton County. It seems like he received some type of sentence, but there was no term. It was for simple assault. And one in 2018 for possession of marijuana less than an ounce.
Okay, that's helpful. Thank you so much.
My understanding, Judge, the 2021 case was dismissed. That's what it says on his GCS.
Okay. Now I need to try to remember what my question was. If it comes back to me, I'll ask it. Ms. Charles, you seem animated about something.
Yes, Your Honor, I just wanted to, I point out to Mr. Melnick in the police report on the data officers responded on December 29. They note in the report that Ms. Jackson's eyes were red, swollen, and bleeding, which is consistent with the photos that we were shown today.
Okay. I want to be clear about the photos. What I heard Ms. Jackson say is these are photos of different incidents, which someday, if we get to dealing with evidence, which is the focus so much today, could be evidence of prior difficulties. If her testimony is each time you see me with an eye like that, it was Mr. Lloyd who did it. But that's not what we're working through today. And I'm not troubled in the context of working through bond that they weren't the same situation. They don't need to be the same situation. I think the best evidence in connection with the charges that the state is actually pursuing would be whatever's on the body cam. And you've mentioned that several times, that the body cam will show that you were saying it was the left eye is swollen. I'm not doubting that the left eye was swollen. That isn't, I don't think Mr. Melnick has said it might not have been. I'm focused particularly on the jail calls. And what I'm going to do for now, Mr. Lloyd, is not set a bond on the case ending in 130, but I am going to direct the state to get to your lawyer, Mr. Melnick, within 1 week. All the jail calls, that shouldn't be too difficult electronically. And I would ask Ms. Charles to flag the ones that she's already listened to, or a colleague, whether it is, what's Jill's last name?
Hollander.
Ms. Hollander, who found them. But that way, Mr. Melnick isn't starting with call 1, going to call 400. And there may be some that he wants to listen to on his own, and that's great. But let's get those to Mr. Melnick. And then if upon listening to those, Mr. Melnick thinks that it would be productive for me to listen to some of them and I might develop a different perspective, then I'll invite him to renew the bond motion. But based on what I've heard about Mr. Lloyd's efforts to continue to remain an influence in Ms. Jackson's life, and not necessarily a positive one, after being arrested for these charges that involve alleged aggression against Ms. Jackson, I'm not comfortable that an ankle monitor would do it. I'm not comfortable that an ankle monitor would keep Mr. Lloyd away from Ms. Jackson. And it doesn't need to be limited to physical contact. It could be the phone calls or something like that that could be used to influence Ms. Jackson and complicate the natural progression of this criminal litigation. So let's get those calls to Mr. Melnick.
Absolutely.
We'll give Mr. Melnick a chance to at least listen to the ones that caught either your ear or Ms. Hollander's. And then if we need to revisit it, we will certainly do that. We don't need to sort out what the situation is with bond in the 917 case. If I'm going to set a bond, it would be across both cases. But if we do come back and Mr. Melnick is going to argue that there is a good basis still to grant a bond in the face of my concerns about improperly influencing witnesses in the 130 case, I would give Mr. Whitenauer an opportunity to argue what he wants to on the 917 case if he thinks that that's a whole different set of facts, which it is, but that might merit a different decision about how we handle bond. But as it stands now, the 917 case is not keeping Mr. Lloyd in custody. Let's talk about status. The 130 case ought to be getting close to trial ready, other than the fact that jail calls need to be handed over. Mr. Melnick, beyond jail calls, anything you feel like you're missing? Like, do you have body cam in that case?
I think Ms. Charles did send me, did you send me?
I sent the link, so I have a link.
with
You
the body
can't, it's
cam,
just
so-
download and let me know.
Yeah, I will.
Okay.
And then,
And you traditionally have not had issues with evidence.com
I've had
links.
huge issues with evidence.
Oh, you have?
To be honest, yeah, it's
Okay.
awful. Genuinely, it's the worst. It is genuinely the worst program out there.
Okay.
There are other programs that are considerably better. Microsoft OneDrive is one. There are other programs that are better, but I can usually work my way through it.
Okay. If you can't, please let Ms. Charles know. She's been very good in my experience, saying, well, if that one doesn't work, we'll get it to you in a different way.
Okay.
But having said that, are there things that you think are missing in the 130 case other than jail calls?
It's not a complicated case, Judge, other
Okay.
than jail calls. No, I don't think there's anything. Other
Your description of it makes me share that same opinion. Mr. Whitenauer, the 917 case is brand new in this one respect. It's on for plea and arraignment. It's an older set of facts and an older police investigation. Assuming Mr. Melnick this week files his entry of appearance and his waiver of arraignment, any issues you see in getting to Mr. Melnick the discovery in the 917 case?
No, Judge, I've reviewed the file and I've identified some items that are missing, including a 911 call on CAD, and as well as body cam. And I requested those items and I can provide them to Mr. Melnick, as well as some contact information for some of the witnesses that we already discussed, Mr. Melnick.
Okay, sounds good. That's how we'll handle it. So Mr. Lloyd, we'll get you back here soon if Mr. Melnick and you talk more and Mr. Melnick concludes that these jail calls are maybe not what the state was representing, or maybe they are, but there are reasons that I should view them in a way differently than I'm viewing them right now. In the meantime, I'm going to keep moving your two cases forward. There will be a scheduling order in the 917 case if you end up, Mr. Melnick, being ready to go on 130 and the state wants to try that one, and trial is what we need to do. I don't know that it will be. We don't need to wait for 917 to catch up, but if for whatever reason you and Mr. Whitenauer and Ms. Charles conclude that 917 is what we try first without the victim, then we may have to wait a little bit longer because you'll need a chance to get up to speed.
on the 130 case, the case that we just had the bond hearing, it's on a status calendar or
For right now.
calendar.
Oh, it's on a trial calendar.
It is for September the 23rd.
Okay.
So assuming I get all that, the only difficulty with that is that I am actually out on leave that particular day, but I know that's just the calendar call, and then
Right.
it goes on to one of your trial weeks. following
Right.
that. Yeah.
Right, that would be something in October, and we may soon. We have a vote tomorrow, but it may be that come Halloween, all of the judges will have much more regular access to jurors, and we can return to. I've got a 2-week trial calendar, and if on Monday we don't get a jury because there was a hiccup, on Wednesday we can get jurors, and that will help us move cases in a little more orderly way. It's not this step function where that one case that was going to go, if it falls apart on the day of jury selection, I'll see everyone in a month. I view that as a good case management thing. I don't know how the lawyers are going to view it, but it'll be more like old times. Smiles, everyone, smiles. Yeah, well, they may come to a crashing halt based on the vote tomorrow. We'll see. All right, Mr. Lloyd, it's good seeing you in person. I've seen you on screen way too much. You should know that your mother has been in court every time your name has even been close to a, if there was a Fred Lloyd on the calendar, your mom was showing up, just in case it was you. All right. All right. And Ms. Jackson, thank you again for joining us.
Thank you. Thank you so much, sir.
All right. So, Mr. Brown, let's see if we can get Mr. Brown in Cobb.
May I be excused?
If that's your last case, yes, sir.
It is. Thank you.
You're welcome. Mr. Cobb. Look at that. There he is. Let's get him unmuted. Zoom has behaved very well today. This will jinx it. Hey, Mr. Brown, can you hear us?
I can.
Fantastic. Thanks for bearing with us today. I don't know how long you've been stuck in that little box, but hopefully they gave you a break over the last hour or so. I need the case number for Mr. Brown. It's not on a calendar. We sort of specially got him here.
Judge, I believe it's 22 SC 182797.
Thank you. There it is. All right. So is it a tint violation? Is that the second count?
Yes, Your Honor.
Wow, I didn't know those still happened.
They still happen, Judge.
Okay.
It's still probable cause
Hey, whatever it takes.
to get in that car.
Yeah. All right. This is a bond hearing.
It is, Your Honor.
Ms. Charles, this is your case?
Yes, Your Honor.
All right, then let's get on the record in case 22 SC 182797. That's State versus D'Anthony Brown. Mr. Matthews is here in court. Mr. Brown is appearing remotely from the Cobb County Jail, and Ms. Charles is here in court. Mr. Matthews, why don't you tell me why you think your client should receive a bond and what that bond should look like?
Thank you, Judge. Is it all right if I keep my seat and can everybody hear me? Is that okay with the court?
If the green light is on that little microphone stand, then you are good to go.
It is. And Mr. Brown, can you hear me okay?
I can.
Okay, good afternoon, D'Anthony.
Good afternoon.
Your Honor, Mr. D'Anthony Brown is 32 years old. He is a lifelong resident of the state of Georgia. Prior to being arrested on these charges, he was gainfully employed. He was gainfully employed for a company called Capstone Logistics, located in Fulton Industrial Boulevard. Mr. D'Anthony Brown is a forklift operator. He's forklift certified. He's pallet tech certified. He operates the reach, the stand-up, the sit-down forklift, the clamp. He spoke with the supervisor and indicated that if he could get a bond, then he could reapply and get back to his job. He was working from November of 2021 to May of 2022. Your Honor, he has 3 children. He has a 10-year-old child, a 4-year-old child, and an 8-month-old child as well. Your Honor, he was living in the Summer Hill neighborhood community, and it was a very unsafe area of the community. And there was a lot of violence that was going on over there in that area. And he and his fiance, Caleb Burnett, who have that 8-month-old child together, they were just really experiencing a lot of unsafe conditions over there. They have since moved to a new area. He would be living with his fiance Kayla and their child at 311 Scott Street, number 53, Atlanta, Georgia, 30311. Mr. Brown, the reason that we've not been able to get to a consent bond is because the state contends that his criminal record doesn't support a consent. He is out on bond on at least two open cases. Now, these are RICO cases. They're RICO cases where it is alleged that Mr. Brown, and in one indictment that I'm representing him on, at least 9 or 10 other or some thereabout.
Just the cargo theft you mentioned, or did I just
not
connect
the cargo,
that with someone else?
No, not the cargo
Okay.
theft, but burglaries of gas stations.
Okay, and that's a RICO case.
It is.
Okay,
They chose
out of what
to-
jurisdiction?
It would be Floyd County, and Coweta County. And there's a Hall County as well.
So it's 3 different RICO cases?
Yeah, well, it's just a big investigation, and they're alleging that some of the conduct happened in each of these counties, but it's the same essential alleged group of individuals.
Of like convenience store, gas station burglaries?
Closed gas stations at night, burglaries. So Mr. DeAnthony Brown, of all these individuals who are charged with this offense, he's the one that spent the most amount of time in custody before bonding out on the charges. So he served approximately 3 to 4 years, almost 4 years on these charges before he was able to even get a bond on these charges, because he was bouncing around from jurisdiction to jurisdiction trying to get bonds, and this was happening all during the pandemic. So with that, Your Honor, he's working, he has his child in the car, and he's pulled over for a window tint violation, and there is a handgun that is alleged to have been located inside the vehicle. There is no allegation that Mr. DeAnthony Brown brandished a handgun, touched it, used it, made the officer afraid or apprehensive about the weapon. No, it's a status offense, and because Mr. Brown is a convicted felon out of Cobb County, he was charged with this offense. He's been in continuous uninterrupted custody since May 12th of 2022. We're asking the court to allow a reasonable bond, a bond with conditions, obviously a bond that requires him to have no contact with firearms, a bond which requires him to maintain gainful employment, a bond that requires him, if the court was reasonably, if the court feels reasonable that he should be on an ankle monitor at the county expense, obviously we have no issues with that. And as far as the window tint, he purchased the vehicle with that window tint on it. The officer determined that it was probable cause to make the traffic stop, and it led to a search of the vehicle because the officer believed that there was some amount of marijuana that was found or smelled, and it led to the search of the vehicle. There was no marijuana indictment or as a part of this indictment. And that's where we are, Your Honor. So I'm asking the court for a $15,000 bond with those conditions that we spoke of. The state is going to provide me with the digital discovery in the case. I have to go back and look to determine whether they've sent me the paper discovery as yet, which would, of course, involve the police incident report. But I need the body cam from that stop to determine if there are any suppression issues that need to be addressed, and any statements that need to be addressed as well in terms of suppressions issues. So in the meantime, Your Honor, he is still presumed innocent of these charges. That still means something in our country. And the court, in looking at these factors, I would think that the court is going to hinge its decision on whether or not, hey, look, DeAnthony, if we give you a bond, are you going to pick up any charges? Do you pose a significant risk of committing felonies while you're out? And
like driving around with a gun in your car.
That is the concern that the court would have. And what could we do, DeAnthony, to make the court comfortable that, that would not happen? Well, I believe, Your Honor, that based upon my conversations with Mr. DeAnthony Brown, that you can't move you can almost anywhere you move, crime is afoot, unfortunately. And our current laws are such that if you're a convicted felon, you can't have a firearm. You cannot protect yourself if you are in jeopardy of being able, losing your own life or the life of your fiance, the life of your children. You just can't protect yourself in our
Not
laws.
with a gun. You could have
With
an
a gun.
axe or a baseball bat, maybe even a crossbow.
Most of the bad guys have guns. The ones that are going to do the armed robberies and the ag assaults and things of that nature. So that is where we are in terms of our law.
Right.
So
have been for a while.
And it has been for a while. And whether we agree with it or not, that, at some period of time, you should be able to, but that's not what we're here today for. We're here today, in my humble opinion, Your Honor, to ask this court to take a chance on Mr. Brown in terms of him not because he's certainly not moving any drugs, certainly not breaking into any convenience stores, not robbing anybody, not doing anything with the firearm. But again, Your Honor, we need to continue to work the case to determine whether or not, what does the state have in terms of whether or not he knew that the firearm. So we need to get the digital evidence. So, Judge, I'm asking the court to set a reasonable bond.
Okay.
I'll be out of the court's way.
You're not in my way. All right. Ms. Charles, before you go, let me ask, I think we may be back to having just one Jackson on the call. Yes, Ms. Jackson, what do you have in terms of cycles and convictions for Mr. Brown? Oh, he wasn't on your schedule, so your answer may be you don't have anything.
I'm looking at it now. If I could just have a few more minutes, Your Honor, I want to get all of the convictions for you.
Sure. Why don't you do that? And Ms. Charles can give me her perspective on bond. I'm interested in hearing, Ms. Charles, if you've had any communication with these other jurisdictions, if they plan on coming off their bond because of this arrest, or what you know about the RICO cases. Not so much the allegations. It sounds like it's a series of allegedly coordinated gas station burglaries.
So yes, Your Honor, as far as that goes, I was able to get in contact with the prosecutor who's over that case. So I don't have the answer just yet. What I was wanting to see was the depth of the RICO indictment, to see how much Mr. Brown was implicated or not, given how Mr. Matthews had initially sort of presented his summary of the case. However, Mr. Brown is an intricate part of these proceedings, and therefore it forms a part of why we're asking you to not take a chance on Mr. Brown, because we believe he does pose a significant risk of committing a felony while pending trial. What Mr. Matthews has sort of glossed over is that this is not Mr. Brown's first conviction by a possession by a convicted felon. He had the same conviction in 2018. Mr. Brown, subject to correction from pretrial services, has 34 cycles, multiple felonies: 2008 robbery, 2009 burglary, 2009 entering auto, 2010 forgery, 2014 gang participation conviction, 2018 possession of a firearm by a convicted felon, 2021 the Coweta RICO indictment, and 2021 Floyd County indictment as well. And so while I understand Mr. Matthews' concerns, Mr. Brown has been given multiple chances, and every time he gets out while on probation, he reoffends. And I have heard no evidence from Mr. Matthews that would give the state comfort that should he be released with these bumper indictments over his head, understanding what the state's position is as far as proposed resolution for this offense, which is not probation, that Mr. Brown would not pose a significant risk to not reappear, and as previously stated, to reoffend while on probation, as he should in the past, that propensity to do so.
Okay. Ms. Jackson, it sounds like Ms. Charles has done some of your homework for you. But do you have anything you want to add to what, if you were able to follow, it came out kind of rapid fire?
Okay. She pretty much covered it. He does have the 34 cycles, Your Honor, and he does have felony convictions.
The 2018 conviction for felon in possession of a firearm, was that in Fulton County?
That was in Cobb County.
Cobb, okay, got it. Are you able to tell if he's on active probation, or should I ask Ms. Tucson that?
You may want to ask Ms. Tucson that. I didn't see it in the GCIC.
Okay. Ms. Tucson, Mr. Brown is not on a calendar that's in front of you. He was on a calendar a few days ago. What do you need about him to look up whether he's on probation right now?
I actually have it. I received the add-on from Ms. Nelson.
Thank you, Ms.
and
Nelson.
It looks like his probation case that he's active on now, it actually expires today.
Well, there you go. And what case was that?
It's Cobb County.
The gun case.
I have to look at the charges. 1 second. That is correct, Judge. The firearm.
Okay.
But there are previous Fulton County cases, but his probation expires today for Cobb.
Got it. Thank you.
No problem.
Mr. Matthews, as the movant, anything you want to add?
Judge, ultimately, the court has to determine if the court gives him a bond, will he reappear in court? That's the quintessential question that has to be answered, and we would submit that he would. And we would submit, Your Honor, that because he's relocated and moved to an area that is outside of that particular area that they were in, where it was just really dangerous and hectic and very unsafe, I would ask this court to take into consideration that if he gets a bond, that he would be gainfully employed and that he would be with his family, and he would abide by any conditions that could, in combination with a bond amount, give the court an assurance that he would abide by our laws in our state.
Okay. Thank you. So, Mr. Brown, Mr. Matthews is correct that the primary factor I need to think about is whether you'll show up for court. And I'm less worried about that. You seem to be kind of anchored in the metro Atlanta area, whether it's Floyd or Coweta or Hall or Cobb or Fulton. Plus you got a nice little young 8-month-old, all that. So I'm less worried about that, but I need to also be not worried that you'll stay out of trouble. And I'm not convinced that that is what will come to pass. I don't get the sense you're going to be out there doing crazy, violent takeover robberies or anything like that. You do have a robbery from 14 years ago, but I'm focused much more on not all that long ago, you got arrested for and convicted of having a gun when you weren't supposed to have a gun. And here you are doing it again while you're on bond in 2 real serious cases. Hold on. And while you're still on probation for having a gun as a felon. So I actually have zero confidence that you wouldn't do this again. I very much appreciate Mr. Matthews' point that what you did was drive a car with illegal tint and there happened to be a gun in it. And that is fundamentally different from you were transmitting drugs somewhere or you flashed the gun at someone because you were trying to intimidate them. That's not this case. I trust that will be reflected in the way this case is resolved because it is much more of a status offense. But Mr. Matthews would need to convince a jury ultimately that you had no idea the gun was in the car for this to be something that works out even mildly well for you. And we'll need to let those facts develop. But on the information I have right now, you are not a good candidate for bond. You were on bond and this happened. You were on probation for this and it happened. So I'm going to leave you where you are. I'm going to ask Ms. Charles to make sure she expedites discovery to Mr. Matthews. Mr. Matthews, if in your review of discovery, you conclude that it is patent that your client did not know the gun was in the car, we should revisit this because then the disposition may well be a time served disposition and a bond accomplishes that. But it doesn't sound like we are at that point yet. You need to cast your expert eye on what the discovery shows. And then if you can't work something out with the state, we may need to talk about bond again, at which time you'd be able to share with me some of your concerns about the state's ability to prove that Mr. Brown was aware that the gun was in the car. Mr. Brown, I didn't mean to cut you off. I just was mid speech, and I finished that speech now. Is there something that you wanted to add that Mr. Matthews didn't cover, or that you think I need to better understand?
Well, with the gun situation,
Mr. Brown.
No, so I don't want you to talk about why the gun was in the car, because you could.
not
Anthony.
Okay.
Anthony.
He's talking about a different case.
Oh, okay.
He's talking about, you're talking about the Cobb case?
Yes, sir.
All right, you can tell me all you want about the Cobb case. I'll listen to that.
The gun was in a female's name, and I was a guest at her house. The gun was in her name, and the house was in her name. They just charged me with it because I was there. I had no knowledge of the gun. I just took the probation for it so I can move on and go to the next county to move on with my life. I know it's, you already said I don't get a bond, but a lot of the things I did when I was young. You know, I had no guidance. You know, I'm 32 years old now with 3 kids.
I hear you, Mr. Brown, and that's why I was saying, you know, what happened in 2008 was a long time ago, and that's something that I definitely factor in the distance and time of that and what's going on now. And these RICO cases are allegations. That's proof of nothing. And the RICO allegations have nothing to do with you being a violent person if you were connected with them. It sounds like it may have been a sophisticated scheme to make some money by taking things that didn't belong to whoever was involved. But as Mr. Matthews has pointed out, there is a presumption of innocence that continues to apply here. And it's just something to take into consideration, that I need to take into consideration, that you were on bond. And a real important part of bond is staying out of trouble. And then you pick this thing up. So I hear you on the Cobb case, and you're not the first person who has almost out of convenience said, you know what, I'm going to eat this one, get probation so I can get to my other problems in my life. And we're not litigating the Cobb case now. We're working through what was going on with the gun in your car in May of this year. I'm going to give Mr. Matthews a chance to dive deep into that, and then he'll come back up to the surface. And it may be we talk about bond again real soon because he's got more information to share with me. It also may be that he and you are able to work this one out, and then we'll take a plea, and you can get back to your family and get back to thinking more about these RICO cases that sound like are bigger deals than this one. Ms. Charles, anything else on behalf of Mr. Brown? Well, on behalf of the state?
No, Your Honor.
All right, Mr. Matthews?
No, Your Honor.
Please let us know if there's any issue getting discovery.
I will, Judge.
Okay, all right.
Thank you.
Thanks, everyone.
May I be excused, Your Honor?
You may.
Thank you.
Absolutely.
All right. We have some status conferences and a plea. I think I want to do the plea first unless we have any status conferences that involve folks on Zoom. Ms. Livingston, is there anyone else you've got that's going to be in any cell that you're aware of?
No, Judge, I have no inmate for Zoom.
Okay, let me just do a census here because we've got a few inmates over here, and if we've got all the right people, then we'll work through those after we take this plea. Do you know who's here? Or should I get Deputy Gordon to pop out? He's here. All right. Can we talk about who's here? Mr. Holt is here. Good. You're making it sound like that's the only one who's here. That's it. That's the only one who should be here, I think. What about, because Mr. Lloyd we've dealt with. I think that's it. All right. Then we are all set. Thank you, Ms. Livingston, for all your help today with all the booths.
Yes, Judge. Thank you.
All right. Take care.
You too.
All right. Mr. Abate, are you ready to go forward in Mr. Daniels' case?
I am, Your Honor.
Mr. Grossman, are you ready?
Yes, and Judge, Ms. Nelson emailed me a plea sheet, which we've executed and signed.
Excellent. I'll verify those signatures during part of our exchange. Is Mr. Daniel here?
Yes, Mr. Daniel.
He should come on up and sit with you. Unless you're taking the plea.
Yeah, why don't you sit?
All right. Let me just get this case up. Okay. All right. Mr. Grossman, is it your preference to handle this from council table, or do you and Mr. Daniel want to be up at the podium?
Whatever the court prefers, I'm fine either way.
My preference is Ms. Rivers's preference, the court reporter, and as long as that microphone is on and she can hear you and your client, you can decide.
Ms. Rivers, are we okay?
I can hear you. I can't see you.
Okay, well, there's.
Well, hold on, I may have messed that up.
You can take your mask off. It'd probably be easier for her.
There we go.
Yes.
Excellent. Okay. Then let's get underway. So, Mr. Daniel, good afternoon.
Good afternoon.
You're going to need to speak a little louder.
Oh, good afternoon.
Perfect. Mr. Daniel, you are here to enter a plea in your case. It sounds like it's a negotiated plea, which means the prosecutor and your lawyer are going to recommend the same sentence. That doesn't bind me. I could impose a different sentence. Could be less, could be more, could be the same. If the sentence is more severe than what your lawyer asked for, you'll be able to withdraw your plea.
Okay.
So I'm just making it up. If the recommendation is that you serve 5 years, and I say, someone is dead, this is a serious crime, you don't seem like you're taking responsibility, and I say 8 years, you and Mr. Grossman will have a chance to discuss. And you can either say, no, thank you, and we get you a trial, or you can say, I really would have liked to have 5, but I'd rather do 8 years than go to trial. So you'll have a chance to talk about it with Mr. Grossman if I sentence you to more. If I sentence you to less, you don't get it back out of it. And if I agree with the recommendation, then that's what's going to happen. Does that make sense?
Yes, sir.
Okay. Mr. Abate is going to put you under oath in just a moment. When you are under oath, you need to answer his questions and mine truthfully and completely. Okay. You also need to let Mr. Grossman or me know if you have questions of your own because you couldn't hear what was said, or it didn't make sense, or maybe it's just different from what you thought was going to happen. Will you do that?
Yes, sir.
Okay. When you're ready, Mr. Body.
Thank you, Judge. Mr. Daniel, if you'll raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give in the matters pending before this court with the truth, the whole truth, and nothing but the truth, sir? Yes, sir. All right, you can put your hand down. And just make sure you speak real loudly into that microphone so Ms. Rivers can take it all down, okay? Okay. Could you please state your true, correct, and legal name for the record? Marquise Darrell Daniel Lass. And are you at this time taking or under the influence of any alcohol, drugs, or medicine? No. And is there any medication that you take either daily or regularly that you have not taken today? No. Okay. And how old are you, sir? And how far have you gone in school? 30 years old, have my bachelor's degree in college. And sir, are you able to read, write, and understand the English language? Yes, sir. And do you understand that you are charged in indictment number 21 SC 179815 with count 1, involuntary manslaughter, count 2, reckless conduct, which is a misdemeanor, and the possession of a firearm during the commission of a felony in count 3? Yes. And do you understand, sir, that you have the right to plead either guilty or not guilty to these charges? And if you pled not guilty or remain silent, you may receive a jury trial? Yes. And have you had an opportunity to go over what we call a waiver of rights or a plea of guilty form with your attorney, Mr. Grossman? Yes. And I'm going to hand your attorney, Mr. Grossman, the waiver of rights form. And if you'll look on the last page and let me know if that's the form you went over and if that is your signature in the back.
Yes, it is. And Mr. Abate, I wanted to correct something. I forgot about count 3. So the maximum would actually be 10 plus 5 plus 12 months.
Okay.
Okay, amend that. Thank you.
Yes. And Mr. Daniel, is that your signature on the third page or the last page?
Yes, sir.
Is there anything about what you went over in this form with your attorney that you have any questions that you'd like to ask him now?
No, sir.
And are you satisfied with the services Mr. Grossman has provided?
Yes, sir.
And Mr. Grossman, do you waive formal reading of the indictment?
So waived.
As well as any and all defects in the indictment, including any with respect to your client's name for the purposes of this hearing?
Right. I would waive the misnomer. I don't think there are any other defects in the charging document.
And the misnomer, is the last name spelled incorrect?
He's indicted as Marquise Daniel, which is his name, but I see when we filled out the form that he signs a hyphenated Daniel hyphen last.
Okay, which is what I heard him say when he was, can you spell your last name so that the court, because I think the court reporter may have just thought you said, I thought you said Daniel and then there was like a lisp or something afterwards. So what is the last name you like to go by?
I like to go by Daniel, but on my license, it's hyphen last.
Last as in not first?
LAST.
Okay, got it. All right.
And Mr. Daniels, what I'm gonna call you, is that okay?
Yes, sir.
Has your attorney advised you of the minimum and maximum sentence for each charge that you are pleading guilty to?
Yes, sir.
And did he advise you that the minimum for involuntary manslaughter count 1 is 1 year, the maximum being 10 years?
Yes, sir.
And as it pertains to the reckless conduct count 2, being a misdemeanor, the minimum is 1 day, the maximum is 12 months.
Yes, sir.
And then count 3, possession of a firearm during the commission of a felony is 5 years. That has to be sentenced consecutive, but it can be probated, suspended, or served in prison.
Yes, sir.
Okay. And do you understand that this is a negotiated plea of guilty, which means that the state and then your counsel will recommend a joint sentence to the court. But as the court indicated, he does not have to follow the recommended sentence, that he can sentence you to however he sees fit up to the maximum for each charge to run consecutive.
Yes, sir.
And do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including the federal court, sir?
Yes, sir.
And do you understand that if you are not a United States citizen, a guilty plea will affect your immigration status and will result in deportation regardless of any advice given to you by your counsel or anybody else, sir?
Yes, sir.
And do you understand that you waive any and all defenses by entering a plea of guilty here today?
Yes, sir.
Do you also understand that by pleading guilty, you're giving up the following rights: the right to trial by jury, the right to remain silent and to not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you, a court appointed if you are unable to afford an attorney at the trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and to compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt by the state of Georgia, and the right to appeal if convicted of these charges after trial. Do you understand that you are waiving or giving up all of these rights by entering a guilty plea here today, sir?
Yes, sir.
And Mr. Daniel, has anyone forced, threatened, or promised you anything to get you to enter a guilty plea here today?
No, sir.
And is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes, sir.
Okay. And how do you plead to the charges in 21 SC 179815, count 1 is involuntary manslaughter?
If you want to fix up your guilty plea, you plead guilty.
No, guilty.
And how do you plead to count 2, reckless conduct?
Guilty.
And lastly, how do you plead to count 3, possession of a firearm during the commission of a felony?
Guilty.
And sir, is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
And do you understand that you may only have a limited right to appeal this guilty plea?
Yes.
And lastly, did your attorney explain to you that you only have 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging this guilty plea?
Yes, sir.
Okay. And are you asking for the court to treat you as a first offender?
Yes, sir.
Okay. And have you ever pled guilty or nolo contendere to or ever been convicted of a felony in the state of Georgia
No,
and in any other jurisdiction?
no,
Okay. And have you ever been sentenced for any crime, whether it be felony or misdemeanor, under the Georgia First Offender Act?
no.
And has your lawyer explained to you what the First Offender Act is?
Yes,
And do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, that your first offender status could be revoked and you could be adjudicated guilty and be resentenced up to the maximum sentence for each charge that we've gone over in this indictment here today?
yes,
Okay. Your Honor, had this case proceeded to trial, the state would have been able to prove beyond a reasonable doubt that on June 6th of 2021, the defendant, the victim in this case, Mr. Kyrion Bone, Monty Green, who is the cousin of Mr. Bone, as well as the defendant, Mr. Daniel, and then Mr. Daniel's girlfriend, Miss Kiera Carson, had traveled from Alabama here to Georgia because they were planning to go to Six Flags over Georgia the next day. They drove here. Mr. Daniels had booked 2 hotel rooms at the Intercontinental Buckhead located the Intercontinental Buckhead located in Buckhead at
It's a hotel for Six Flags.
Right. So located at 3315 Peachtree Road here in Atlanta, Georgia, Fulton County. Mr. Daniel traveled with a firearm. He did, it was verified by the Atlanta Police Department, had a permit for that firearm and that he owned the firearm legally. And he had brought it on the trip and into the hotel. At some point, once they arrived at the hotel, his little brother, who was 17 years old, Mr. Bone, he gained access to the firearm. And Mr. Daniel and Mr. Bone were staying in separate hotel rooms, but on the same floor. And Mr. Daniel, the victim, was staying with their cousin, Mr. Green, and he was playing with the firearm, posting photographs on Instagram of him posing with the firearm, which was a Glock 19. Mr. Daniel saw this and had—
Meaning he saw the social media activity.
Yes.
Realized, wait a minute, my gun is with, you said it's his little brother.
17-year-old brother.
Okay,
yes.
but not 7-year-old. I mean, he's not an adult, but it's a 17-year-old who had the gun.
Yes.
Okay, in a nearby hotel room.
Yes, without the defendant's permission. When he saw the social media posts, he immediately went to the room in which his little brother was staying, and he noticed that the gun was in his brother's pants pocket. So they began to kind of wrestle to get the gun back. And during his attempt to get his gun back, unbeknownst to him, his brother had loaded the firearm, the deceased victim in this case. And during the attempt to get it back and the wrestling and confusion that was occurring during that time, the gun did go off. It shot his brother in the upper left side of his shoulder and neck. Mr. Daniel immediately called 911, which we have a recording for. And he was hysterical that his brother had been shot. And based upon that 911 call, Grady EMS, as well as the Atlanta Police Department, responded, attempted to give Mr. Bone medical assistance, and he was taken immediately to Grady. But despite the medical intervention, Mr. Bone ultimately died as a result of being shot in his neck area. The defendant remained on scene, as well as Mr. Green and Ms. Carson did as well. They all made statements to the police and cooperated. Ultimately, Mr. Green and Ms. Carson could not really provide any sort of insight to what occurred during the time that Mr. Bone was shot.
Were they both in the, who shared rooms with whom?
Mr. Green shared rooms with the victim, Mr. Bone, which is the room that Mr. Daniel traveled to get his gun back.
And Mr. Daniel had the room with the girlfriend?
Yes.
Okay.
And coincidentally, Ms. Carson was in the room taking a shower. So they had just gotten in from traveling. This is about 1:45 p.m. And then Mr. Green when Mr. Daniels came into the room, was also taking a shower in the room in which he entered.
So it was brother versus brother with effectively no witnesses?
Yes, that's
Okay.
correct, Your Honor. Mr. Daniel, when he spoke to the police, for lack of better words, or to summarize it, he explained pretty much what I have just explained to you here today. Based on the investigation from the Atlanta Police Department, as well as members from the DA's office, we have no reason to dispute the factual summary that Mr. Daniel provided. And based upon that is the reason for the involuntary manslaughter charge.
Was there anything done through the medical examiner's office, or I don't know who would do it, to figure out who could have been holding the gun based on the trajectory? I know sometimes we get cases where there's not a way that it could be self-inflicted because you can't shoot yourself in the back, for example. This is in the front, but I don't know if anyone reached a conclusion that it would have been Mr. Bone's hand on the gun versus Mr. Daniels, or can't tell.
I asked, that was a question when I got the case, immediately asked the medical examiners. It was Michelle Sims, who assisted with Dr. Henninger during the autopsy. Dr. Henninger indicated to me he didn't believe it was a self-inflicted wound based on the position of the bullet. Very few people shoot their left shoulder to attempt to kill themselves. There was also no soot or stippling, which when I explained to Dr. Henninger kind of the facts and circumstances of the case as we knew, he said it made sense to him that there wouldn't be soot or stippling, as during the tussle, the gun wasn't right up against his shoulder based on the statements of the defendant. So I had no reason to believe that the defendant wasn't telling the truth about what occurred. And I definitely would, if this went to trial, Dr. Henninger could have ruled out that it was not a self-inflicted gunshot wound.
Okay.
I had some concerns about where the gunshot was on the victim, being that it was in his neck, and from what the defendant described, it was initially in the victim's pocket. So I was confused as to how it got there. But as I spoke to Dr. Henninger, he kind of explained that the wrestling was occurring and the gun, when it came out of his pocket, immediately went off through either the fault of the defendant or the victim, as we can't tell who pulled the trigger. But to him, it was nothing unusual as to where the wound was, due to there was a tussle over the gun before. So based upon all of that, that's what the state would have been able to prove beyond a reasonable doubt if this case had proceeded to trial. In my review of the defendant's criminal history, he has none. He was arrested in 2014 for carrying a firearm, I believe without a permit, but ultimately that case was dismissed after he was able to provide proof that he did have a permit. I guess he just didn't have it on his person, and that was in Alabama. And again, that was roughly 7 years ago, or 6 years ago. My math is bad. Based upon the conversations and negotiations that I've had with Mr. Grossman, the state and defense would recommend a sentence to Your Honor for count 1, involuntary manslaughter, 5 years probation. That after 3 years, I'd have no problem with it suspending. Count 2, reckless conduct, would merge with count 1. And then count 3, 5 years suspended, and obviously it has to be consecutive. So that'd be the recommendation from the state based on the negotiations with defense counsel.
Any conditions of the probation?
That he maintain, or that he not violate the law. This is an unusual circumstance because this is an incredibly tragic case. I can't imagine the burden of having to walk around knowing that you killed your brother inadvertently. I have spoken with the victim's mother, Miss Bone, and she was very clear that she didn't want the defendant to go to any sort of to be in prison or incarcerated in any way. He does have, I believe it's 2 children. And from speaking with her,
Mr. Daniel has 2 kids.
Yes.
Or Mr. Bone had 2 kids.
Mr. Daniel, Mr. Bone had no kids.
Okay.
But speaking with Miss Bone, the victim's mother, she indicated that the 2 brothers were thick as thieves, is how she described it. They were very close. And that she assured me that she knew that this was not done intentionally, and that, she could tell the anguish that he, is going through and punishing himself every day. So again, this is a tragedy for all parties, and nothing further from the state.
Okay. Ms. Jackson, do you have any criminal history for Mr. Daniel?
Your Honor, I did not receive a calendar information on Mr. Daniel, so I would need information.
That's okay. This was a one-off when we learned that it had been negotiated. So it sounds like there was a 2014 arrest that didn't materialize into anything else. So don't worry about that.
Okay.
Mr. Grossman.
Judge, I don't have a lot to say. I'd like to thank Mr. Abadi for coming to this conclusion. Mr. Thomas is here. He's Carrion and Marquise's father. He's father of both these young men. So, I mean, the first thing that really struck me was just looking at the custodial statement that Marquise made to the police. I mean, and Mr. Abadi said it, I think better than I could have said it, really, just the anguish. And it was just a terrible, terrible tragedy. I understand that, by entering a plea, we're waiving all defenses, including accident. I know that I shared a photograph with Mr. Abate with that when it must have been Monty Green, the cousin, who took the pictures that went online that Marquis saw when he became aware that that Carrion had the gun, and you could see the firing pin was back. So unbeknownst to Marquis, he loaded the gun and he'd also cocked the trigger back. So we know that would have not taken a lot of pressure to squeeze off a round, and that's what happened. And it's a negotiated plea. Marquis is asking to be treated as a first offender. You're not going to see him back here. He's got 2 kids. He's got an 11-year-old son who lives with her mother, and he has a 5-year-old daughter who lives with Marquis. Marquis operates his own business. He sells cars. I believe he's been doing that for 6 years. I can't really speak highly enough about this young man. He's always been extremely courteous to me. He's an intelligent young man. We're just asking the court to accept the negotiated plea. You won't see him back here, and I'm confident he's going to be able to successfully complete first offender if he's treated as such.
And home is in Alabama?
Huntsville, Alabama is his home place.
So how do you envision probation working since it needs to start out in Georgia?
It's going to need to start out in Georgia. I've explained to him that he's probably going to have to meet with somebody here. He's traveled here with his father and his stepmother today. So what I kind of envisioned, it may be possible that he may need to come back here within the next couple of days. What I was kind of envisioning is it may just be that he gets like a report date today, and then he can come back and he can take care of the process of getting his probation transferred to Alabama.
Okay, but you've helped him understand that doesn't happen right away, and there may be expectations that he be in Fulton County or in Georgia for a little while they're working through that.
Well, I was not aware that he'd have to remain here today because, like I say, he did travel here with his father and his stepmother. So maybe I was just wrong and I didn't think this thing through. I thought worst case scenario, he would get a report date and he'd have to come back.
It might be after he comes back. We'll find out from Ms. Tucson in a moment, but my understanding is that once Mr. Daniel reports, which wouldn't be tomorrow or today, it would be 72 hours, whatever, by Monday or Tuesday. He then might need to be in Georgia for a while. I don't mean a few hours, while all of that paperwork is prepared and transferred. And Alabama doesn't have to say yes. I suspect they will, because it's mutual, and we get cases from Alabama. But we'll hear from Ms. Tucson. I just want to make sure there's no surprises. If the answer is that Mr. Daniel needs to be local for a couple weeks after he starts reporting, because you have to be in Georgia until they sign off on that. I don't remember the specifics, but we'll hear about
I
it.
don't either. I hope it won't take that long.
Okay, well, we'll find out in a moment. Did any of the people you mentioned want to say anything, or you're speaking on their behalf?
I don't know, Mr. Thomas, apparently not,
Okay.
but they are here to support him.
I have seen their pain as we've worked through this.
Yes, sir.
Mr. Daniel, above all, you have a right to speak. This is your plea, and you are taking responsibility for what happened. You don't have to add anything more than I've already heard from the prosecutor and from your lawyer, but I would be remiss if I didn't ask you if there was anything you wanted to say.
I don't have anything extra I wanted to add in.
Okay. And how old are you now?
30 years old.
Okay. Well, Mr. Daniel, I think Mr. Bate put it just right when he said the hardest thing about this isn't going to, he didn't put it quite this way, but the hardest thing about this isn't going to be the sentence you get. It's what's already happened, and that part you can never erase. I assume you were holding your brother and trying to keep him alive until the Grady folks got there and you knew what had happened. And then you got that awful, awful news that he didn't make it. And that's on you to a certain extent. And I'm not saying blame. This was not an intentional act, but it was a confluence of this struggle. And what are you doing with that gun? Give it back. It's not safe. And it sure wasn't safe, because he's gone. And you can't ever erase that. And I think for you, you'll remember this day because you pled, and then hopefully soon probation will be in the distant past. You'll be a good dad to your kids and run your business and all that. But forever, there'll be your memory of that situation with your brother. That's tough. Mr. Daniel, I find there is a factual basis for your plea. I also find that your plea is knowing and voluntary. Knowing simply means that you've understood all the things that people have been talking about. Is that a fair statement?
Yes, sir.
Any questions about anything?
No, sir.
Okay. Voluntary means that no one has forced you to enter this plea. You have decided, after consulting with your lawyer and your family, that this is the best way forward for you. Is that correct?
Yes, sir.
Then I'll accept your plea. I'm sentencing you pursuant to the Probation Options Management Act. What that means, Mr. Daniel, is that while you're on probation, if you have a violation, and I hope you have none, if that violation is small or technical, you and probation will work that out. But if it's more significant, you get arrested, you get caught with a gun, because you cannot have a gun while you are a first offender probationer. That comes back to me, and we'll work through what's going on. I need to talk to you about first offender, and I know Mr. Grossman has covered it with you, but I need to do it on the record. First offender is primarily an opportunity for someone who qualifies, like you, haven't been in trouble before, no prior felony convictions. And it means that when you leave here today, you still have no convictions. Even though you've pled guilty, even though I'm giving you a sentence, it's not a conviction. And it will remain not a conviction as long as you stay in good standing with probation. And then eventually your probation will be closed out and you can file some paperwork and it's gone. Again, not the memories of what happened to your brother, but your case is gone. While you're on first offender probation, you don't have to tell anyone you're a convicted felon. If you're applying for a job or going back to school, you never have to check that box saying I'm a felon, because you're not. That's the real good part of first offender. The downside of first offender is that if you don't live up to the expectations we all have for you, and you go sideways or backwards and get arrested for something, and it comes back to me or a judge, and the state says you should revoke, I can take away your first offender status. And because you've already pled guilty, I could sentence you up to 15 years, 10 plus 5, 15 years in prison. I'm telling you, if you are back here because of something involving a gun, no matter how accidental Mr. Grossman may say it is, if you had a gun in your hand, it was pointed at someone, that gun went off, it's going to be a big chunk of those 15 years that I would resentence you for. And you've got your whole new case that you wouldn't have dealt with. So I say that not to threaten you in any way, because my guess is Mr. Grossman's right. I'm not going to see you again unless I'm buying a car from you. But you need to understand the risk of first offender. Do you feel like you understand the upside, the good things of first offender, as well as the downside?
Yes, sir.
Understanding those things, do you want to be sentenced as a first offender?
Yes, sir.
Okay, I will do that. I think you qualify. In some ways, this is a tough case for first offender, but in other ways, it's the perfect case for first offender. There's someone who died. Generally, we don't do first offender when there's a death. But this is not what I typically see when there's a death, where it's a loved one and it's as close to it's an accident. Why am I being prosecuted as you can get? All right, I'm going to follow what's been negotiated. Count 1 will be 5 years. Count 2 merges into count 1. Count 3 has to be 5 years and it has to be consecutive. So it's a total sentence of 10 years. The first 5 will be on probation. The remaining 5 will be suspended. It's still a sentence, but you don't report to anyone. I don't have a problem with you living in Alabama, but you will need to negotiate that with Georgia probation. They have to transfer supervision to Alabama in order for you to live in Alabama. So we're going to hear from Ms. Tucson in just a moment. She works with probation, and she's going to give you a rough feel for what it means, but it may be that you have to be in Georgia in a hotel or something for a little while, not starting today, but when you come back to report, you may need to stay in Georgia for a bit until Alabama says it's okay. We'll supervise Mr. Daniel. Okay? Is that going to be a problem?
No, sir.
Okay. All right. You signed a document that Mr. Grossman went over with you that listed all the rights you're waiving and mapped out what the plea deal was. Can we get that?
Yes, Judge.
Okay. Is that your signature on the second to last page? I'll hold it up in just a second. Thank you. Well, actually, you guys signed on the same page. This is a interesting format. Where'd you get this?
Off of my computer. That's my bad.
Okay. There's a black ink ballpoint pen. Is that your signature, Mr. Daniel?
Yes, sir.
Okay. And then beneath it, you've signed it, Mr. Grossman.
Yes, sir.
And you went over this with your client.
I did.
All right. Second set of signatures go on the indictment indicating the guilty plea. We are doing those electronically now, Mr. Daniel. Do you authorize me to sign the indictment indicating your guilty plea?
Yes, sir.
Mr. Grossman?
Yes, sir.
And Mr. Abate?
Yes, Your Honor.
I think that covers everything. Anything else from the state?
No, Your Honor, other than we spoke with Ms. Bone. She did not want to attend here today. We let her know that the plea was going. I also attempted to get in touch with Mr. Thomas, the father of the deceased victim as well. Unfortunately, I didn't have a good number, but I knew Mr. Grossman had been in contact and he was aware of what was going on.
Okay. Well, thank you, Mr. Grossman, for keeping that channel open. It might have been easier for you to keep it open than Mr. Abate anyway.
Thank you, sir.
Mr. Grossman, anything else on behalf of your client?
No, just as long as we know, what to do next with Ms. Tucson.
Coming up next, what I'm going to ask is if you could give Ms. Tucson your cell phone number, and that way you all can go outside and Ms. Tucson can work with you, and I'll be able to move on with the next few positions on the calendar.
Great.
Does that work?
Yes. Ms. Tucson, can you hear me?
I can hear you.
Okay, 678-358-6555.
678-358-6555.
Yeah, I'll step outside when the judge excuses me.
Okay, I'll give you a call shortly.
Thank you very much.
All right. And with that, we're done, Mr. Daniel. I wish you luck with these things. You go with Mr. Grossman because you're going to need to be talking with a probation person too.
Okay, thank you.
Thank you, Judge.
You're welcome. All right. At long last, to our status calendar, if I can
And
find it.
Judge, I'm sorry, before I give him a call, will I be needed for the status conference?
I don't think so.
If so, you could send me an email or.
Yep. We'll reach out for you if there's a surprise plea, okay?
Okay, thank you.
Thank you. All right. Position 1 is Mr. Lowe, and we asked that Mr. Lowe not be produced. Mr. Cladis, I think this was published before we knew your change in circumstances. This would be the oldest case I have of all my criminal cases. It was a public defender case for about 1,000 years. And then on the eve of trial, they determined they had a conflict. Did you end up ever connecting with Mr. Lowe?
I have spoken to Mr. Lowe. I have not been in contact with him the last 2 weeks. I had a phone number for him at the Georgia Regional Hospital that worked in the last week or so, suddenly doesn't work. So I have not, he's the only person I've had on a calendar this week that I have not spoken with.
Okay. Well, there's nothing we can do with this case for a long time anyway. And this was one that was going to take you a great deal of time to get up to speed on. Mr. Abate, you're listed as attorney on Lowe. This has been a Ms. Love special for a while.
Yeah, they covered that.
Okay, but you're not suddenly stepping in, okay, as the guy. Anything new from the state?
No, Ms. Love did not indicate there was any updates that she had to provide to the court other than she maintained she was ready for trial.
Yes, she is. All right, we have to reset for counsel. Okay, thank you. Mr. Holt. Mr. Holt is here, so if we could bring Mr. Holt out, please. Mr. Cruz, your client's up next.
Oh, Your Honor, may I borrow a pen from the court if there's one on that table over there?
Thank you, Your Honor. Look at that. You can have a law enforcement pen.
Thank you. Ran out of ink during the meeting.
I won't tell Ms. Nelson you're going through her drawers. Yes, sir. All right. We have two things to work through with Mr. Holt. One, does Mr. Holt know of your employment situation?
Yes, Your Honor.
Okay. I'm trying to remember why when you went to trial the first time, Mr. Holt, did you have the public defender or the conflict defender, or did you have a lawyer that you had hired?
I had a public defender.
Okay. I'm trying to remember why they rolled off the case. But neither here nor there. So Mr. Holt is here in custody because he missed a court date. He is here in a larger sense because he had a trial, he was found guilty, and his conviction was reversed. And we need to work through what we're doing next. Am I remembering correctly, Ms. Charles, that,
Your Honor.
pardon me?
You are remembering correctly.
That this is, well, that part I'm okay with, but was this one where the victim is either ill or elderly or both, and there was a possibility, at least in your mind, if not on the other side, of working this out short of trial?
There was an attempt with his previous counsel, Mr. Theory, to work it out short of trial. However, the state's offer was not straight probation, and Mr. Theory indicated Mr. Holt was not interested in any plea that required any additional time in custody.
Got it. Now, this calendar doesn't list the charges, but my recollection is they're serious charges. And so another guilty verdict is not a probated sentence.
Correct.
Okay. And the case was not reversed because it was insufficient evidence.
No, it was reversed on inappropriate hearsay evidence that was allowed in.
Yeah. Okay. Okay. So Mr. Cladis, why don't we talk then about Mr. Holt's bench warrant? Because I know he was, and then you became anxious to try to clear up what happened.
Well, Your Honor, as the court noted, he's been living with this case for almost all of his 20s. He's turning 27 today. There was a trial, there was an appeal, convictions reversed. He was in custody throughout that time. He was in custody for almost another year after that, until Your Honor granted bond in September of 2020. As far as I'm aware, there were no issues with his appearances for court.
No, until
April 5th. In the early part of this year, Mr. Holt and his fiancee, Ms. Williams, who is present in court right now, became homeless. They lost their apartment. They were living out of their car, not getting mail, basically. As near as I can determine, prior counsel did not contact Mr. Holt, or if he did, I don't see any records of it anywhere in our office. He just did not know, Mr. Holt did not know that he had court. The failure to appear was completely inadvertent. He was not attempting to evade the court's authority or to evade this case in any way. So we're asking the court to just reinstate bond. Miss Williams has found housing. She is living in an apartment again. She is taking care of Mr. Holt's son by herself. If Mr. Holt is released, he can go, he has a job that he can go work with his brother who has an auto shop in Decatur. Again, Miss Williams is herself working again. I don't think there will be any further issues with Mr. Holt missing court if the court reinstates bond. Okay. And so what Mr. Holt wants me to just advise the court, pretrial services, as far as I know, had no issues connecting with him or being in contact with him. There was never any question of that.
Well, we'll find out in a minute because we've got pretrial services on. How old is your son?
2.
2. So Ms. Williams is having to work and manage a 2-year-old? Unless the 2-year-old comes to work, how does that go? Is there another family member who helps out?
She paid like $100 a week for daycare.
Daycare, okay. And is paying rent. All right, must have a good job. And your claim, Mr. Holt, is that if you get out, you can work for your brother or with your brother?
For my brother.
So he's the boss. He could decide to hire you, or he's just hoping, hey man, I can get you a job because the boss likes me.
He's the boss.
He's the boss. And what would you do?
Changing tires, washing cars.
Okay, and that's in Decatur?
Yes, sir.
I don't know if it's in the city of Decatur.
It's on the east side. It's in the east side area. I'm not sure exactly.
That's okay. But I mean, it's not in Kansas.
No, sir.
Okay. And the new apartment is in the metro Atlanta area?
Yes, I have an address.
You don't need to give it to me right now, but it's in the metro Atlanta area.
So, yes.
Okay. All right. Ms. Charles?
Your Honor, the state will ask that you keep Mr. Holt in place and not grant him, reinstate him on bond. You know, before I go further, may I approach? I would
Yes.
Put something in.
Are you giving me something that Mr. Cladis has too?
Yeah, I'm going to give him the copy.
Oops.
This is a letter that was concept to you on 8/10. Indicating the notice of eviction alleged by Mr. Holt.
And who sent this to me?
Mr.
Mr.
Cladis,
Cladis
yes,
did.
sent it
Okay.
8/10 addressed to Your Honor, but copied to me as well. And so, yeah, when I printed the letter, there was some glaring red flags just pursuing the letter. The lack of a letterhead, the font mismatch, there was some errors in grammatical errors that just didn't look right to me. And so, Your Honor, what we did was contacted the Boulder Crest Lane apartment company. And I have here confirmation from the manager of the company that this letter, regrettably, Mr. Holt and his fiance, friend, partner, has perpetuated a fraud upon the court and made Mr. Clayton maybe an unwitting accomplice. They have sent me the template. That's what would come from the courts, which looks nothing like the letter that Your Honor has in his possession. They've also confirmed that the lease, the only adult on the lease at the time was Kishwana Williams, but this has been, I guess, altered, maybe reproduced to add in Zacchaeus Holt to make it look as if he would have stayed at the address at the time. Also, if you note on the letter in your possession, Your Honor, on the above property manager, there's like a dot, but if you tilt it, it looks as if there's like a ridged indentation, as if there was tape over that, so sort of barring the address, any signatures, I'm sorry. It's not signed or executed in any way. I spoke to Miss Downing, or Kwame Downing, who's a community manager at the Vesta Boulder Crest Apartments at the address 26 Boulder Crest Lane. She says Miss Tanya Hicks, who was identified here as a property manager, is no longer employed with the Vesta Boulder Crest Apartments as of June of 2022, and that Ms. Kishwana Williams did leave the property in January of this year. However, Mr. Zacchaeus Holt was never, ever on the lease. In In Odyssey, we have an address of 818 for Helmer Court. Additionally, when Mr. Holt was first represented by counsel, previous counsel, the reason I was told why he was not able to attend was because he was hospitalized. And when we had come for the initial status before we had the reset, Mr. Overton Theory was saying to the court and to myself that he was just waiting on the paperwork. And so I said, well, once I get the paperwork, we could probably do a consent bond. I would like to review that first. And so, Your Honor, I'd like to also review what I've received from the manager. And ask that Your Honor would take that into consideration as to Mr. Holt's credibility and his representations to the court that he would reappear or abide by any conditions imposed by the court. This is a clear demonstration of Mr. Holt's propensity to be false, and we ask that you keep him in place.
Okay, so Mr. Cladis, two things at least. One, I'd like to hear a little bit about oh, no, it wasn't actually a medical situation. It was eviction, and maybe it's both. And I realize that one did not occur on your watch, but I'm recalling that as well, now that it has been brought to my attention, that your predecessor, who doesn't bind you in any way, said the issue was a medical issue, and that's not what you're sharing. And then two, I want to give you a chance to digest. I don't know if you got a copy or if I have the only copy. And
I can forward it to him.
We'll get you a copy of this, but I want you to have a chance to explore this a little bit, because on its face, it calls into question this notion that it was an eviction, and that the real reason that Mr. Holt wasn't here is because mail that would have been sent to apartment 64D wouldn't get to him because he wasn't living there anymore. We just need to get to the bottom of it. There may be a reasonable explanation for it. There may not. But let's start with the medical situation. And that may be news to you, in which case, another reason to take a time out and get you back here, having had a chance to digest what Middleburg Communities has had to say about never ever providing eviction notices that look like this.
I'm not aware of the issue with the eviction notice. To my mind, the question is whether Mr. Holt, where he was and why he was there. As far as I know, he was staying with his girlfriend, her fiance, Miss Williams. He had been living with his sister for some period of time leading into, I guess it would have been the fall of 2021. He was sort of back and forth between the two residences, maybe spending some nights a week with Miss Williams.
And I want to be clear, this is not me auditing where did Mr. Holt spend his nights. He could spend every night with Ms. Williams as long as the mail was going to the address on record and he was getting that. And so if that's mom's place and the notice goes there and mom says, hey, you got your notice, you better go to court. Whatever the system was in the past, it worked because Mr. Holt was here. I let him know in no uncertain terms, if he misses one day, we're done with bond and he can wait where he is now until this case gets resolved. And he missed a day, true to my word, I revoked his bond and here we are. If there is a good reason that he missed court, medical, first story, or he was homeless, then there isn't a way for him to update his, I don't know how he updates his address. There's not an address to give. It sounds like maybe there was always mom's address. And what Ms. Charles is bringing to my attention is maybe this Boulder Crest address had not disappeared after all. I don't know, but it's murky enough right now that I think you and Mr. Holt are going to need to confer and do a little more digging on this one. But I cut you off. I'm sorry.
I forgot where I was. He was staying with Miss Williams. The mail was, as far as I know, would have still been going to the address on file. I believe my investigator spoke with Mr. Holt's sister. She doesn't recall their receiving mail during that period of time when she would have been getting the notice for the April 5th hearing. Whatever issues there might be with the eviction notice, I don't think that disproves that Mr. Holt was homeless at the time. I don't think it disproves that Miss Williams was homeless at the time and that they were not receiving the mail.
Well, it contradicts it, but we'll see. If what Middleburg Communities is saying there was no eviction, then if this is not what you've been told it is, then that, I think that will go to credibility, not of you, but of the whoever provided this. But I'm not reaching that final conclusion yet. There's just enough here that gives me pause that I want you to look into it a little bit. I'm also looking up Mr. Holt's address of record, so we know where things were being sent. Things were being sent to Helmer Court. That's mom's?
I believe sister's address, is that not?
I don't know. Ask your client. It doesn't say whose it is. It just, Helmer Court. Who lives at Helmer Court?
That's my other sister. Can I ask a question, sir? Can my sister change Miss Takira Smith, Miss Carmichael, the one you let me out on bond with? Is she able to change my address?
I mean, your lawyer could. I mean, in theory, I could. Someone needs to let the court know, the clerk's office know a good address, the address in the system to which every notice is being sent and to which it worked every other time. You always made it here for court. So the clerk's office mailing something to Helmer Court worked every time.
No, the last court date that I came to 6426 Rockaway Road. That's the last court date that I attended. It came to Takira Carmichael's house.
Oh,
that's when she kicked me out. So I don't know if she changed the address and told me I can't receive mail there. But if you look in the system, 6426 Rockaway Road, that's where the last court date that I attended came to.
Who is it who kicked you out? Your sister kicked you out?
Miss Carmichael. I couldn't live there. That's why I ended up with
Who's Miss Carmichael?
My sister, who you released me on bond to, who signed my bond.
Oh, she kicked you out?
Yes, sir. She has another baby now and she's married and she doesn't really have room for me there.
Oh, okay.
I contacted Miss Lovelace and let her know that I was staying with my fiance and I was homeless at the time. She could correspond.
What was the court date you missed?
April 5th.
April 5th.
Okay.
2022.
So one notice was sent to Takira Smith, no known address. So that's not on you. Another notice was sent to you at 6426 Rockaway Road.
That's Takira Smith's address, the one you released me to.
Okay. So in the middle of March, notice was sent to that address telling you to be here on April 5th. In the middle of March, where you were not staying at that address?
No, I was not.
Okay. And when did you tell anyone in the clerk's office that we should use a different address?
I didn't really have an address at that time. I was homeless. If you look at my emails with Ms. Lovelace, it will correspond there.
I can.
Ms. Lovelace is.
She works for
Pre-trial
pretrial
services.
Okay, pre-trial. Okay.
Your Honor, I have-
Hold on. Let me just do one more. So then what is this Helmer Court?
I don't know. That's why I said, can my.
Oh, could someone have changed it
Yes,
for
I'm
you?
asked.
Got it. Have you ever heard of that address?
Yes, that's my other sister address, but I don't live there.
Okay, but does that sister communicate with you?
No.
Okay. So you're thinking maybe one sister, the kick-out sister, changed it to your other sister because she didn't want to get your mail anymore.
Yes, sir.
Okay. Well, that's interesting. Your sisters are not helping you a whole lot with all that. What were you going to say, Mr. Cladis?
Just that I may have indicated earlier, there appears to be some knowledge on the part of pretrial services and prior counsel. I think it would have been Michael Webb at the time. Email exchanges between them described Mr. Holt as homeless, and that's in the fall of last year. I don't think they meant living on the street homeless. I think they meant sort of unstably housed.
Sure. Well, let's see what we can learn from our friends at pretrial. Ms. Jackson?
Yes, Your Honor.
Hey there. Do you have a channel into how Mr. Holt was doing on pretrial release?
He was doing very well. He was in compliance up until the end. And I think that has something to do with his housing situation because I see at the end where they closed it, and the only note that's there is that it was a judicial hold. So normally when it's a judicial hold, it's a residential, they don't have a address on file for the defendant. But he was
Okay.
in compliance, he would communicate with Ms. Lovelace.
And you're saying there's no address on file because he had communicated to pretrial, I no longer have a stable address?
That, the only thing that I have in the, for us, the notes in pretrial services, it says case closed, judicial hold. It doesn't give me any additional information. The only thing that I was stating when a judicial hold is filed is when someone doesn't have an address on file, whether it's for courts or pretrial, they'll file a judicial hold.
Do your records though show what addresses were on file for Mr. Holt?
Just a moment, let me see if I can. It's not in the notes. What address he had or any updates or changing in addresses.
Okay. And is there anything in the notes? I guess I didn't follow exactly what you said. Is there anything in the notes that said that Mr. Holt relayed to Ms. Lovelace that he was having trouble with a stable address? Or that wouldn't be recorded in anything you have access to?
I can look through the notes and try to see if she made a made a note of it. Let me look through some of them and see. No note of it, Your Honor. Nothing stating, I'm not saying that he didn't have that conversation with her, but it's just not in the notes.
Right. Okay. All right. So, Mr. Cladis, I think I'm going to send you back to the research room to figure out a little bit more about what's going on with this eviction situation, because they're not aligning. Boulder Crest is saying this isn't a document we would have produced. And so my concern isn't so much, is it true that your client was in the midst of an unstable housing situation? It would be, why did he think it was a good idea to present this to you if this is not legit?
I would point out for the court, Mr. Holt being in custody does not have access to any kind of document generating system. I did not receive that document from Mr. Holt.
Okay.
Whatever issues there might be with it, he is not the author or the creator of that document.
Understood, but this came from you?
It did.
Okay, so you and Mr. Holt need to work through it, but I appreciate he doesn't have a laser printer in his cell. At least he ought not to. That's harder to conceal than a cell phone. I'd also like to hear a little bit more, not today, about, well, wait a minute, was it a medical thing or was it an unstable housing situation? Then we can keep talking about this. In the meantime, I guess talking about when we could try this case again isn't the right role for you. You can continue to dig deeper on this so that we can reconvene soon to talk about maybe reinstating the bond, but you're not the right one to talk to about trying the case. Okay. All right. I'm going to give you this. This is what Ms. Charles shared with me. So you've got a copy. And then Mr. Holt, we're not going to wait a long time to get you back here. I'm going to give Mr. Cladis a little time to speak with you. He may need to speak with Ms. Williams. But when we talk again about reinstating the bond, I want to understand fact or fiction. It was a medical thing versus it was a housing thing. And then if the current story and the story you're sticking with is that it was a housing thing, how we just reconcile these two things. Because part of what you'd be asking me to do, Mr. Cladis, if I were to release Mr. Holt, is to have confidence that he's going into a stable situation where folks wouldn't do things to benefit your client in a way that would frustrate the wheels of justice turning. And if, I'm only saying if, this eviction letter is not legitimate, that would be not consistent with giving the court straightforward information about what's going on with Mr. Holt. Okay?
Yes, Your Honor.
All right. Thank you. All right, Deputy Gordon.
Your Honor, may I have a word with Mr. Holt before I?
Sure, and you can talk with Ms. Williams. The next one doesn't involve you, so we can handle Mr. Carr. Are you here?
I have one. No.
Mr. Cruz, is Mr. Carr with you?
Yes, I'm here, sir.
Great. Let me get back to my screen. Oh, why did it get small?
Yes, sir. Mr. Carr is here.
There he is. Yep.
Me, Your Honor.
I see him. He's not with you, but he is there. Let's replace and add you to it. Excellent. Let's move on to number 3 on our calendar. This is the case of State versus Brian Carr. And if I'm remembering correctly, we had been stuck for a long time because the alleged victim in this case has had federal criminal woes in Florida. And we were having trouble extracting him from there so that he could come up here and assist the state in making its case. Let's get an update from Ms. Charles, and then I'll hear from Mr. Cruz.
So, Your Honor, we've been fortunate. 2 weeks ago, I heard from Mr. Owens, and he is now here in Fulton County Jail.
Oh.
He was transported back, I guess, he was sentenced and released back to Fulton County.
And why is he in our jail?
I don't know. He called me and said, did you bring me back? Because I'm in Fulton County right now.
Huh. So let's keep him here.
Yes. And so I told him I'm going to have to make some time to come out and speak with him so we can fully flesh out, where we are with this case. And then I can give Mr. Cruz a more comprehensive update. And actually, he called me today. See the number.
Mr. Owens?
Mr. Owens.
Okay.
Mr. Owens. He calls almost daily because I said I'm going to come see him. So I need to just find a time to get out there and sit with him for a while and figure out where we go from here. But it's good now. He's accessible, which is good.
He is. So what do you see? I know the next immediate step for you is to go talk with Mr. Owens. I'm anxious, as I suspect Mr. Carr and Mr. Cruz are, to get this to closure. And so I think putting on a trial calendar makes sense. Now that Mr. Owens is here, that was the obstacle for the state saying ready. Mr. Cruz was always saying ready. And because Mr. Carr was on bond, I was okay giving the state some continuances because it really was beyond your control. It wasn't just, I can't find my own discovery. But now Mr. Owens is here. So any reason from the state's perspective why we should not move Mr. Carr's case to a trial calendar?
Not at present, Your Honor.
All right, Mr. Cruz, we've got Mr. Owens. And he's just as available to you, I suppose, if he's over at Rice Street. Any reason we can't get Mr. Carr's case on a trial calendar soon?
No, sir.
Okay. Mr. Carr, you doing all right on bond?
Yes, sir.
Good. Mr. Cruz, I think we covered this before, But other than being able to talk with Mr. Owens, if Mr. Owens wants to talk with you, any discovery issues, or this is as trial ready as it's going to get?
So we do have a little bit of an issue. I talked to Miss Charles about it a while ago. And I called her a couple of times. I wasn't able to get her to rediscuss it, but I have no way of identifying which officer's body cameras belong to who. Ms. Charles explained to me that the body camera videos would identify the officers. In our case, it or at least from the videos we have, she said she saw it. Maybe it's me overlooking it, but I've looked at it multiple times and I just can't seem to find where these officers' names are. So I think that's very minor. Secondly, just any statement that she gets from, I have somebody go out to meet with them, or will attempt to have somebody go out to meet with him if he's willing to speak with us. But I would just ask any statements that he gives to her.
Sure. If there's anything that's memorialized, you'll be entitled to that. And then, Ms. Charles, when you get a chance, if you could help Mr. Cruz sort out, it may be as simple as, look, there's a badge number in the corner. I don't know.
Your Honor, I may just refresh Mr. Cruz with recollection. On April 18th, we discussed this issue at length. And on April 18th, I sent him the audit log, and the audit log that matches the body cam, that matches the officer's name, may list them and, as they track the body cam. And I thought that resolved that issue for him. So if he looks at the attachment that I sent on April 18th, that should assist him in clarifying who body cam belongs to what.
And I may have overlooked that.
Okay.
I'm sorry. I haven't seen the audit logs. I may have overlooked that. If it's okay, can you just resend it to me?
Absolutely, no problem.
All right, she'll resend it, but also April 18th, that was when the email came. She'll send it again, and that ought to be the end of it. If she sent it to you twice, then it's on you. And hopefully, that's assuming the audit log works. I have no idea what that term means, but hopefully it will help you, Mr. Cruz, associate video number 1 with Officer X, video number 2 with Officer Y, et cetera.
Yes, sir.
Mr. Carr, we will get your case on a trial calendar again, and this time it will stick. It will be on the trial calendar. The state will need to announce ready. If you all can sort it out, we can take a plea at any time. If you can't, then we'll try the case. Anything else, Ms. Charles?
No, Your Honor.
Mr. Cruz?
Nothing from the finish, Your Honor. Does the Honorable Court have any idea of around what time the trial will be set, as far as just, month-wise?
Sure. I think we're looking at October now, because I think our September calendar has been filled by the last set of status conferences. So October, maybe November, but I'd say one of those.
Okay. Thank you so much, Your Honor.
You bet. Take care.
All right. You too.
Mr. Cladis, don't go too far. The next case is yours. Kyler Burney.
And may we be excused, Your Honor?
Yes, you may. Thank you for hanging in there.
Yes, sir. Thank you.
I guess, yes.
All right. Mr. Burney, has Mr. Cladis updated you on his employment situation?
Yes, sir.
So Mr. Cladis will be replaced, unfortunately. I'll be with a great lawyer, so I'm not sad that will be it's the change that's a problem, because you're going to need to get to know a new lawyer, and that slows things down. What we had hoped to do today was talk about whether your case was ready to go to trial. And Mr. Cladis may actually be ready to go to trial, but he can't fairly represent you by the time your case would be on the trial calendar, which is in about a month and a half. He's actually gonna be sitting at the other table, so he can't do that. What we'll do is get you back in here. Once we know who that lawyer is, we'll have an afternoon where it's just that lawyer and his or her clients. And then we'll talk about how quickly that lawyer can get up to speed on your case.
Yes, sir.
All right. Mr. Cladis, were there discovery issues that you had noted in this case?
There may be a missing video. The state is looking into it. It would be a video of Mr. Burney's arrest.
Okay. Now there's a co-defendant, Creole Brazil, who's not on the calendar today. Did something happen to Mr. Brazil?
No, Judge, she had his status hearing earlier.
Yes, Ms. Wood's case.
Got it. Okay. So that case is trending along. Mr. Burney, all we can do is wait till there's a new lawyer in place. And as I said, we'll get you and that lawyer back in here and we'll talk again.
That sounds perfect, sir.
Well, I'm glad it sounds perfect. Now, you're on bond. Any issues with your bond conditions?
No, sir.
Okay, and have you moved?
No, sir.
Same address. Good. All right. Well, you noticed from that last gentleman who was in here, if you do move, make sure you get that address updated in the system because we'll keep firing off letters to that old address until you update it so we can send it to the new.
Yes, sir.
All right. Mr. Cladis, anything else?
No, Your Honor.
All right. Good seeing you, Mr. Burney.
Thank you, sir.
All right. Only one case left, and that's LaShondra Smith. Hey, Miss Smith. Hi, come on up and sit with Mr. Cladis, please. This is like the Cladis special calendar.
It's definitely special.
So, Ms. Smith, you've now heard me say to a number of people that Mr. Cladis is changing jobs, which means we gotta get you another attorney. Your case lists a co-defendant who's not indicted, Javorius Carter.
I believe the state null pros the charge against him.
Okay, so Ms. Smith stands alone. How is discovery looking?
It looks mostly complete to me. There may be another video issue in this case, some security camera video that's referred to in a police report that doesn't seem to have made its way into the state's file.
Okay, or at least didn't make its way to you, or Ms. Charles has told you she doesn't have it.
I don't believe either of us has it.
Okay, so then it's going to be a question of whether it exists anymore.
The officer in the report said he was going to pick it up, so will reach out to him to confirm whether it was ever picked up.
Okay, all right. So it's not a body cam, it would be he's getting it from the gas station or the whatever.
Was a
Okay,
gas station.
got it. Other than that, Mr. Cladis, and your soon-to-be unavailability, any reason we couldn't move this to a trial calendar?
Not that I'm aware of.
Okay.
But I would like to see, I mean, I guess I would like, if this video exists, I definitely want to see it.
Well, so would the state, we can't move it to trial because of your transition, but I think my conversation with your successor will be, other than getting to know Ms. Smith and getting to know the case file, we're gonna move it to a trial calendar. If the state can get the video, or you, anyone can try to see if it still exists. It may prove inculpatory, exculpatory, or it could just be blurry, and we don't know. But I don't want that to hold things up. We have a hold up, and so we'll work through that. Ms. Smith, you are on bond. Any issues with your bond conditions?
No, sir.
Okay. Are you working?
Yes, sir.
What do you do?
I'm a customer service representative.
For
Maximus.
what's that?
They are call center. They do handle calls with RS, Casa Permente, United Healthcare, different contracted works.
So if I'm calling United Healthcare, you might be the one who answers the phone?
That's correct.
All right. Are you nice on the phone?
Of course.
Good. All right. I think that's it. Ms. Charles, anything else for Ms. Smith?
No, Your Honor.
And you're still, yes, ma'am.
I did want to state something, Your Honor. Within, I'm not understanding why Mr. Carter was not charged because I had multiple damages to my vehicle.
We can talk about it.
Was Mr. Carter sort of on the other end of what was going on? Is this one of these cases where we had alleged victim and defendant in? Yes. All right. The DA's office has a knack for doing that, where there are two people having a dispute and then they like indict them together or something. But
No, Your Honor. The video kind of disproves Ms. Smith's account of the statement.
okay, and I don't want to go there right now, as Mr. Cladis was trying to tamp that down as well. You're asking a fair question. I'm not the one to answer it. Mr. Cladis can help you with it. It may be that the state has some thoughts about that, but what we're working through, you and me, whoever your lawyer is going to be on the prosecutor, is your case, not Mr. Carter's. There may be a great defense that your lawyer would use either to try to get you a better deal than maybe what you're hearing about, or to convince a jury like, wait, we got the wrong defendant. This should be State versus Carter. And that may well be what your lawyer argues. But I don't have the authority to tell the state, well, you got to go change this indictment. You indicted the wrong person. They may have, and then the jury will say, why did you waste our time? It's not about Ms. Smith, it's about Mr. Carter. Hopefully we don't even get that far. Maybe there's a way to work this case out. but we need to get you a lawyer who can be there with you through the way this sorts out. And if it needs to be a trial, it'll be a trial. For now, you're on bond and it sounds like everything is going smoothly. You just like to get this out of the way. Is Mr. Carter someone who is still present in your life?
I have a current, I just made a report on the 4th of July for a break-in.
Okay, so he's someone who is still unhappily in your life.
Somewhat.
Okay, all right, got it. Well, I would do your best to stay away from him. It sounds like the issue is he's not staying away from you. All right, we'll talk to Mr. Cladis about that. I will get you back here when we've got the new lawyer, you and Mr. Burney, not your case, but a number of people are going to need to meet that lawyer and then tell me when can we get this case to a trial calendar. You're still at the same address?
Yes, sir.
Okay. If that changes, just make sure you notify your lawyer. And if you're not clear who that is, reach out to my staff so we can get the address change in the system. All right?
Yes, sir.
All right. Ms. Charles, anything else?
No, Your Honor.
Thank you.
Thank you, Your Honor.
All right. I believe that's it. Ms. Nelson, any hidden calendars?
No, Judge, that's it.
That's it. All right. Well, thank you, Ms. Jackson. Thank you, Ms. Rivers. And Ms. Williams, you never revealed yourself, but thanks for being on the call just in case we needed a victim advocate.
Thank you, Judge. Have a great one.
You too. See you all around.